Good morning, everyone. We'll go ahead and get started. Welcome to the public hearing. Today is March 24th, 2025. This is going to be the last public hearing for the Public Health Committee for the 2025 session. We will still be listening to people, but this is a public hearing. With that, I'm going to ask my co-chair for some remarks.
Thank you very much, Senator Anwar. Happy Monday, everyone. We're so glad to see you here. We look forward to hearing the testimony today. As we often say, our fellow legislators are in and out of the building. The building is very full. There are a lot of committee meetings and hearings happening today. Some folks will be joining us online, so rest assured that even if our committee members are not here with us in person, that they will be reviewing testimony and very much listening to what you have to say. Thank you, Senator.
Thank you. And as our ranking members join us, we will have them be able to speak and weigh in. With that, we will go ahead and get started. The first person on our list is Senator Looney. I do not see him yet, but as soon as he's available, we'll take him for the conversation. And the person next on our list is Commissioner Gifford. Commissioner Gifford, you're on. Welcome.
We can move them. Yes, please. And feel free to move those items. I don't know why they're there.
What are they? Welcome, Commissioner.
Thank you, Senator. Good morning, Senator Anwar, Representative McCarthy-Vahey, Senator Marks, Senator McCrory, and distinguished members of the Public Health Committee. Very happy to be here this morning to comment on 3 bills that you have before you. I'm Deidre Gifford, the Commissioner of the Office of Health Strategy, and we look forward to the conversation. To begin with, I'd like to make some comments on Senate Bill 7050. This is the agency's bill regarding strategies and recommendations on the Certificate of Need program. First of all, I'd like to just say that we very much appreciate the engagement that we've had with this members of this committee over the past year and a half on the topic of Certificate of Need. I think we've jointly made a lot of progress on the transparency and accountability and efficiency of the program. We appreciate the proposals that the committee has put forward, and we look forward to further conversations as the session progresses. And our bill would do a few things. First of all, it would allow OHS to establish policies and procedures as a prelude to regulation for the Certificate of Need statute. That ability resides in some parts of the statute, but not all of it. And so for making sure that applicants and others impacted by the program have clarity in what our policies are, we think it would be important to add this throughout the statute. Another very important but somewhat technical change that we propose has to do with the definition of termination of services. As we know, there have been a few applications recently that have received a lot of attention with regard to termination of services. It's one of the requirements of CON. We found that even though we have added an additional definition to termination of services, there's remained some confusion. So our proposal would clarify the definition of a termination would be 180 days of closure of the service in a 2-year period or any 30-day consecutive closure. Right now, we're seeing some facilities cycling services on and off. And if there are not 180 consecutive days of closure, there's some confusion about whether that constitutes a termination of service. So we propose to clarify that. We propose adding proton beam therapy to the list of technologies that would require CON in the future. As you know, the agency has recently approved 2 proton beam therapy facilities in the state. Those were approved, those required CON because that technology was not currently in use in the state. When the first facility opens, which we anticipate will be this year, a CON will no longer be required for proton beam therapy because it is not explicitly called out in the statute. Proton beam therapy has a lot of potential benefits for patients, but it's also quite expensive, sort of a newer technology in the treatment of some forms of cancer. So we believe it fits squarely into the type of service that should require a certificate of need.
Excuse me, Commissioner, but you've reached your 3 minutes. Thank you.
Thank you.
But Commissioner, do please finish your testimony. We have questions, and one of my question was if you would finish your testimony, we have more questions.
I'd be happy to. I'll be brief. We propose adding cost and market impact review, making it clear that the agency can actually consider the findings in a cost and market impact review when one is required for the transfer of ownership of a hospital. Currently, there is ambiguity in the statute as to whether the agency can actually review and use the results of its own report in reviewing that application. So we propose to clarify that. And finally, we propose adding an expedited CON review process. This is something that we've talked about extensively with members of this committee, that the current CON process has many fixed timelines with no opportunity for waiver, absent the most recently enacted waiver for in the narrow case of a bankruptcy of a hospital. This proposal would allow a expedited 30-day review of a certificate of need in two circumstances. One, if there was a significant unmet need as identified by the agency in its facilities and services plan, or the applicant identifies a significant unmet need in their application. So we think that this is a way that we can further make the program more efficient and transparent for applicants and for the state, and would affect a relatively probably small number of applications. So that concludes my remarks on 7050. With regard to Senate Bill 7, OHS really appreciates the intent of many sections of this bill. Section 3 we support, which would build on our collective work together in limiting particularly off-campus hospital facility fees. This would add a certain type of infusion service to the types of services where a facility fee would not be allowed. And OHS believes that this builds on our collective work in this area over the years. Section 14 would require OHS and the healthcare cabinet to do a study on stop-loss insurance. We do not support this section of the bill in its current form because OHS does really not have the expertise or experience to regulate, to opine on insurance regulation. We understand the intent behind this section of the bill, and we'd be happy to work with the committee to talk about what might be a more appropriate venue for the study that the legislature wishes to undertake. Section 15 of the bill, OHS supports. This is the section that would eliminate the presumption in favor of approval for the transfer of ownership of a large group practice. We want to note, however, that it is unusual because of the way the statute is worded. It is unusual currently for any transfer of ownership of a large group practice to require CON. So while we support eliminating the presumption of approval, the fact of the matter is that most of these transactions are not coming before the agency now because of the loophole of one transfer from physician ownership to physician ownership. So happy to work with you on potential changes to that section and how our current statute is limited. With respect to SB 1539, the committee's CON bill, we note that Section 1 would expand OHS's review of transactions involving private equity. We know this is an issue of great importance to the committee and to the public, and we share your desire for further transparency into those transactions. As you know, the governor proposed HB 6873, which would enable the Office of the Attorney General and the Office of Health Strategy to review transactions involving private equity, which currently do not receive review. This would allow the AG to consider the effects of the transaction on access, quality, and affordability of care, and to work with OHS in reviewing those transactions, and would allow the OAG and OHS to impose conditions on those transactions if they were warranted. Section 2 would require OHS to deny any certificate of need application to terminate labor and delivery services unless those services could be obtained at another hospital within 25 miles. While we certainly appreciate the salience of this issue and the concerns behind this legislation, we did take a hard look at distances between labor and delivery units as part of the development of our recently published Facilities and Services Plan. We held a public comment session specifically on this topic. We asked our vendor to review the literature, and we were unable to find a data behind a specific mile limit that could get general agreement. So while we share the goal of having clear evidence-based guidance for the distribution of labor and delivery services, we look forward to working with the committee to review this proposal and ensure that any thresholds established in statute are rooted in data and evidence. Sections 3 and 4 of the bill would require OHS to publish notice on its website of an appeal, an agreed settlement, and when the agency enters into negotiations for an agreed settlement. We support these provisions, in fact, have enacted them based on very helpful conversations with members of this committee and others. We currently don't post notice of an appeal, but we'd be happy to do that, have no objection. Finally, Section 3 of the bill includes a provision that would prohibit granting any request for intervenor status in a public hearing for a CON application filed by a group practice of 5 physicians or less. We understand the concerns raised by the committee that a petition for intervenor status could be potentially abused for anti-competitive purposes. But we do have concerns about this section in privileging one type of applicant over others in the process. And we want to be sure that rights of all parties are upheld. So we look forward to working with the committee to ensure that no applicant faces inappropriate or undue burdens in the CON process. Lastly, Section 3 would also establish an expedited review process for an increase in hospital beds. We note that, as I mentioned, our Bill 7050 would also authorize an expedited review process for a broader category where unmet need could be demonstrated. We note that as of December, our projections through 2030 show that there's currently an excess of hospital beds in the state of 1,626 licensed beds. And we also note the ongoing shift from inpatient to outpatient services in the hospital setting. So we share a lot of common interests in this proposal and look forward to further conversations. That concludes my testimony, and of course, happy to entertain your questions.
Thank you so much, Commissioner Gifford, for your testimony. I know many of us have a lot of questions, so I'll start with a couple and then we will rotate around and then I'll continue with my other questions. This is a little bit about the changes that have happened already. So would you be able to speak a little bit about how Office of Health Strategies has tried to become more efficient in the last 1.5 or 2 years since you've been in the leadership role?
I'd be happy to, Senator, and thank you for the opportunity. As you know, because we've discussed it many times, there was a period of time when OHS was experiencing prolonged periods of time to review and approve CON applications. When I arrived, we undertook a number of processes to address that, with the end result being that the median time from filing an application to final action, whether that's agreed settlement, approval, or denial, the time for that process to be completed has dropped by 60%. I think our mean number of days now is 139, somewhere in that range. We can get you the exact number. So that was undertaken by replacing many of the staff that had been lost over the course of the pandemic. We now have a full complement of attorneys and analysts in the CON program. We've been reviewing our training protocols. We've undertaken a review of our application process. We'll be publishing for public comment a revised set of forms to make the application process more clear. In general, we've looked at the process from A to Z to see where efficiencies could be obtained. In the past, often there was more than one letter sent out asking for additional information. We've tried in almost every case to limit that to a single letter and have really reduced the number of second or even third letters that the agency has been sending out. So we've focused on efficiency, transparency, as we said, Senator, and the results have been a much shorter process. And frankly, we've been hearing from applicants how much they appreciate the changes that the agency has put in place.
Thank you so much. And the second question is, again, more for clarification opportunity. When there's an application in process, now my understanding is the plans for Office of Health Strategies is that if an application has been submitted, but it's incomplete, the website will speak about that.
So tell me if I answer your question, Senator, with the following. We have instituted a new process where every active docket is now listed on a web page separately from our large and somewhat cumbersome CON portal, which is sort of the official database for the program. We've started a separate page which lists the active dockets and what the next step is for each. So to your point, if we are waiting for an applicant to return information, it will indicate that. If the applicant is waiting on us to set a hearing date or send out a completeness notice, it will indicate that. If the application is undergoing agreed settlement negotiations, that will be indicated on the webpage. So rather than asking everyone to search the entire portal database, we've got a separate page where if you have an active application or the public wants to see the status of an application, they can check that page.
The reason I asked this question is that OHS gets a lot of bad press with respect to the Prospect and Yale deal. And that's where the CON has been under review. A lot of the bills that we are seeing and what you are proposing are indirectly or directly linked with some of those experiences. So my understanding is that many a times when the applicant has an incomplete application, the general public is not aware of it, and it appears that the delays are based on the OHS processes rather than the fact that you don't even have a full application that's completed. So can you help us clarify that aspect? And going forward, would we be able to identify that the delay was, let's say, 2% based on the delay in application, 98% by OHS, or whatever the ratios could be?
Senator, one of the things that we have been working on since I got to the agency was an enhanced portal that would help us track a lot of the measures that you're describing. So we have received now approval for bond funding to buy that new tool that's already in use elsewhere in the state. And that will allow us to track in much finer detail each segment of the application process and make reports such as the one that you are describing. We also want to make sure that applicants don't have to guess what the agency is thinking when it comes to an application. We're clarifying what we actually need in order to have a complete application. You are correct, particularly in the agreed settlement process. There can be long gaps where the agency is waiting for an applicant to respond, and the public would not necessarily know that that was happening. That, in fact, has prolonged many of our negotiations. And we think this enhanced transparency as proposed in your bill and in our new website will really help clarify that it's not always the agency that's delaying the process.
Thank you, Commissioner. I'm just going to keep going. I got the permission from my co-chair. She has some questions too, but I'm going to ask a couple more and then we'll see. This is about a remark you just made that we have plenty of beds in the state. So if there's a patient in Farmington and the beds at UConn are filled, expect and there's a multi-hour or multiple day waiting in the emergency room. We have a bill on emergency room and we'll hear during the course of the day. I hope the OHS individuals would listen to part of the conversation around that. If people are waiting in the emergency room for multiple days because there are no beds available, and it's not as simple as having more beds. It's more that they are going to be beds which are going to have staff. But expecting that the total number of beds for somebody in Farmington to go to Norwalk or Stamford because we have quote unquote enough beds doesn't make sense. They have to be in the community that a person is at. And I think OHS should have to reevaluate their definition of having enough beds in the state to be very regional and focused within a short driving distance. How do you feel about that aspect and the bill that we have proposed?
Thank you, Senator. And while the number I cited does pertain to beds across the state, when we look at a particular application for increased inpatient beds, we actually do exactly as you proposed. The state's methodology, which is now published in our facilities and services plan, looks in the immediate primary service area for that hospital and how many other beds are available. So you're correct that we don't say, if there are beds in Fairfield, that applies up in Hartford. Secondly, we have been working, have had several meetings with Dr. Moore and the ED boarding group. We appreciate that work and have been following it closely. As I think the report identifies, ED boarding is a multifactorial problem. And as you point out, Senator, it's not strictly related to a lack of inpatient beds. And a lot of it has to do with the ability to find appropriate setting for an individual to be discharged from the hospital, is my understanding. That was a major recommendation. Something OHS is very interested in working with the provider community on. Our data indicates that up to 30% of visits to a hospital are for non-emergent issues. Now that wouldn't necessarily impact the boarding, but it would certainly impact the ED overcrowding and the ability of ED staff to care for individuals who are there. So we, with our programs like AHEAD and emphasizing primary care through our benchmark program, OHS is very interested in making sure that the ED is only being accessed by people who need an actual emergency room for treatment.
Thank you. And that brings me perfectly to the next question I wanted to ask. I have been in conversation with Dr. Moore and some of the other emergency room doctors. The bill that we have for emergency department waiting time on the public hearing today is a very basic bill, does not say a whole lot. And the reason is that we want to have a quality criteria be created and recognized and followed, but we want Office of Health Strategies to be the entity to do this, because you're looking at this cerebral part of the healthcare in the state and looking at the patterns of what's going on and what are the patterns, and we are in a very dangerous situation from patients' perspective, but also clinicians' perspective and the burnout that we are seeing. And we cannot do this without a state entity owning part of this. And because it's sort of a symptom of a larger issue that's happening in the internal workings of the hospitals and the insurance industry, we would love for Office of Health Strategies to be the lead in this effort.
Senator, I do not have formal prepared testimony on that bill. Certainly, we understand and appreciate the issues that you're talking about. We have, as part of our statutory mandate, data collection on ED visits already. And we have quality data collection under our healthcare benchmarking statute. So there certainly may be opportunities for OHS to work on this issue, and we'd be happy to speak further with you and other members of the committee about the feasibility and potential resource needs for doing that data collection.
I have Representative Kristen McCarthy-Vahey.
Thank you very much. And thank you, Senator. I'm interested in more conversation on a number of these items along the lines of what Senator Anwar has asked about, but I'll have a few questions just going back to the bill that your office has proposed in terms of the terms of service piece. I wanted to see if you could speak about this a little bit more specifically in terms of why it is this way, because we've talked about this as a committee leadership with you, kind of what's happening. And you talked about the cycling on and off, and why is that a problem? And why do we need to make this change?
Thank you, Representative. So the issue of when a certificate of need application is required for a termination of service is obviously dependent on the definition of when a service has been terminated. What we have observed, particularly this began during the pandemic, when some facilities had closed or terminated under an executive order certain services. When they began to restart them, there were issues with staffing, there were issues with demand in some cases. And so certain facilities would open a service for a period of weeks or months and then close it for some other period, depending on whether, you know, they had staffing issues or demand issues. Then restart the service, then terminate it again. And under our current definition, if that stoppage was not 180 consecutive days, some providers think that they have not met the definition of termination. Well, you can imagine, for example, let's take a hypothetical of a labor and delivery unit that is closed and then open, closed and then open. Be difficult for a family, a patient, a provider to know with confidence that that service would be available when they needed it at the time of a childbirth. Same with progressive care unit or ICU services, that in order for the community to understand whether a service will be available when it's needed, there needs to be some consistency in whether the hospital is actually offering that service. When there's cycling on and off closures, we think there's a risk that that perpetuates the decline in demand and potentially perpetuates the staffing challenges that some of these facilities face. So for all of these reasons, transparency, efficiency for the community, we think it's really important to tighten up this definition in the statute.
Thank you for that. So put another way, it would be if an organization was wanting to close this current strategy, if that is in fact a strategy, and I know I'm assuming intent, and I'm just for illustrative purposes, that they could do that in order to get around the CON process potentially at this point. I'm not suggesting that that's what you're saying, but the decrease in demand just perpetuates that cycle, as you said. So this is a way to assure we're really catching everything.
Yes.
Okay. Just also to the CMIR, the cost of market impact review, just to clarify that at this point in time, when you create that report, your written testimony reads, the current statute is ambiguous as to whether OHS is actually permitted to review or use the findings in the CMI report. On a practical level, can you give us some examples of what's happened in the office and in that communication, and why, you know, do we really need this? If there is ambiguity, oftentimes we've had bills here before where it seems, well, this is possible, but just if you could talk about the practical implications for your office.
Yes. So when a hospital is being transferred to a larger hospital system, not in every single case, but in many cases, when a hospital is being transferred to a larger hospital system, that the agency is required to have this report produced, cost and market impact review. There have been 2 since I've been at the agency. They are extremely useful reports. They talk about the market share, the cost, the quality, the impact on providers and on communities of this hospital transfer. Right now, the statute suggests that we have to have 2 separate teams. In a pretty small agency, we have to have 2 separate teams, one team reviewing the application for the transfer of ownership and one team working on the cost and market impact review. When the CMIR is done, that team reviews it, and per the statute, if it suggests that there are antitrust implications in the cost and market impact review, it is transmitted to the Office of the Attorney General. She or he can act or not act, depending on the findings and where they are in their own review of the transaction. This team over here reviewing the actually CON does not have the opportunity to see what this other team in this agency has created. And importantly, can't use what's in the CMIR as evidence during the application review process. So this very rich, significant report is produced within our own agency, and we are not able to review it when looking at the transaction. So it's a disservice, in my view. It's a disservice to the public. The applicant pays for this report, produces extremely useful information, and yet we are not reviewing it in the application process.
Thank you for that. In 6873, we talk about the Attorney General's process, the antitrust review process that happens. Can you explain how the CMIR fits in a little bit more? You alluded to it, but just walking through, applicant comes in and they have to go to the AG's office and to the Office of Health Strategy. Can you talk about the parallel process as it may be, or, are things concurrent? Are things sequential? And just speak to that.
Happy to. With your permission, I'd like to invite Boyd Jackson to join me. Boyd is our Director of Legislation and Regulation, in case I misstep. So the 2 processes, the Attorney General's antitrust review and OHS's cost and market impact review, are completely independent. And in fact, it's possible and has happened that the Attorney General's office can complete and act on their antitrust review before we've had an opportunity to complete and transmit our cost and market impact review. So they neither the AG's office nor OHS benefit from the rich material that's in that report. There's no, other than the direction to us to assess whether there are antitrust implications and transmit the report, there are no other obligations that I'm aware of that the OAG and OHS processes be synchronized or otherwise mutually reinforcing. Okay, Boyd's nodding his head, so I guess I got that right.
So I want to make sure I understand properly that the bill before us wouldn't necessarily impact what you said about that sometimes the CMIR is not complete before the AG's office completes.
That's correct.
The bill does not address that
That's
aspect.
correct, Representative. Yes.
So the bill really addresses the internal aspect within the Office of Health Strategy to allow that those 2 teams are both able to review the material.
Correct.
Okay. Is there a conversation, an effort or desire to make sure that that CMIR is getting to the AG's office or a need for that information that would be helpful to make sure that that gets to them in time for their review?
In working on Boyd Jackson, Director of Legislation and Regulation, Office of Health Strategy, in working on the governor's bill, we talked about the interaction between the cost of market impact review and the notice of material change process, and we are actively seeking to harmonize all of these processes that are going on at the same time. I know the Attorney General's office has told us that, you know, kind of anything we can do to expedite that process and get it started as early on as possible helps them. There is a waiting period after the cost of market impact review. So if we refer it to the Attorney General's office, the parties are not allowed to close for 30 days until after that transmittal. So there's time there, but if they've already reached an agreement, it may not, that is, if the Attorney General's office has already reached an agreement with the parties, it may not be able to reopen it. I think that this is where better collaboration during the notice of material change process might help all parties involved, so that we would be able, the Office of Health Strategy would be able to share information it's getting through the CON process and through the cost of market impact review while the Attorney General's office is reviewing the notice of material change, and everyone would be on the same page, so to speak, and have access to the same information, rather than having kind of 3 processes, each with walls between the different teams.
Thank you for that. So it seems that there's opportunity for even more discussion. I like the word harmonizing, leveraging those reports and that information to make sure that we are best protecting the patients and providers of the state and access, cost, quality, the things we talk about all the time. I may have further questions, Mr. Chair, but with that, I will go back to you.
Thank you so much. One of the section that you have touched on is the one about 5 physicians or 5 physician or less. The issue is that the intervener is a part that at least some of the people feel gets abused a little. And Senator Summers has not been able to join. She's in another meeting, so I'm just going to ask on her behalf because we've had this conversation. One of her constituents has been a plastic surgeon who needed her own space to be able to do the procedure. And whenever this person would apply, they would have a big hospital network, say, or university networks would say, we are going to intervene. And the person said, well, after trying to fight that battle, she just left the state. And then I think that's where we feel that entrepreneurs or individuals who want to be independent, a small little group cannot fight a big institution. And so while you say that you cannot have a policy where you're siding with one side or the other, well, the current policy is already doing that. So the current policy is in favor of large entities rather than small mom and pop shops, if you will. So just a reason why that part had to be put into legislation. So I wanted to see if you can speak to that.
Thank you, Senator. And as I mentioned, we are certainly sensitive to the concern that the intervener process being misused. And so we'd be happy to talk about anything we might be able to do to address that. I believe that process is spelled out in Uniform Administrative Procedures Act. So that is, a statewide process that pertains not just to the Office of Health Strategy. We have not had any examples of the type of application that you are referring to in this section of the bill. So we are not aware of how large a problem this actually is. I do point to, for example, the group practice transfer loophole that exists, which is not exactly the same, but somewhat analogous. We have in our statute language that gives an exception to the transfer of ownership of a group practice from one physician to another. That loophole has been exploited to the extent now that the office is not reviewing those transfers because of that language in the statute. I think one of our concerns is that privileging another type of application might have also unintended consequences, in addition to depriving a legitimate intervener or one who doesn't have malicious intent from having their voice be heard in that particular transaction. So happy to talk more about how we might address the senator's specific concerns, and maybe there's a way we can do it that would meet everyone's needs.
Thank you, Commissioner. Senator Gordon.
Thank you, Mr. Chairman and Commissioner. Nice to see you today. One question I have follows up on testimony that you've given here today. Is it my understanding that you're saying that the length of time for CON applications to go through a review process and be decided one way or the other by your office is down to 130 something days? And if that's the case, is that a mean or an average number, or is that just based upon what the last application process was?
It's the median for the last year. And I see Boyd going to the website, so we can tell you the exact number of days. So it's the median number, and it's for, I believe it's for a 1-year period.
No, thank you. Just because median is much different than an average or the mean. So that does give me some indication that if that's the median, then half of the time it's longer than that, as you know, statistically. So that's important for me to know. Thank you. And the other gets into your testimony relative to HB 6873, which I know this committee has already dealt with, but it is in your testimony relative to 1539. You do mention, and I won't read it word for word, that you don't feel that all private equity applications, especially buying a hospital, should go through a CON process, that there is a separate process trying to be looked at through the other bill involving your office and the Attorney General's office. And I'm just trying to understand a little bit about the process, if you don't mind. In the current CON process, there are various criteria that have to be looked at to make decisions, is my understanding. Whether we can argue whether or not those statutes are really being followed, but separately, technically, there are those provisions. In the other bill, if it's going to be just your office and the Attorney General's office looking at things and not necessarily have private equity all the time go through CON, and I think we shouldn't even need a CON process for private equity, because I think we should ban them from being involved in any type of hospital situation at all. But be that as it may, are there specific statutory requirements that the Attorney General's office and your office would follow in making decisions or putting conditions on an approval if a private equity wants to be involved with the hospital, but it's determined that it does not need to go through a CON process? I'm just trying to understand how that would play out versus going through a CON process, because I've raised concerns about the lack of real specific criteria if we don't use a CON process.
Thank you, Senator. As you point out, under the notice of material change proposal, the review could end in multiple different ways. It could end with a review and no action. It could end with an approval with conditions, or it could end with an approval without conditions, or a referral for a full CON. I think the type of transaction that's contemplated in this section of the bill this morning, because it contemplates private equity taking an ownership share of a healthcare facility, would likely be the type of transaction that would receive a lot of scrutiny through the notice of material change process, and may in fact be referred for a full CON. To answer your specific question, Senator, the criteria for the notice of material change conditions are quality, access, and affordability. We don't have the 13 conditions spelled out in the same way as we do in the CON statute.
Thank you, Mr. Chairman. All the rest of my questions I'll follow up in writing. Thank you.
If I may just add on, the notice of material change bill does not alleviate or remove any already existing requirements for a CON. So it is not a substitution. It ensures that we catch additional transactions. So if a hospital transfer would already require CON, it would still go through CON. It would not escape CON by going through notice of material change.
Thank you. Although it sounds like there's some situations that CON may determine not to be required. Thank you, Mr. Chairman.
Thank you, Representative Kristen McCarthy-Bay.
Thank you very much for the second time, Mr. Chair. Just going back, Commissioner, to your comments about that group practice transfer exception, and you used the word loophole. And I'd like to kind of take that back to the role of private equity, to the good Senator, my colleague's comments. Can you speak a little bit about how that loophole works and how that may or may not tie into that private equity piece, as we've had conversations in other settings? And I'd like that to be here on the record with us publicly.
Just to be clear, Representative, you're speaking specifically about the transfer of a large group practice. Yes. So the statute, and I'll paraphrase, the statute right now says that a CON is required except when the group practice is being transferred to a physician owner. What has happened is that many of these transfers place a physician nominally as the entity to which the practice is being transferred in what may be a very large and complex corporate structure, but nominally the transfer is taking place to an entity that's led by a physician. And we've done a few determinations since my time at OHS, and found that, in fact, a CON would not be required because of that specific language. Many of these transactions never come before us, and we've been asked, why wasn't that reviewed? Why wasn't that reviewed? And it's specifically because the physician-to-physician transfer exception can be put in place legally and technically avoids the need for a CON review.
Thank you for that answer, Commissioner. So is it fair to say, as a result, we really don't have any real sense or data about the extent to which private equity is funding healthcare in our state, whether it be hospitals or in our group practices or other healthcare entities?
I think that's fair to say. In fact, we've worked with some researchers over the last year or so who've been doing a lot of work to try to uncover the extent of private equity investment in healthcare, not just in Connecticut, but around the country. They've developed what they call a heat map based on public records, based on websites, based on what they know about private equity companies and what they say publicly. There is no one single database where one can go look up how much private equity is involved in the healthcare system.
I know we have had and will continue to have around this circle a lot of conversation about private equity. Both Senator Elmore and I have been quoted in various ways within and without of context. And I've said many times, not all for-profit entities are created equal. Not all private equity is created equal. But to the good Senator's comments a few moments ago, we've been burned here in Connecticut. So we're all a little more hesitant, and we're certainly looking for more scrutiny. Mr. Chair, if I may, I'll just end with a comment. We spent many hours together, huddled in a conference room last year, trying to work on changes to the certificate of need process to help expedite. And I think, as we say here many times, the goal is to balance the need for transparency and awareness so that we can assure the protections for the people of our state, with the need to expedite processes, because we know that we're also needing to provide that access to care. And sometimes that expedited process is what's important. I expect that just like we did last year, we will be communicating regularly, frequently, and working together with our ranking members who, though they may not be here physically, are certainly involved in the conversation. And we look forward to working with you on this and on a number of other proposals that tie to the bills that are before us today. Thank you, Mr. Chair.
Thank you, Madam Chair. So with that, we have no more questions. I'm sure we will be having multiple conversations between now and the sessions.
Thank you very much. Appreciate the opportunity to have the discussion, and we look forward to the little room upstairs and drawing on the chalkboard. Thank
Yes.
you.
Thank you. That brings us to Honorable Beverly Strait. Welcome. Good afternoon.
Good afternoon, Senator Anwar, Representative McCarthy-Vahey, and members of the Public Health Committee. I'm Beverly Strait, the Probate Court Administrator. Thank you for the opportunity to offer concerns and testimony on Senate Bill 1538, an act concerning emergency department boarding and crowding. I have submitted written testimony with more details on the current conservatorship and guardianship processes in the probate courts and my concerns with the bill presently before the committee. I don't support the bill in its current form, but let me state at the outset that the probate court system shares the committee's concerns with any patient who is maintained in an emergency room or hospital for longer than is medically in their interest. I have reviewed the December 2024 ED work group report and the Connecticut Hospital Association's response. I note that it lacks any analysis of the conservatorship or guardianship proceedings in the probate courts. I note as well that over many years, the probate court system has worked and collaborated with the state's hospitals and CHA to address challenges in this domain, and we are committed to continue to work with all stakeholders in this regard. I have three main points I'd like to highlight this afternoon. One is the lack of specific numbers or data on how many patients are boarded due to legal proceedings, and specifically what about that process is allegedly causing the delay. Without clear evidence-based guidance on what is causing boarding as a result of anything involving the probate court, a feasibility study would be unable to address solutions. Second is that Connecticut already has a very robust process to address exigent circumstances, to expedite the appointment of a temporary conservator when the patient may suffer irreparable harm by any delay. Again, my testimony goes into more detail about what those processes are. Third is that there are critical protected constitutional rights that are already embedded in Connecticut conservator laws that should not be weakened. As the ED report itself acknowledges, there's little or no actual data to support the initiative for which this bill seeks to establish. The lack of data to identify the source of any problem in conservatorship proceedings in essence means that any feasibility study to establish an expedited process for the appointment of a conservator may not, in fact, actually result in an improvement with boarding and crowding. As I noted in detail in my written testimony, of significant importance as well is that already exists in Connecticut expedited proceedings for the appointment of a conservator in emergency situations where the patient may suffer irreparable harm if there are delays in the legal proceedings. A temporary conservator may be appointed in certain situations even without a hearing, called an ex parte appointment, with an expedited follow-up hearing that would allow for a temporary conservator to make critical decisions without delay. There are multiple different fact patterns that could impact various legal proceedings that might be involved in what the emergency department and hospitals are encountering.
Excuse me, Judge Strait, but you've reached your 3 minutes. Thank you.
Thank you. Happy to answer any questions.
Well, thank you so much for being here, and thank you for highlighting the issues that would that could have possibly been part of, or that may still be part of the bill going forward. But your role or your organization's role is a small part of a very big picture of, but it's helpful when you clarify it from your perspective. So we appreciate your testimony.
Thank you.
Seeing no questions or comments, we'll move to the next. Sorry, Representative Kristen McCarthy.
Just thank you, Mr. Chair. Just to follow up to what you are saying, Mr. Chair, I think this issue in terms of our ED crowding is and has been an ongoing conversation. So just know that we intend to remain in conversation about it. Thank you, Mr. Chair.
I appreciate that opportunity.
Thank you. And with that, we move to the next person on the list, which is Attorney Alma Nunley and Emily Gate from the Office of Attorney General. Welcome. Thank you for being here. You're on. The other one, the one that did there. Perfect. Press again.
Good afternoon, Senator Anwar, Representative McCarthy-Vahey, and members of the Public Health Committee. I'm Alma Nunley, Co-Special Counsel for Reproductive Rights for the Office of the Attorney General. With me today is Emily Gate, my Co-Special Counsel. I appreciate the opportunity to testify regarding Senate Bill 7, specifically sections 4 to 13. These sections provide Connecticut patients and providers with important protections. Sections 5 through 10 prohibit hospitals from denying stabilizing medical care to a patient suffering a medical emergency. For decades, the federal government had consistently enforced the Emergency Medical Treatment and Labor Act, or EMTALA, to protect patients across the nation. However, recent litigation between the federal government and some states has called into question the scope of EMTALA's protections, raising the possibility that the emergency medical care that a person receives is dependent on the state where they have an emergency. In a case brought against Idaho, the prior administration sought to ensure that EMTALA provided the same protections to all patients in all states. The new administration has recently withdrawn that case, indicating an unwillingness to enforce EMTALA to the same extent as in the past, and furthering confusion as to patients' rights and providers' duties. Rather than wait and see what happens next, now is the time for Connecticut to enact legislation to provide clarity and ensure its residents continue to have protections when they're at their most vulnerable, suffering from a medical emergency that seriously threatens their life or health. Senate Bill 7 also provides greater protections than EMTALA. Section 12 expands on Connecticut's existing anti-discrimination laws and clarifies that a hospital may not base the provision of emergency medical care on certain protected characteristics. For example, a hospital could not refuse to screen and stabilize a patient with acute chest pain because of their immigration status. We respectfully request one addition to the list of protected characteristics in Section 12, gender identity and expression, which is consistent with our other anti-discrimination laws in the state. Inclusion is essential at this time when transgender people are under unprecedented attack from the federal government, who seeks to deny transgender people's existence and prevent them from accessing health care. Section 4 provides protects medical providers from punishment for providing their patients with full and accurate information about reproductive and gender-affirming health care, which is essential for patients to be able to make informed decisions about their own care. It further protects medical providers from punishment for providing emergency medical care. In other words, it protects doctors who are complying with the other requirements of this bill. Section 4 does not interfere with a healthcare entity's ability to otherwise decide the services that it provides outside of the context of a medical emergency. Finally, sections 11 and 13 provide enforcement mechanisms for the protections found in the other sections. In sum, sections 4 to 13 ensure that in Connecticut, patients can continue to seek emergency medical care regardless of their ability to pay, expands patient protections to encompass other protected characteristics, and protects medical providers from discipline for doing nothing more than fulfilling their ethical and legal obligations. Thank you for the opportunity to testify before you today, and I look forward to any questions you may have.
Thank you so much for your testimony, and thank you for the work both of you and others in the Attorney General's team have been doing around this issue. I wanted to clarify something. So let's say there's a Catholic hospital and somebody comes in with an emergency issue that they're aborting. if that's the case, what would this bill expect that institution to do?
Well, currently under federal EMTALA and this bill, the hospital would have to provide whatever stable care is necessary to stabilize the medical emergency. If that would require an abortion would be required, but only if it is necessary to stabilize the patient and they couldn't safely be transferred elsewhere.
So, and the part of this bill is primarily about literally emergency situation.
Yes.
And currently, if the federal law was enforced, are we making these hospitals do something that they were not doing before? They should not be doing before based on the federal laws?
No, we would not be requiring a hospital to provide any additional care that that the federal law already requires. We're simply ensuring that in Connecticut, we can continue to enforce it in the way that it's traditionally been interpreted.
So I'm going to ask this again because I think there's some misinformation that has been circulated around this topic, where there is an organized group of individuals who have suggested that this bill is requiring Catholic institutions not to hold the values that they hold from their perspective. But the bill is not changing that. It's just making sure that the state law mirrors the 1986 and beyond EMTALA law for the federal government, which as of right now remains enforceable.
That is correct in the emergency provision of medicine, yes.
So we are basically saying that the state law is just being in sync with the federal law.
Yes.
So, okay, so if there is a federal law in place, why do we need a state law? Can you explain that as well? And then come closer to the mic so that I want to make sure everybody gets to hear this.
Of course, I can lean a little bit more forward. Certainly. So there's several reasons here. The first is that since Dobbs, there's been tension between state and federal law regarding what EMTALA requires. And there needs to be clarity that in Connecticut, it still requires what it traditionally required. And that confusion also is manifest by like the chaotic time in which we live, where it's unclear whether the resources will be allocated at the federal level for enforcement in the way that it traditionally has. And this allows Connecticut to make sure that it can enforce this law and make sure that its patients are safe, its residents are safe, regardless of whether the federal government continues to interpret it in the way that it has in the past.
So there is some evidence in other states that the federal government is not willing to enforce the EMTALA law as they were at least maybe a year ago?
Yes, so the prior administration had brought a case against the state of Idaho for circumstances where the Idaho law did only permitted an abortion if the life of the mother was in danger, not serious jeopardy to health, which is what's required under EMTALA. So they brought a case to enforce EMTALA against Idaho. And just within the last several weeks, the current administration has withdrawn that case.
And that's a concern and anxiety that why is the federal government not fighting on behalf of the citizens?
Yes, although they have not expressly said it, it's a clear indication that they're changing their position on what EMTALA requires.
Thank you for that. That's very helpful. Now, if a hospital is listening to this, not necessarily based on what the religious identity of the institution is, the hospital may say, why do I have to do more paperwork now? Is this going to require them to do more paperwork, or is it just expecting them to take care of emergency situations?
It's expecting them to take care of emergency situations. There may be some additional reporting and paperwork required so that the state has the information it needs to enforce the law, but that can be accommodated. If there's specific concerns about any of those provisions, then we'd certainly welcome them to hear those, but we have not heard specific concerns addressing any particular reporting requirement or other paperwork.
So if I was to make a statement to say that when somebody goes to the hospital, by the federal law, they're supposed to provide them care to begin with, and they're supposed to have some documentation about that. Would it be fair to say that just send a copy of that documentation to the state as well?
I would have to see, I can't speak to specifically what that documentation has, but the state law is intended to encompass the same information that the federal documentation encompasses. So I would not see why it could not be designed so that would be sufficient.
And you probably heard a little bit of the conversation, which we'll have a little bit more in-depth discussion on during the course of the day. The emergency room are flooded. On a good day, you can't get the timely care that one would expect or historically may have expected, because there's a lot of reasons for that. Is this going to create a flood of more emergency room visits for healthcare systems?
No, here we're only speaking to a genuine medical emergency where someone's life, their bodily organs, there's a serious threat to their health. This wouldn't encompass someone who's coming into the emergency room for what's ultimately routine medical care that may be sought elsewhere or lower risk to themselves.
So in my other life, I'm a physician. Sometimes you hear from a patient, it's an emergency from the patient's perspective, and we respect that. But we are defining the emergency based on how you defined it just now, rather than I've got a sore throat, it's an emergency.
Yes, it's still the hospital's responsibility to triage patients and prioritize the true emergencies and then get to the other care as appropriate deemed by the doctors there.
That's very helpful. Thank you for your testimony, Madam Co-Chair.
Thank you, Mr. Chair. And thank you for being here and for the extensive work that you have done on this beginning many months ago, actually. So just to go back a moment to the phrase that you used was the resources at the federal level are not as available to enforce the EMTALA laws. And I'm assuming that you're, based on the previous conversation with Senator Anwar, that is a Department of Justice resource that you're talking about, or are there other enforcement resources that you might have been referring to?
I'm referring more broadly across the government. So it would include CMS and Health and Human Services as well, where there's obviously everyone's seen the news. There's been issues with changes in staffing, changing in priorities, not just limited to the Department of Justice.
Okay, thank you for clarifying and expanding on that. I know this may seem elementary, but my colleagues here know that I like to talk about things at the fourth grade level so that all of us can be on the same page. But when you talk about the Dobbs decision and why you believe that that decision makes this specific change to our state law necessary, can you be pretty explicit about why you think that is?
Certainly. Well, the Dobbs decision, the Supreme Court held that there was not a constitutional right for a woman to choose whether or not to have an abortion, and it returned that issue to the states. Since then, we really live in a patchwork of laws across the states, where some states there's very severe bans, some states there's restrictions, some states like Connecticut, it's women are protected in their ability to choose, but that's created issues with how our federal laws interact with those state laws now. And so it's important for Connecticut, as a state that protects women, as a state that protects providers who provide this type of care, to ensure that in Connecticut, it's clear that we know what the law means and that means that women are protected in these circumstances.
Thank you for that. I know in testimony you reference at least one state, but do you know how many other states have state level EMTALA provisions in place as we move into this new landscape?
There's a variety of states that have some level of provisions. California is the big one. They actually enacted a state level EMTALA prior to the federal EMTALA in response to the same concerns. Washington has protections, as does Vermont and New York, and there's a number of others. It's a little hard to track because they're not necessarily a comprehensive single scheme, but they all have laws that provide circumstances for emergency medical care and when that care must be provided.
Thank you for that. And in your conversation with my good co-chair, you talked about the fact that this really mirrors in many ways the federal EMTALA, but there are certain provisions that go beyond. And can you speak to, again, repeat what those provisions are, why those are necessary, and how they are in line with what we already have in statute in many ways in Connecticut?
Certainly, Section 12 goes further than EMTALA by providing certain additional anti-discrimination provisions for protected characteristics, which include sex, age, race, many of the same characteristics that are found in our human rights and opportunities laws. And this would parallel and ensure that it's very clear that in the hospital setting, in the emergency room setting, those same protections for those same protected classes of people that they enjoy in public accommodation in other places, it makes it explicit that they apply to the hospital setting as well. Section 4 also goes beyond the provisions of the federal EMTALA to protect providers who are providing medically accurate information to their patients regarding reproductive and gender affirming healthcare from disciplinary action. And it also protects doctors who are providing emergency care in an emergency setting to stabilize a patient from similar disciplinary action.
Thank you for that. So just to reiterate, what you're saying is that these protections parallel our existing CHRO laws, and this makes it explicit for hospital settings, is what you're saying.
Yes.
And then furthermore, the provider protection piece. We've heard from folks in the past, and I believe we will, we've received some written testimony and input that in some ways that we are asking people to do something that would go against their religious freedoms or beliefs. How would you respond to that?
I'd respond in two ways. First, I'd encourage the committee to look at the testimony that has been provided by doctors. In particular, I'd point to the testimony of Dr. Cara Delaney, who can speak from personal experience in a way that I cannot, as I'm not a medical provider, as to what, as a doctor, she is required to do and what certain restrictions on the ability to counsel and provide information can cause. But I will say that what we're seeking to protect is doctors' ability to allow their patients to have informed consent and to make informed decisions about their health care and to provide information that's necessary. If a patient doesn't have the full scope of information, then it limits the informed nature of their consent. And this is what we're really speaking about here.
This is about informed consent, something we've talked about often here and have certainly spoken about in other bills this year. So that's what you're seeking to do, is to protect and secure that full scale ability for informed consent for the patient, but also to protect a doctor or provider who is giving that patient that opportunity.
Yes.
Wonderful. Thank you, Mr. Chair.
Representative Jagga, followed by Senator Gordon.
Thank you, Mr. Chairman. Thank you for your testimony. I think I get the point of what you were saying, but in your testimony, you referenced the situation in California. That same situation, if it were today in a Catholic hospital in Connecticut, what would their obligation be?
Their obligation would be to provide the care to the patient if that care was necessary to stabilize the patient. And the condition in California, there was active hemorrhaging, there was risk of severe harm to the patient, sepsis, and potentially even death. And the requirement would be for them to provide the stabilizing care and not simply send the patient to another hospital. And I want to be clear, we're not saying that a hospital in Connecticut has done this. We point to the California example as illustrative of why these laws are necessary.
Thank you. I wanted to be clear on that. Thank you.
Thank you, Senator Gordon.
Thank you, Mr. Chairman. Thank you for being here. This is certainly an issue I know quite well. I remember when EMTALA came out, and one of the hats I wear is I'm a doctor. So it's not uncommon. I'm called to see people in the emergency room, even though I'm not an emergency room physician. And I note that there's a bill that my colleague, Senator Summers, and I submitted about trying to codify federal EMTALA into Connecticut law. And part of what sparked my interest was the Idaho versus United States case, which is quite interesting. What the Supreme Court did, mostly on procedural grounds, not on the merits of the case, as you know. So we'll see what the lower courts do more and more, with this issue. But to me, it's more if there's a good faith on the part of a patient, regardless of who that person might be, seeking emergency medical care, and it's determined that that person has an emergency medical condition, then certainly separate from legal requirements, the standards of care have been and continue to be that care needs to be provided. And certainly those in the healthcare profession take that seriously, because in those situations, you're not just talking about harm, you're talking about potential loss of life, quite frankly. So to me, the federal EMTALA law has been around for close to 40 years and has served very well. One of the questions that I get asked is, and I think it gets into the difference between emergency care and non-emergency care. And sometimes those lines get blurred, but there really is distinctions made in the EMTALA law as best as possible. And there's been some discussion relative to Catholic hospitals that if there is somebody who presents to their hospital in an emergency situation, regardless of what that is, and we've heard testimony in prior years about this, care is provided, which is different, am I correct, than if, say, a Catholic hospital doesn't provide certain services on an outpatient basis. That's different than what needs to be, just not medical standard of care, but also legally by the federal law in an emergency medical situation. Is that correct?
That is correct. So this does not change in any way the outpatient services that the hospital would be required to provide, only the emergency services.
And that's my understanding. And the federal EMTALA law does speak to that and makes a big distinction between the outpatient care and the emergency medical care, wherever that needs to be. Usually those are in the emergency departments for obvious reasons. So to me, looking just at what was the basis of why I was looking to see about what to do about codifying the federal EMTALA law, your office, and I read through your testimony, is really looking to say, and am I correct, that we have this law that's been in place, it's been working well, there were really good reasons this law was put in, with some really horrific situations that were going on before, people being denied emergency medical care or transferred to other hospitals and died as a result before EMTALA went in, that you're okay with taking the existing federal law, not talking about what may happen to it as amended, and having it codified here to protect those basic provisions for the people here in Connecticut. Is that correct?
I will say that, yes, we are interested in codifying what the existing requirements under the federal law is. I will make clear that we feel it's important to make sure that Connecticut is able to have an enforcement mechanism for those laws.
No, thank you. And I'm glad the Attorney General agrees with me on a bill that I had submitted on this, because the federal law does have enforcement. And I do understand reasonable enforcement if we have laws in this state. So thank you, Mr. Chairman.
Thank you. So I want to put something on your radar that we will reach out to you and your office. About a couple of years ago, we had this conversation that if a physician is employed by the state of Connecticut, the medical malpractice in that situation is very different, because if you're working for UConn, if something bad happens to a situation where somebody who's uninsured comes in and they're provided care, University of Connecticut is the one that is going to be sued, and it's the state of Connecticut that is there. And we are trying to look at the EMTALA law from the federal government at that time. This was before we were in the current situation that we are in. And the thought was that for providing the care that is mandated by the federal government for the fairly large number of individuals in very critical emergency situations and ICU or hospital situations, people are taking significant financial malpractice risk. Now, if the state is going to require that, perhaps there's an opportunity for the state to have a support for medical malpractice in those situations as well, to try to make sure that the cost of medical malpractice does not continue to go up. Just something, I don't think you can answer this today. It's a lot more homework, but I think we should have a conversation around this topic as well, now that it's going to be a state law in the picture rather than the historical federal law in the picture. So it becomes a little more closer to home if you will. Seeing no other questions or comments, we wanted to thank you for being here.
Thank you very much.
Thank you. And I just wanted to make a comment quickly that we have passed our 1 hour mark. So now we are going to be alternating between members of the public and some of the elected officials or individuals representing state entities. The person I have number 10 is Rick Porter. You're on. Welcome. Thank you for being with us today.
Good afternoon. I'm Pastor Rick Porter. I'm a street pastor, and I came here to oppose Bill number 7 because I see the pain. I see the pain that our state legislators are really causing. I see the confusion. Kids are being transformed way beyond. I mean, 4th and 5th graders wondering if they're gay. And I was here the last meeting when 2 transgenders were complaining about the books in the schools, how it ruined their lives. And now I'm out there seeing what's going on in abortion. In their last trimester going in there and coming out flush and white. But the thing is that I'm in the streets. I'm inviting you in the streets. And it's the fallen middle class people who are suffering the most. They need opportunity. They need their money spent on creating jobs. I had a woman crying because she then murdered her baby in her womb because of helplessness and hopelessness. And now she's suffering. So when we make laws, you got to put both perspectives in it. You got to really tell the truth from both sides. Can't be just one side, you know. It's a woman's right to choose when you don't even consider the pain that can cause certain people. Yes, I know there's a lot of people who, you know, they abort their babies for one reason only, selfishness. And then later on they grow up and they look back. So even they should have some kind of education, what this can cause them. Because I'm in the streets. I'm with the people. The reason why I'm a pastor is because I can feel their pain. I can feel their sorrow. So let's put some money to bring our jobs back where people feel like, wow, I can use my hands again. I am created by God, and I can use these hands, and I can provide for my family, and I can be the man I was created to be, and the woman I was created to be. Because we are created. What's happening is a transformation spirit. It's getting into our youths, it's getting into our babies, and that is evil. It really is. It comes from the evil one. I know you don't want to hear this truth, but come into the streets with me. I invite you. There's not a place in Waterbury that I cannot go into and people greet me and people hold on to me and have me pray for them and cry, and I will cry with them. And now he's sending me to other cities because there's basically not enough pastors in Connecticut, even though there's a lot of churches. But you have an opportunity to say, hey, you know, let's make sure all voices are heard and not just this group or that group, because you're a causing pain. You really are. Your laws are causing pain. When I look around, especially in Waterbury and in cities and some places in Hartford I go to in Meriden, you know what I see? State communist zombies who don't know what they want to do with their lives.
Excuse me,
Want to do.
Mr. Porter, but you've reached your 3 minutes. Thank you.
So I'm here
Thank
if you need
you.
any questions.
Yes. Thank you so much, Pastor Porter, for your testimony. I see Representative Doffany has a question or a comment.
Thank you, Mr. Chair, and thank you for being here today. It sounds like you're on the streets and you do probably a lot of counseling, I'm sure. That's part of what you do. Can you speak to, which you're right, a lot of times people don't speak to what happens after these life decisions are made and they have to live with those the rest of their life. We think we've solved the problem all in a nutshell by the procedure of an abortion or starting some of these procedures that suggest that they're going to change sexes and that sort of thing. Can you just speak to what you hear and what you're seeing, the aftermath of those choices and decisions, and what people are saying about that?
Well, there's two, the abortion industry and what social level you're at. The pain is just different. And as far as, especially I deal with a lot of men who went through the procedure and, now they call themselves a woman's name. And what I'm seeing in that group, right, is that they're only happy when they're rebellion. In other words, when they're expressing anger and bitterness, they seem to be happy. But behind the mask, right, I had people tell me, it's like, the man part of me is so miserable. I mean, literally cry, in my arms. And the middle class, poor women, they were middle class one time and they lost their status somehow. They're the ones who seem to be suffering the most when it comes to the abortion industry. That it was helplessness. And now they wish they held on to that hope. It was, and the only thing I can do as a pastor is saying, hey, listen, you're forgiven. If you take it to God, you will be forgiven. You will be forgiven. He'll take that pain. I can't take the pain, but he can take it. So I point them to Jesus Christ to take the pain. But our laws are not helping. The laws that we're passing is so one-sided. They didn't see any option. And quite frankly, a lot of the groups who are trying to give options are being shut down now. They're being frowned upon and stuff like that. I go to New Haven abortion clinic and I see them in their final trimester. And so that's another thing that I was listening to the last lady say. So who's gonna say what's emergency? Well, I just don't want this baby born. It's emergency. I have an emergency. Let's get this, because I might harm it. Or, well, I mean, who's going to define these emergencies?
Thank you. Thank you for your testimony today. Thank you, Mr. Chair.
Thank you so much for your testimony. Seeing no other questions, we move to the next person on our list, which is Treasurer Eric Russell. Welcome. I just wanted to quickly make a comment that we do have a viability ban in the state of Connecticut, so that should be clarified for people if they're confused. Thank you.
Good afternoon to members of the committee, and thank you for the opportunity to submit testimony in support of Senate Bill 7, an act concerning protections for access to healthcare and the equitable delivery of healthcare services in the state. I want to spend my time this morning or this afternoon discussing a specific provision in the bill that would establish a safe harbor fund. We are fortunate to live and serve in a state that prioritizes an individual's right to make informed private decisions about their own bodies and healthcare. And thanks to the leadership of the General Assembly and Governor Lamont, we have extended legal protections to providers of abortion and gender affirming care under the state's safe harbor and transgender health shield law. Moreover, as state laws banning abortion and strictly limiting gender affirming care have proliferated elsewhere, Connecticut has welcomed anyone being denied care in their home states to seek care in ours. These laws and policies have been helpful for those who can afford to travel to Connecticut and receive the care they need. But for those who do not have the means to travel, often low-income individuals, people of color, young adults, the safe harbor provided in Connecticut is out of reach. The Safe Harbor Fund is designed to reduce this financial barrier. As currently drafted, this privately funded state-led initiative would be governed by a board of trustees who would issue grants directly to nonprofits and healthcare providers who are already providing safe and compassionate care in our state. These grants would help patients in need pay for costs like travel or lodging or childcare when seeking access to healthcare in our state that is unavailable in theirs. I've advocated for the establishment of this Safe Harbor Fund since the Supreme Court's Dobbs decision, and its urgency is only increased. Regressive and often cruel policies banning abortions and prohibiting gender-affirming care are creating a crisis for families and individuals. States with abortion bans have seen a threefold increase in maternal mortality rates, and suicide rates among LGBTQ youth, particularly transgender children, continue to rise at alarming rates. These tragedies are documented and research and examples included in my written testimony. By establishing this fund in Connecticut in statute, the state can send a reassuring message to the nearly 25 million women of childbearing age that live in states with abortion bans or restrictions, and the 118,000 trans youth who live in the 26 states that have passed bans or gender-affirming care restrictions. That Connecticut's safe harbor is accessible to everyone, not just those who can afford it. Ultimately, it's my hope that other states who share our values will follow our lead and establish similar funds of their own. The right to make choices about your future and access healthcare services should not be determined by where you live or how much money you have. By establishing the Safe Harbor Fund, we are fulfilling the promise that dignity, respect, and care will always have a place in Connecticut. So I urge the committee to act favorably. Thank you for raising this bill and for the opportunity to testify. And with that, I'm happy to take any questions.
Thank you so much, Treasurer Russell, for your testimony and your advocacy on this important issue for the past couple of years. Who's paying for this?
So the Safe Harbor Fund would be privately funded. We have already had conversations with outside organizations. We've worked collaboratively with other states in conversations around raising dollars into these funds. So there would be no state funding that would be credited to these accounts.
So why does the state of Connecticut need to hold on to this?
So there are a couple of reasons. One, just from a practical perspective, Treasury has the function and ability right now to hold and safeguard these funds and to make sure that we are able to invest the dollars that are in these funds to keep the funds growing. And so from a very practical perspective, there's just the component that would be really helpful. But I think more importantly, I think it's setting up a fund like this in Connecticut is sending a really resounding message to the residents of our state, but more broadly, that we believe that we're a state that truly is a safe harbor, and that doesn't just apply to individuals that have the resources to say, I'm going to take 3 days off of my job and travel to Connecticut to get the care I need. That we know that the folks who will be most impacted by these restrictive laws are individuals that are working hourly jobs, that may be single parents that don't have the resources, that don't have the ability to take 3 days off of work and travel where they need to. And so I think it sends a really clear message about who we are as a state. And then from another practical perspective, being able to build out these coalitions with other states and dedicate resources where they're most needed for people to get the care they need, I think is a really valuable way of leveraging the state's position.
Thank you so much for clarifying some of these important questions. I think there are confusion again in this situation out in the public that this bill is asking for the state money to be used for this purpose, or taxpayer money, but you just clarified that that's not the case at all.
Not the case at all. So we are not looking for any taxpayer dollars to be going into this fund. These will all be privately raised fund dollars.
So this fund has a home in the state at this time, theoretically speaking, if we move forward and this becomes a law. Fast forward X amount of years, there is a new treasurer, new governor, and they say, we do not believe in the historical ideals of the state of Connecticut. What could happen to this money?
So the funds would likely be going back to or to another state that would have a safe harbor fund where the resources could be used the same way. We have a board of trustees under this legislation that would be deciding dollars that we would be accepting, and then would be going through the process of deciding how those funds would be distributed to existing nonprofits or healthcare providers who are providing care. We would go through that same process for delivering those dollars back as well.
Thank you so much for that answer as well. I was going to ask my co-chair, but she's yielded to Representative Dauphiny. So Representative Dauphiny, you're on.
Thank you, Mr. Chair. Thank you for your testimony today. I was just trying to clarify, because what you just said, I'm trying to understand the language in this bill on line 1 049, it says the account shall contain any monies required by law to be deposited in the account and any funds received from any public or private contributions. It's a little confusing. I wondered if you could, elaborate on that in terms of you're saying there's no taxpayer money required or would be put into this fund. Sounds like you're saying it would be all volunteer. Can you just clarify that?
Yeah, so I think this, yes, is intended where we would only be using private funds. I think this language was included in the event that there was ever interest and the state decided that it was going to put money in. We wanted to have just clarity that we would be able to distribute it. We're also open if that language is comfortable taking that piece out. But to be very clear, the intent here is that these are only private dollars going into the fund itself.
So if I may, Mr. Chair, and just to clarify, so if this bill passes, there's an open door for going forward, putting taxpayer funds into this account.
Yeah, this is just standard language when the accounts were created, which is why we use that. But again, we are happy to take that language out if it is something that would make the committee more comfortable. Because again, the intent here is that these are all private dollars. We are not looking for any appropriations from the legislature to fund this.
And so if I may, so we have this being set up, is that something that you would see as an opportunity to maybe do another kind of fund that would then support, let's say, adoption for people wanted to put private funds into an adoption situation that would help those sorts of things? I mean, this seems to be kind of the opposite of that, but would you be open to something like that as well?
Certainly happy to collaborate with the legislature on any issue that is important and that would relate to our office. To be clear, I appreciate the question. I don't think it's opposite to. I think that these are, there's a need for support for many services and for many different constituencies in our state. This was created specifically in the wake of the Dobbs decision in terms of this concept, understanding that there are many people right now, unlike with adoption, where there are many organizations providing support, that there isn't the ability for many people in other states to get the care that they need. The state, the legislature, the governor have made very clear that this is a priority for us in Connecticut. And this is a way to make sure that all individuals from those states have access to get the care that they need.
Thank you. I would just say that for the adoption agencies that I know across the state, there's nothing that the state does to help precipitate that. That's so I just add that to it. But thank you. I appreciate it.
Senator Gordon.
Thank you, Mr. Chairman, and Mr. Treasurer, thank you for being here today. I've read through stuff on the bill, and I won't go through all my questions. They're really procedural.
Okay.
I'm not going to ask any questions at this point in time relative to any merits of trying to create this account, and some of them have already been answered, and some I can follow up at a later time from a procedural point of view. But one of the questions I have is, since your office would be, if this were to be created, your office would administer this account. It'd be a board setup. Would you then expect any need for additional staff and or additional funding for your office to be able to handle this? Or is this something through current staffing levels and current budget for your office would just be put into it and nothing extra would be needed from how to administer this?
Yeah, so we would need nothing extra. The investments would happen alongside either our short-term investment fund or existing pension assets. So that would be just simply additional dollars added to the investment work that we're already doing. And the trust itself, the Board of Trustees, would be constituted by several members. We would have regular meetings, but that would not require any additional administrative support.
Thank you. And one last question I have for the public hearing is, I'm assuming your office and you, as the treasurer or whoever would be treasurer at any future time in this state, if this account were to still be in place, would have the oversight to make certain money is handled properly. But is there any checks and balances outside of your office that would be looking into this, such as undergoing audit reports or oversight by the legislature?
Yeah, so first I would say that the trust itself would be governed by that Board of Trustees. So there would be several members that would be overseeing any of the funds that are actually attributed to the safe harbor account. But secondly, all of the money that we manage, everything that we do on the investment side in our office is audited on an annual basis, and this would be no different. This would be included in that audit process as well.
Thank you, Mr. Chairman. Thank you for testifying.
Thank you.
Thank you. My co-chair, Representative Kristen McCarthy.
Thank you very much, Mr. Chair, and thank you, Mr. Treasurer, for being here with us and for your tremendous advocacy for some of our most vulnerable communities, especially in light of what we're facing now. A couple questions. Just in terms of the adoption piece, you may not know this, but is adoption restricted in other states in the country that you're aware of?
Not that I'm aware of broadly. I know that there are, as we've seen oftentimes, I can speak specifically to the members of the LGBTQ community that there have been certainly efforts to restrict who can adopt children, but not adoption more broadly.
Thank you. Thank you for that clarification. I, at one time, served as a post-adoption social worker and have been very supportive of adoption work. But I think that specifically this effort is an attempt to address the fact that what we heard earlier today from our Attorney General's office, the patchwork of laws around the country as the federal government continues to, in some ways, and I would say maybe allegedly, give more rights and abilities to the states. One of the questions that we've heard from people, and I think you've spoken to this a bit in your comments, but specifically is why not a nonprofit? There are some national nonprofits or regional nonprofits who are certainly trying to support efforts to assure that people are able to access care. So what is a way that this is different, and why do you see it as important rather than going through a nonprofit?
Sure. So thank you for the question. I think I think we have the capacity in the treasurer's office to maximize these dollars. And so as they're not being used, if they haven't been distributed from a grant perspective, we can invest these funds and make sure that we are, again, maximizing the resources that we are able to raise. Two, I think as you talk about this patchwork of legislation, right, and restrictions, we have the ability to coordinate with other states in a very concerted way to create a network of states that have safe harbor funds. We've been in communication with many. Vermont, for example, is rolling legislation, safe harbor fund legislation this session as well, but to make sure that we can dedicate resources to states that are most in need and to build out a broader network where people can access care. Obviously, if we are able to do this, Connecticut is going to have less need, I think, for funding than, say, a state like Colorado that is surrounded by many anti-choice states. There's going to be a need for more resources. So we're able to coordinate that, I think, in a more concerted way. But frankly, I just think that we have an obligation to do this. I think it sends a really clear message about who we are and what we're about, and making sure that people have access to care in a trusted way, coming from a trusted entity like the state, rather than trying to find organizations that may be able to help fund travel and lodging and childcare when they are most in need.
And just to follow up, is this exclusively for people coming to Connecticut versus if there are Connecticut residents, for example, because of the viability ban that we do have, and at times if there was ever a need, I'm just theorizing here, for a Connecticut resident to travel, would it also apply for them as well?
That would certainly apply. And I think one example that I often think of is you could have a Connecticut resident that is, say, in college in Texas that may need access to care that they are not able to get in that state, but don't have the resources to get on a plane and come home to get the care that they need. This could very much be beneficial to Connecticut residents as well as those traveling from out of state.
Thank you, Mr. Treasurer. Thank you, Mr. Chair.
Thank you. I just had another question quickly, and then I'll come back to you, Representative Toffany. I just want for the record to be able to make a quick little statement so that when you had approached the Public Health Committee leadership, including our ranking members and the chairs, you have been very clear from day one that you did not want any public money whatsoever. So I wanted that to be on the record. It was only private funding. And your proposal states that as well. The bill has been written based on your proposal, but the bill has used the standard language that is used, and that's why the public money component may have come in there, but it's not coming from your office any shape or form. Is that right?
That's correct. And thank you for clarifying.
Yeah. And frankly, because that's the intent, if that part of the language is removed, your office is fine with that.
That's correct.
Okay, just wanted to mention that. Representative Daphne.
Thank you, Mr. Chair. And for the second time, our good chairwoman mentioned that this kind of treatment or access might not be available in other states where adoption might be, but you keep talking about access, and access we know is cost, right? People having the ability to pay and afford. And I think the precedents we're setting here is that we'll stay on one side of the argument, which is to destroy lives, and then on the other side, we're not putting those dollars in to save lives. And that was the point I was trying to make. Is that's where I was going with the adoption. Is there's been no initiative to do that piece of it. So I just wanted to clarify that. While I know there's adoption in other states, it's very expensive and costly.
And I appreciate your comment, although I would obviously disagree with the framing. The one thing that I would say is if you would like to collaborate on the creation of a fund or raising dollars to support adoption in Connecticut, I would be happy to collaborate with you on that.
That sounds great. Thank you so much.
Thank you. Seeing no other questions or comments, thank you so much, Mr. Treasurer.
Thank you.
Look forward to working with your office. With that, we come back to the member of public, which is Ellen Lizio. Welcome. Thank you for being here with us this morning and afternoon.
Good afternoon, Senator Anwar, Representative McCarthy, and members of the Public Health Committee. My name is Ellen Lizio, and what brings me here today is Bill number 7, Section 480, which requires providers of epileptic patients to counsel them regarding sudden unexpected death in epilepsy. I'm here today because SUDEP snuck into our lives unannounced and without warning. On February 4th, 2024, my son, Trent J. Lizio, had been at his dad's house doing what he loved the most, drumming. I'm so glad that the drums were at his dad's house. Trent texted me that afternoon saying that he'd be staying at his dad's that night because he was tired. Trent was an accomplished musician, extremely loving big brother to my daughter, Kate, a believer in all that was good. Things that were funny. He was creative, hardworking, about to start his second semester in college, and he had the most expressive big brown eyes you could ever want to see. He was also a lover of the color orange, which is why I look like a giant jack-o'-lantern right now. So we texted a few more times that night, and I wished him sweet dreams. The following morning, on February 5th, 2024, I received a call from my daughter asking why Trent's car was still in the driveway around 10 a.m. when he would normally be at work. Me figuring he overslept, I asked her to go in and wake him up and send him off to work. I texted Trent, "Are you awake?" There was no response. I called Kate. No answer. There was just silence. During that silent time, I later learned that Kate had found Trent dead in his bed. She had dragged him to the floor and started CPR on her big brother, called 911 and called her dad, who returned home from work and took over CPR until EMS arrived. My son, Trent J. Lizio, was pronounced dead in his bedroom on the floor. We learned later from the medical examiner's report that no parent should ever have to read that he died from SUDEP, sudden unexpected death in epilepsy. We knew nothing about what caused Trent's death. Even I, as a nurse for 23 years, specializing in critical care and trauma-based care, had never heard of it. Oh, so SUDEP was never discussed with us when we went to appointments with Trent. I went to appointments with him. His dad went to appointments with him, not because we were trying to be overbearing, but because he asked us to. He wanted us to be involved in his care. So when I started, he had never been notified about SUDEP. It was never discussed. No plan was ever created in case of an emergency. And there are things that could be done to minimize the risk, such as staying on your medication, which Trent did.
Excuse me, Ms. Lucio, but you've reached your 3 minutes. Thank you.
Please go ahead, finish your testimony.
Thank you. There were several things that he could have done, that we could have done to minimize his risk, such as being more aware of him having seizures at night. We were not aware of this. He wasn't aware of it. His age, the fact that he was Caucasian. 79% of SUDEP patients are Caucasian male between the age of 20 and 40. When I notified Trent's providers of his passing, 3 out of 4 of his providers did not know what SUDEP was, including the person, the APRN, who took him off of his seizure medications. This has to be changed. Caregivers of epileptic patients have the right to know about SUDEP, its risks, and reducing the possibility of it occurring. Education and knowledge of SUDEP is power. It may help alleviate the fear of it happening. Counseling needs to be fit to each person. Giving providers the tools to discuss SUDEP with patients is as important equally. Educating them as to the risk factors of SUDEP, why and how SUDEP happens, and how to reduce the risk, and how to have these difficult conversations with people. It's difficult to sit in an office with a person and tell them that they could potentially just die in their sleep. I would much rather have been informed than eternally and desperately mourning the loss of one of the 2 favorite people in my life. And when I lost my son, I also lost a huge part of my daughter. No sister should have to do CPR on their brother who clearly was not coming back. Had he still been on a seizure medication, it's possible that he might not have died. Had he avoided triggers that we weren't aware of, he might not have died. We didn't know the questions to ask or the path to take because we weren't given the information. My family and friends have suffered a crippling, horrible loss. There are no todays, no tomorrows. There's just simply the day that Trent died. Please vote this bill in. It could save another family from suffering the way we have. It would be greatly appreciated. Thank you for listening and taking the time to help create this bill, Senator Anwar. I appreciate your help, your support, and your caring. You are an amazing person, and you are appreciated. Thank you.
Thank you. Ms. Lizio, thank you so much for your testimony. I'm so sorry again for Trent's loss.
Thank you.
Thank you for sharing your testimony. And I know every time you share this, it's very painful,
It is.
but you do it because you want to save other people and other
Absolutely.
families from hurting.
Yes.
We cannot thank you enough. And thank you
you.
for sharing Trent's pictures. His eyes are beautiful, as you've said.
Thank
and,
you.
And he's a musician. He's
Yeah.
a good musician.
Thank you so much.
Sure. I have Representative Dauphiny who has a question or comment.
Thank you, Mr. Chair. I don't have a question. I just wanted to thank you too. It was a very heartwarming testimony.
Thank you.
And I'm sure he's looking down at you and saying, that's my mama.
That's what he used to call me,
That's-
Mama.
Yeah, there you go. Thank you.
Thank you so much.
Seeing no other comments, we move to the next person on our list, which is Representative Carrie Wood. Representative Wood, thank you for being here this afternoon and being here this morning as well.
Thank you, co-chairs of the Public Health Committee and ranking members of the Public Health Committee. My name is State Representative Carrie Wood. I represent the 29th District. I'm here in my capacity as Chair of the Insurance and Real Estate Committee. I am opposed to Section 14 of SB 7 and ask that the committee consider removing that before passage. The committee, Insurance and Real Estate Committee, held a public hearing on SB 10, which had a very comprehensive public hearing and more language around regulations in terms of stop loss. That section of the bill was amended by my co-chair. It was unanimously removed in a bipartisan manner. And the bill SB 10 was voted out of committee without stop loss regulations in it. So I think it's a very dangerous path to go down to start discussing regulations around a tool that helps businesses maintain more affordable healthcare.
Thank you so much, Representative, and thank you very much to the Public Health Committee for giving me the opportunity to testify on this
Grace,
bill.
can you introduce yourself?
Sorry?
Can you introduce yourself?
Oh, yes. Thank you so much. My name is Grace Bringman. I am a public policy associate with the Connecticut Business Industry Association, testifying in opposition to Section 14 of SB 7. So this section establishes a study on the feasibility of regulating stop loss policies coupled with self-funded health plans as fully insured plans. And we find that equating self-funded plans and fully insured plans may create a legal gray area, as the regulatory standards for self-funded and fully insured plans are completely different. And as Representative Wood spoke to earlier, this section is also an insurance issue that is being discussed in a different committee of cognizance. So I'm going to provide some context on this issue and then bring the argument full circle. Employers typically provide health benefits to their employees in two ways. One, a self-funded plan where they directly pay for medical claims as they are incurred, so kind of a pay-as-you-go model, or a fully insured plan where they pay monthly premiums to an insurance company who assumes medical risk. Self-funded plans are coupled with a stop-loss policy that protects employers from high costs incurred from catastrophic claims. Self-funded plans are regulated at the federal level by the Employee Retirement Income Security Act, more commonly known as ERISA. Stop-loss policies and fully insured plans are regulated at the state level by the Connecticut Insurance Department. And the fundamental question that this language is trying to ask is, how can we apply state-level regulations of a fully insured plan to federally regulated self-funded plans? And quite frankly, my answer to that question is to consult an ERISA attorney, as well as the relevant case law that defines this preemption doctrine. By treating stop-loss policies coupled with self-funded health plans as one entity, this proposal could potentially violate ERISA. And the study established by this bill could really open a Pandora's box of consequences that could affect an employer's ability to offer benefits. And when we talk about employers, we're not just talking about small businesses, we're also talking about the state health plan, as well as towns and municipalities who also self-fund. So with that, echoing Rep. Wood's statements, I do urge removal of this section from this bill, and we're happy to take any questions. Thank you.
Thank you so much for your testimony and thank you for being here. So explain to me how this is going to have a negative effect on the state employees.
I believe that the state employee health plan is self-funded. If you could speak more to that, Rep. Wood, I think you might have more insight on that.
Sure. If stop loss regulation was to go into place, we consulted with brokers that sell these types of policies, and there was anywhere from a 10 to 20% increase in costs. So adding additional regulations around plans that these municipalities, small business, medium-sized business. I mean, right now, the concern is help us with our insurance costs. That is what we hear all the time. Why would we want to add up to a 20 or 25% increase by regulating stop loss plans. We also want to make sure that stop loss exists as a tool. And when we did go out to the industry and ask what happens if regulation comes around stop loss, they might not use stop loss. They might have to pivot to a different direction. So we should be focused as a legislature on providing more options in this space rather than putting more regulations, cost, expense, and offering less tools. Businesses, nonprofits, municipalities, towns, fire departments, they are looking for help and relief in the cost of health insurance.
And if I could add on to Representative Wood's statement, in 2019, there was a bulletin published by the insurance department that really outlines the criteria for a stop loss policy being approved. And in that bulletin, and I encourage you to look at it as I'm paraphrasing here, but it basically said a stop loss policy may not be approved by CID if it essentially acts in lieu of a health insurance plan. So I just want to note that as well.
Thank you. This is very helpful. Thank you for taking the time to help us understand this better. Thank you. Seeing no questions or comments, appreciate you guys being here with us.
Thank you.
Thank you.
Thank you. Is Representative Cohn here? But we'll go to Katie Rudek. And then after that, we'll have Senator Cohn. Welcome. Thank you for being here with us. Go with the one on your left. Yes. Go ahead.
Members of the Public Health Committee, my name is Katie Rudek, and I'm honored to stand before you today as VP of Clinical Integration for Kooth Digital Health. Before joining Kooth, I served as a mental health professional for 10 years in community mental health settings as both a clinician and an agency leader. Today, I am testifying in support of Committee Bill Number 7, an act concerning protections for access to healthcare and the equitable delivery of healthcare services in the state, sections 22 and 23. Youth mental health is in crisis, and the long-term societal consequences are severe. This crisis is not just an individual issue. It is a systemic one that requires innovative, large-scale solutions beyond traditional care models. In Connecticut alone, 40,000 youth aged 12 to 17 struggle with depression, yet nearly half do not receive any care. According to the Annie E. Casey Foundation, youth in Connecticut have reported feeling sad or hopeless almost every day for a period of 2 weeks or more at an increasing rate each year since 2017, rising from 27% to 36%. Additionally, the percentage of youth reporting 0 poor mental health days has dropped from 51% to 37% over the last decade. The proposed pilot program aligns with the urgent need for scalable digital mental health solutions that provide universal access to support services, shifting from reactive crisis management to true prevention and early intervention. A preventive population health approach complements the companion bill in the Education Committee dealing with treatment and fills the gap between no care at all and clinical mental health treatment. Ensuring that mental health support reaches young people before they hit a breaking point is critical to fostering resilience and well-being. For over 2 decades, Kooth has provided digital behavioral health support to youth, including through Saluna, a mobile platform that provides preventive mental health and wellness support through 3 pathways: evidence-informed and research-backed educational resources that promote mental and behavioral health awareness, coping strategies, and emotion regulation skills; a pre-moderated online peer community forum that fosters mutual support, enhances social connection, and reduces isolation; and private online sessions with licensed mental health providers. This population health model bolsters traditional in-person care by making preventive mental health support, awareness, and education accessible to all, regardless of acuity of need. Saluna has already made significant impact, serving more than 20 million individuals across California, New Jersey, Illinois, and the UK. With over 40 peer-reviewed studies, Kooth has demonstrated the impact of preventive population-based mental health services. Health economic studies show a 3-to-1 ROI driven by reduced mental health-related medical costs downstream, including a reduction in hospitalizations for suicide attempts, self-harm, and high-risk behaviors such as binge drinking and smoking, and a decrease in antidepressant prescriptions for youth. Additionally, 3 in 1 survey respondents reported that they would not have access to mental health services without Saluna, and 88% had at least one need met in a single session. For these reasons, I am testifying in support of Committee Bill Number 7. I appreciate your time and attention to these crucial matters and stand ready to address any questions at the appropriate time. Thank you.
Thank you so much. Can I ask you a few questions quickly? So
Yes.
tell me a little bit. My understanding is that the NHS in United Kingdom has been using this. What is your experience with that? Because that's a very large sample size.
Yes, so we have over 20 years of experience in the UK funded by the NHS. And we actually have peer-reviewed published papers showing what is in my written and verbal testimony, the effects of these preventative upstream mental health solutions. So a reduction in hospitalizations for suicide attempts, a reduction in hospitalizations for self-harm, binge drinking, and smoking behavior, even improvements on assessments such as the CDOS, which measures suicidal ideation, the YP core, which measures anxiety and low mood, and the HOPE scale, which measures a young person's perception of their hope for the future. So we were actually able to see statistically significant improved assessments when a young person had access to COOTH.
So when I heard about this the first time, without doing a deeper dive into this, my reaction was, well, cell phone is part of the problem. The apps are part of the problem. Now here we are saying, well, there's an app that is going to help take care of the needs of the emotional challenges that those children are having because there's a network of support in place. And I've looked at some of the data and it does pan out. But do you have any information? In the US, I understand California has done some of this as well, and other states are looking at this.
Yeah. So I'll address the cell phone issue. We're very aware of the tightrope walk between guiding young people towards their cell phones and offering a supportive service in a place where young people go anyway. So we actually, our content and our services are really aimed at teaching young people skills that they need and psychoeducation that they need, and then encouraging them to weave it into the fabric of their everyday life. So they're not dependent on going back to the phone over and over and over again. In California, we serve every 13 to 25-year-old in the state. They have access to our services, and we're seeing early successes. We also are serving a pilot program in Illinois and a pilot program in New Jersey right now.
Thank you so much. This is helpful. We appreciate you being here, and we look forward to we have two of my colleagues have a question. My co-chair, Senator Gordon, if you go first. Yeah.
Thank you, Mr. Chairman. Thank you for testifying. My understanding is that this is something that would be used via the technology, which most kids nowadays, everything is driven by their phone. And this is through the school systems? Is that my understanding?
So when we partner with a state, we collaborate with school districts, we collaborate with community mental health agencies, mobile crisis units to establish relationships so that we can make parents and young people aware of our services. However, a young person can access our services through the app on the phone.
Thank you. And a follow-up question is if this is something that a minor child would potentially be using, and I'm not speaking to any merits or the importance of addressing mental and behavioral health, which I understand, but from a procedural point of view, if this is something to be offered to a minor child, this would or would not, in all cases, require the consent of the parent or the legal guardian?
Yeah, so we would comply with Connecticut state laws regarding age of consent. And if the young person is under the age of consent, we would require parental consent prior to them engaging with one of our providers on the service.
Thank you. Thank you, Mr. Chairman.
Madam Co-Chair.
Thank you very much, Mr. Chair, and thank you for being here to testify and for this important work. When I was a youth minister, I used to say we meet people where they are. So I think that's the idea behind this. The question I have is you have pilots in New Jersey and a couple other places. Just can you talk a little bit about how those pilots work? Because, you know, the California example is pretty ubiquitous, but how are you implementing those pilots and what areas are you trying to pinpoint in that?
Yeah, so we work with each state to identify the areas that they want to serve. So it's really up to the state as to what counties or districts they want to roll out in. And how we do it is we just have the access open to either a specific area code or a location based on what the state wants to do. So a young person could put in their zip code and then they would have access if that zip code is in the area of service.
Great, thank you. So really it's state driven in
Yep,
terms of
it's
how that
state-driven.
works. Okay, thank you. Thank you, Mr. Chair.
Thank you. Seeing no other questions and comments, we thank you for being here with us,
Thank you so much today for your time.
of course. And next is Senator Cohen. Welcome. Thank you for being with us and thank you for waiting from morning till this afternoon. And I know how busy you guys are.
Thank you, Mr. Chair, Madam Chair, rankings, and members of the committee. We will expedite our testimony because Dr. Moore here is going to be late for his shift at the hospital. But I did want to just thank you for raising SB 1538. We're here to talk about that today, and I will cede my time to Dr. Moore in just a moment. Really appreciate the efforts on this bill. As you all know, I have taken a special interest in this matter since Dr. Moore, who's a friend and a constituent, has raised the issue with me a number of years ago. And this committee has been gracious enough to promote a working group on the topic. And as a result, there were several measures that were and recommendations that came out of that working group. And while this bill deals primarily with the conservatorship aspect of those recommendations, I think we'd like to ask that it go a step further and perhaps incorporate the quality control measures that were suggested through the Office of Healthcare Strategy and perhaps some other measures that were recommended by the working group. And so with that, I will turn it over to Dr. Moore. Thank you.
Thank you. Thank you, Senator Cohen. Dr. and Senator Anwar, Representative McCarthy-Vahey, and all the members of the Public Health Committee, thank you for the opportunity to speak to you again. I'm here to speak in support of SB 1538. I urge you to pass this bill and to consider strengthening it or other relevant legislation substantially. While conservatorship is one small part of the issue, there's much more that is needed. Over the last 2 years, at the request of the legislature and this committee, I and more than 24 volunteers spent hundreds of hours examining the issue of emergency department boarding and crowding and produced our report last December. This not only involved substantial time, but put some of us at risk professionally. I'm personally aware of at least one person on our work group who had their position at the hospital threatened due to publicly speaking out about the risks to patients due to hospital boarding. I'm not sure how many of you might recognize the name Libby Zion. She was an 18-year-old who died suddenly in 1984 due to factors that were ultimately attributed to excessive resident work hours. There were likely many deaths due to overworked residents. However, Libby Zion happened to have a powerful and well-connected father who became obsessed with appropriate changes and accomplished them. I can guarantee you that over the next year, someone in this room will personally experience or have a loved one experience the indignity, discomfort, and safety risks associated with hallway care and hospital boarding in the emergency department. I hope that we don't need a Libby Zion moment to affect someone in this room to really convince you of the need for change. The recent CHA report tells us that nearly 4 in 10 admitted patients to the emergency department, or more than 80,000 Connecticut residents annually, will experience boarding times of at least 4 hours, a threshold that has widely been used to delineate unacceptable care. Thank you for passing Public Act 244. It is the first law of its kind in the country to require reporting on boarding. It shows that the issue is widespread and gives us a baseline for change. However, we need you to continue work that this legislation has given us a toehold on. So what should you do? I would like to suggest that you strengthen this bill or SB 7 by directing the Office of Healthcare Strategy to incorporate boarding measures similar to those provided through Public Act 244 as a quality measure for value-based care, which can be revenue neutral, even positive for the state. This and issues of capacity are fully within the purview of OHS. I applaud the OHS for incorporating some of the considerations of boarding into the recent March 15th report on healthcare facilities and services. However, we need to routinely include this as a measure of quality of care and to incentivize hospitals appropriately. 18 years ago in 2007, the legislature failed to pass HB 7293, an act concerning emergency department crowding, and emergency physicians were left defeated. There's no doubt patients have died and continue to die due to substandard emergency department space and resources. Here we are again. We have done our work to guide you in addressing this issue. Please do not let this work and the ongoing work on behalf of our patients be in vain.
Thank you so much, Senator, and thank you, Dr. Moore, for your commitment to this important issue. This bill obviously does not do a whole lot, though, in the current form at this time, based on the report, which is a pretty robust report. And I think when I look at that report, it almost looks like the crowding is a symptom of everything that's going wrong with our healthcare system, between the hospital patients not getting discharged and part of the Medicare Advantage plans, which are just a very big hurdle for patient to get the care that they need. And it's a number of different aspects. And many people are coming in when they do not necessarily need emergency level of care because they're not able to be seen in a timely fashion in the outpatient setting as well. So it's a combination of everything that goes wrong that we are seeing. Tell me a little bit about the quality criteria. And then I spoke to the Office of Health Strategies about quality criteria, and you heard the commissioner. Could you speak a little bit about that?
Sure. First of all, you mentioned overutilization, which is certainly an issue for getting patients in and out of the emergency department. But we'd like to emphasize that the real issue is boarding, and it's the use of space and time in the emergency department to care for patients that are already admitted. Yes, this is a big issue, and there's many factors that play into it. However, there are times where resources are prioritized to other things, and this is a place where it's been going on so long. That's why we're here at the state level and not addressing it at individual hospitals. It's affecting patients, but there needs to be some pressure to move the resources in the right way and to provide the appropriate resources. Our report may have been overly comprehensive. We do advocate for more resources for the hospital, but if we had to narrow it down, as I said in my testimony, I believe looking at overall state capacity issues and making sure that distribution is correct, as you raised with Commissioner Gifford. If you have a hospital bed up at, Charlotte Hungerford, it may not help, the patients that are waiting for a bed down at, New Haven Hospital. So I think it's an issue of capacity distribution, but it really, should be addressed. And that's why we think OHS may be an appropriate place to look at that.
Thank you so much. Senator Marks has a question online, and then followed by Senator Gordon.
Thank you, Mr. Chair. Thank you, Dr. Moore. It's good to see you again, but I'll be happy when we're in session and we don't have to see you anymore because this problem's been taken care of. I can't imagine as a 62-year-old woman lying in a stretcher for more than 4 or 5 hours, right? Especially not in a hallway. And we all know that it happens all the time. My local paper, the New London Day, had an article yesterday about the increase in violence to nursing staff, especially in emergency departments and psychiatric floors. But do you see an increased risk to your patients that are being boarded in the ED, their frustration, increased agitation, and how that might affect the safety of everybody in the emergency department?
100%. And this is not just boarded patients, but boarding leads to overcrowding. I don't know if anyone's watched The Pit. It's on HBO Max. If you had to watch even the first episode, you get a bit of a sense of what we're dealing with. But that series actually used many emergency physicians and consulting to develop the storyline. There was I don't know what episode, spoiler alert, there was an assault on a nurse from a patient who was waiting. And this is something we see increasing all the time. And a lot of it is related to boarding and crowding. So 100%, staff violence, staff burnout is a result of this issue.
Yeah, thank you. And I just, when we lost a nurse in home care last year, so many of us had said, we all kind of knew this was going to happen, right? And I just fear that we are going to not fix this until something terrible happens. So hopefully we can do a little bit more work and we can get those insurance companies to not punch out at Friday at 4 o'clock and come back in Monday at 8. So our patients are also lying in beds waiting for the insurance company to say that they can have a room at a nursing home, which I'm sure is a huge part of the problem. So thank you so much for all the work you do. And thank you, Senator Cohen.
Senator.
Could I just add to that too, just respectfully, and thank you, Senator Marks, but I will say that something terrible has already happened. There's already been loss of life in our hospitals because of this issue. So I just wanted to make that point.
Fair. Good. Senator Gordon.
Thank you, Mr. Chairman. Senator Cohen, Dr. Moore, good to see you. I know you and I have chatted quite a bit about this, and I do see it firsthand when I have to take care of my patients who have been admitted to the hospital, but are still in the emergency room for a number of days. I've read through the report, and as you know, you worked with a number of folks, including my good friend, Dr. Shanghold, so he reminds me of the report every time I speak with him. But relative to the bill before us, I know this is just one piece of the puzzle, and in the working group recommendations, you talked about a number of things about wanting to look into a better way to deal with the hospital discharges. And I'm not necessarily blaming the hospitals, but as you know, there's a lot of complications and challenges sometimes to get patients out of hospitals, especially if we have to get people to nursing homes, rehab facilities, and some of the red tape issues and blocking and other things we find. But in your years that you've been doing this, you've been seeing this problem get worse and worse about the backlog of people who could be discharged from a hospital, and all intents and purposes they're just stuck still in the hospital. And that, of course, then backlogs to the emergency room where you're trying to get people who should be in the hospital onto a floor bed or an ICU bed. You've been seeing this just getting worse and worse over the years?
Absolutely. Oregon has a state level hospital discharge challenges task force. I've been talking with their state a fair amount, and that was one of the primary recommendations of our report is a discharge challenges work group. We understood there might be a fiscal note attached to that, which could make it difficult. I still believe that would be important to look at those issues. Hospital beds after World War II were about 1.6 million for the United States. They're now about 600,000. We were able to adjust for that by taking the length of stay down from over 20 days in the 1950s to around 6 point something days now. But in 2019, that reached a nadir, and it's coming back up. And the reason for that is because we have baby boomers that are getting older and sicker, and we can't get them out of the hospital, in addition to avoidable care delays, such as getting post-acute care, whether that's nursing homes or rehabilitation facilities. So 100%, I think there are solutions, but we need to really look at them as, from a statewide perspective. So it's absolutely getting worse. A lot of times the hospitals can't help but back up into the emergency department. And that's, part of the recommendations of our group to look at that. But it should still be a quality measure in and of itself, the care of patients in the emergency department.
Thank you. And I agree. And I think a lot of the recommendations that your working group put together are really good to look at. And you cited Oregon. There's a few other states that have been trying to delve into this, and we don't necessarily have to reinvent the wheel in this state. We can see what a lot of other states are doing, but your working group recommendations are, to me, hits the nail on the head. And I really hope we can, as a legislature, look to delve into it more, and what can we do to enact some of this, especially the quality measures, to better understand.
And just to say, Connecticut really is leading the way on this nationally. We're getting a lot of attention from our national organization because you guys have passed some things. PA 24/4 was extremely helpful. So, there are times where we have to look to other states to see what they've done, and there's times where we need to lead the way. Connecticut actually is of a size that we could lead the way on this, and I really appreciate your attention to this issue. We have an opportunity to do really amazing things that could spread to other states.
Thank you. Thank you, Mr. Chairman.
Thank you, Madam Co-Chair.
Thank you, Mr. Chair, and Senator Cohen, Dr. Moore. Thank you both for your advocacy. I'm really just here to say thank you, and I'm looking forward to actually working more closely with you than in the past couple months. So I'm hoping that we can also make progress, and also just to say thank you to all of the members of that working group. It's concerning to hear what you shared, that one of the members had a situation where they were concerned in any way about their employment status or their position. And we want people through this process, through a publicly appointed working group task force, to be able to help us understand what the issues are, which is also why we work with all of our stakeholders together as we talk about these issues. So thank you for your time with us and for all the time you've invested in this. Thanks, Mr. Chair.
Thank you. And I'll close with a quick little comment with Dr. Moore. When you get into something you don't leave it till you fix it. So, which is a pretty cool thing. And I bet your patients, if they see this quality in you, they know they will be taken good care of. And thank you for the work that you do in training the next generation of physicians for bedside ultrasound. You're like a top-notch trainer in the entire state. So thank you for that as well.
Thank you very much.
And thank you, Senator Cohen, for making sure that we do not change our focus.
Thank you. And I can attest to him not giving up because I sat on the Board of Ed with him and he saw projects all the way through, including late start times. We changed that in Guilford. So
Get 20 minutes from my kid.
yeah.
Thank you.
All right. Thank you.
Thank you. We'll move to the next person who is online, which is Jared Ross. Mr. Ross, you're on, followed by Senator Fazio.
Thank you to the chair and the members of the committee. Thank you for the opportunity to provide testimony in opposition to SB 7 today. My name is Dr. Jared Ross. I'm a board certified physician and senior fellow at Do No Harm Action, an organization that works to prevent discrimination in the provision and delivery of healthcare, as well as to protect children from harmful medical interventions. While I applaud the intent of SB 7 to prohibit discrimination by healthcare providers and facilities, I'm concerned that the bill mandates so-called gender-affirming care as the accepted standard of care in Connecticut. There is no domestic or international consensus on how to treat people, especially children, suffering from gender dysphoria. The so-called standards of care from the inappropriately named World Professional Organization for Transgender Health, WPATH, is highly problematic. Despite its name, WPATH is neither a worldwide monolithic consensus, nor is it professional, having inappropriately removed age restrictions from its guidelines under pressure from former U.S. government officials. The lack of professional conduct has further been illustrated by the WPATH files, a trove of internal documents leaked by Mia Hughes and Michael Schellenberger. WPATH is both ideologically captured and has significant financial conflicts of interest in creating lifelong gender medical patients. Organizations such as the Association of American Physicians and Surgeons, the American College of Pediatricians, and the American Society of Plastic Surgeons all oppose these interventions on children, as do the governments of the United Kingdom, Sweden, Finland, Belgium, Italy, Argentina, and 26 U.S. states. Several exhaustive systematic reviews of gender care for minors have all shown that the evidence for these treatments is very weak, yet WPATH ignores these robust studies, instead relying on methodologically flawed, low-quality survey data to support their predetermined conclusions. We know that most, if not all, of the children dealing with gender distress have underlying mental health challenges such as depression, anxiety, eating disorders, and autism. While these children most certainly need compassionate talk therapy to address these challenges, we must protect them from the horrors of so-called gender-affirming care. Again, there is no strong evidence supporting the use of medical interventions such as puberty blockers, cross-sex hormones, and surgical procedures to treat gender-distressed children. These irreversible procedures do nothing to address the underlying issue that these vulnerable children are facing. And several large studies in adults, including one released just last month, show higher rates of substance abuse, depression, and suicide after patients receive so-called gender-affirming surgery. We must ensure that children suffering from disabilities are not used as pawns to promote an ideological, anti-scientific medical agenda under the guise of preventing discrimination. Thank you.
Thank you, Dr. Ross. Dr. Ross, where is your organization based out of and where are you?
I am based out of Charleston, South Carolina, and Do No Harm Action is based out of the Washington, D.C. area. We work in all 50 states.
Thank you for that. And you're asserting that the bill is actually in some way requiring?
We're concerned that the bill mandates so-called gender-affirming care as the accepted standard of care for people struggling with gender dysphoria in Connecticut.
Can you point to a line reference where you see that in the bill?
I believe it's in the beginning of the bill. I will be happy to pull that reference and submit it via written testimony instead of taking the committee's time here.
Thank you. I think we see the bill differently. Senator Summers.
Yes, thank you for being here. Are we still here? Okay. I just had a couple questions. Dr. Ross, do you actually treat children that have gender dysphoria?
Yes, I work as an emergency medicine physician, and unfortunately, I see a lot of these children that are coming in crisis, suicidal, having cut themselves or harmed themselves, intentionally overdosed on medications. So this is a real challenge. These children clearly have underlying mental health issues, and instead, their parents and themselves are sold this bill that if they simply change their name, inject themselves full of drugs, and have surgery to chop off healthy body parts, that all of their mental health issues will go away. And that couldn't be further from the truth.
Okay. So one of the things that you referenced was you were concerned that this bill uses gender affirming care when somebody has gender dysphoria, excuse me. What is the standard of care for gender dysphoria? Is there a standard of care that has been accepted by the medical community? And also, could you repeat the organizations that you named? I know one of them was the plastic surgeons. Like who is against sort of this gender affirming care? Can you list those physicians again, those groups?
Yes, absolutely. There is no international consensus. We've seen a lot of unbiased research coming out of Europe. The US followed Europe down this rabbit hole starting in the 1990s and subsequently removed many of the safeguards and restrictions. Europe, despite keeping those safeguards in place, has realized that these procedures are not helpful and are harmful and has reversed course. Unfortunately, here in the US, ideologues have driven us further down that rabbit hole of performing more of these medications and procedures. The organizations here in the US that are against it are the Association of American Physicians and Surgeons, AAPS, the American College of Pediatricians, and the American Society of Plastic Surgeons.
And is there a standard of care that is accepted in the United States for treating children with gender dysphoria, or is there not a standard of care and every physician who treats these individuals treats them in their own individual way?
Yes, there is no unified consensus here. There is no standard of care. What WPATH, or the World Professional Organization for Transgender Health, puts forth as their so-called standard of care, it is neither a domestic nor an international consensus. And it is misleadingly named by an organization that has significant ideological and financial conflicts of interest.
Thank you for that. I have a couple more questions and I don't want to monopolize all the time, but this is an important subject. So I wanted to make sure that I'm clear and get your answers, being a physician who actually works with these children. I hear what you're saying as far as Europe. They're ahead of us on a lot of things, everything from recycling to maybe this. But you mentioned something that, and I don't know if I heard it right, that if you take puberty blockers, that they're not reversible. Can you describe what happens? You said the parents are, I think you used the word coerced into injecting their child or taking specific medications, thinking that if they do this, then their child will feel better. But if they go ahead with these drugs, or I'm assuming that, yeah, there are drugs. I don't know if they're injected or you take them by pills. I'm not exactly sure. Can you stop? Can you go back? I hear different things, that they are reversible, they're not reversible. Can you speak to that, please?
Yes, thank you for the question, Senator. The puberty blockers are injected medications. They can also be delivered as an implant that's placed in the body. These are often sold to parents misleadingly as being reversible and simply buying time for the child to figure things out. Unfortunately, we know that neither of those are the case. We know that parents are often told this suicide myth: would you rather have a living son or a dead daughter? And in fact, we know that that's not true. When the United Kingdom banned puberty blockers in gender distressed children, the suicide rate remained unchanged for these children. So we have good data to back that up, and we have additional studies out of both the Netherlands and Sweden looking at adults and seeing that adults have higher rates of suicide, much higher, up to 19 times higher, after receiving these so-called gender-affirming surgeries. With regards to puberty blockers themselves, we know that these stunt growth and hamper bone development, leading to osteoporosis. And there is a large body of evidence now showing that this decreases brain development, specifically in spatial reasoning and emotional processing. And so you've got children who are already suffering from mental illness, and you're giving them a medication that impairs their brain's ability to process emotion and regulate emotion. We also know that based on the study you look at, 97 to 100% of children that start on puberty blockers go on to take cross-sex hormones. So this is not simply a pause button. It is not reversible. This is sending them down a path of permanent harm, irreversible harm.
Okay, my last questions are, when did the UK ban the use of puberty blockers?
I will have to get you that exact reference, but I believe it was in 2022.
Okay, and would you be able to send us or send our clerk the copies of those studies from Sweden and the Netherlands? That would be helpful also.
Yes, I'll be happy to send over those studies showing the suicide risk.
Thank you very much.
Thank you.
Thank you, Senator Summers. Dr. Ross, you said you're an emergency department physician. Is that correct?
That's correct, yes.
Do you have a specialization in gender affirming care?
No, the specialization in gender affirming care is not board certified and has only existed for a few years now. There are actually competing specializations for that. Again, multiple physicians groups trying to monopolize that area, as it is seen to be highly profitable, given that these patients will be required to be on medications for the rest of their life and have multiple
Dr.
surgeries.
Ross, if I may ask my question a slightly different way. When you are practicing medicine in your capacity as a doctor, you treat people coming to the emergency room having experienced different emergencies of all backgrounds, all ages, whether or not they have experienced any gender affirming care, correct?
Correct. Yes, I treat all patients as based on an emergency on their definition as required by federal law.
So you are seeing patients who are coming in with different conditions, not necessarily specific to that. And are you aware that the first step in the gender affirming care process is to meet with a mental health provider?
That is not what's occurring today, and that is no longer the WPATH recommendations, as we've seen from the WPATH files, which were leaked by Michael Schellenberger's group. This is an affirmation, patient-guided buffet that we are running into. This is unlike anywhere else in medicine. The patient drives the treatment, and the doctor simply follows what the patient wants.
Thank you, Dr. Ross. Senator Elmore, back to you.
Thank you so much. I just need a yes and no question. So I do not necessarily want to expand too much. We've given you a fair amount of time. Dr. Ross, you have been very clear that you are against any form of diversity and equity and inclusion. Is that also included in the patients that you provide care to, or is just other aspects of life?
I believe in judging people by their merit, not by the color of their skin.
So how do you treat the patients then?
I treat each patient as an individual person addressing their acute needs.
Okay, well, thank you so much for your testimony. Rep Mara has a question.
Thank you so much, Mr. Chair. Thank you for your testimony today. I guess I'm just looking at this and kind of trying to figure out what exactly you don't like about it, or if there's something that we could add in that would be better. Because really what this is looking at is allowing for gender affirming healthcare and then protecting physicians or healthcare workers that are performing gender affirming healthcare. Do you believe that it should be maybe gender dysphoria? Is that what you think? And if we have, treating gender dysphoria, then that would be maybe better to have in the bill than just saying it's gender affirming, because in some cases, maybe if there was a true standard of care and you do go through mental health services, maybe it wouldn't be gender affirming, maybe it would be some sort of mental health treatment. Is that kind of where you're going with this?
Our concern is that the bill supports gender affirming care as the standard of care in Connecticut. And we believe that these children are suffering from mental illness, as has been shown by the data, and that instead of addressing those underlying mental illnesses, we are instead fast tracking them down irreversible procedures, medications, and procedures to obtain something that's not biologically possible. And that's this attempt to change sexes. So we are opposed to any children receiving so-called gender affirming care.
Okay, thank you so much. Thank you, Mr. Chair.
Thank you. Senator Gordon.
I'll be quick, Mr. Chairman. Thank you for testifying today. One question I have is you've cited the WPATH recommendations. I think their standard of care version is number 8. Is it your testimony, and correct me if I didn't hear it correctly or misunderstood it, that mental health is not considered part of standard of care in these types of situations, especially if we're dealing with children and adolescents? I just want to make sure I'm clear on what you said during your testimony.
Correct. This is a patient-guided process now. This is simply an affirmation model that the medical profession just provides. These ideologically captured physicians just simply provide whatever the patient wants. The issue that we have in multiple states is that physicians and/or mental health providers are shackled by state law to provide affirmation only, that under the guise of preventing so-called conversion therapy for homosexuality or bisexuality, that mental health providers are prevented from digging into these actual issues. We would never affirm an anorexic girl's body dysmorphia. We would never affirm someone who comes in and says, you know, I want to get divorced. Mental health professionals dig into the underlying issues and examine with the patient what's going on in the context of reality, and treat delusions and hallucinations as just that. They do not affirm those beliefs. Can you imagine if we affirmed anorexia? So that's the problem that we're facing here.
Well, thank you for your testimony. I just want to reference that if you read through the standard of care version 8 by WPATH in chapter 18, they have a whole chapter devoted to mental health and why it's considered one part of the standard of care, recognizing that there's multiple different types of standard of care that can be done at the same time. So I just want to clarify that. Thank you, Mr. Chairman.
Thank you so much, Senator Gordon. So, Dr. Ross, did you actually read this bill?
Yes, I did, sir.
Well, there's nothing in this bill that you're talking about, and that makes it quite interesting because the bill is not creating a standard of care. The bill is talking about emergency care and then also protections for the providers. So I know you're talking about your talking points, but I just want to make sure that you understand that the various statements that you have made about the bill are not in this bill. So, but thank you for your testimony. Seeing no other questions, we'll move to the next person on this list, which is Senator Fazio. You're on. Welcome.
Good afternoon, Chairs Anwar and McCarthy-Vahey and distinguished colleagues. I'm here to testify with regard to House Bill 1539 and to testify in strong support of rolling back certificate of need laws, which would, without a doubt, increase access to care, create healthcare jobs, and reduce the cost of new healthcare for families. Certificate of need laws are an extra and unreasonable permission slip from the government for the right to compete in an industry that doesn't exist almost anywhere else in the economy. CON is red tape that substantially increases the cost of entry into the market, reduces competition, reduces quality of patient services, and increases cost. The Obama-era Federal Trade Commission even said that by their very nature, CON laws create barriers to entry and expansion to the detriment of healthcare competition and consumers. Data has proven that states with CON laws see worse outcomes. A study of 128 studies of CON found overwhelmingly that CON laws do not benefit patients and residents. Only 11% of those 128 studies found that CON have a positive effect for patients, and the majority of the studies found that they had negative outcomes for consumers. One study found that repealing CON laws reduced healthcare costs by about 6% in states and increased the availability of hospital beds by 99 per 100,000 in the population. And the studies aren't even necessary to tell that story in Connecticut. Ask residents and patients in Greenwich or Danbury or Waterbury or elsewhere. They understand the unreasonable impediments that this imposes on healthcare. A recent study by the CT Mirror found that it takes an average of 378 days to get a CON approved for the establishment of a new healthcare service or facility in our state. That is absurd and ridiculous and impedes the creation of healthcare access, healthcare jobs, and innovation in our state. Even though the legislature and administration have not fully embraced reform, they have tacitly acknowledged its value. The governor rolled back CON under his emergency powers during COVID, and the legislature has recently, to their credit and to this committee's credit, passed legislation to roll back CON for birthing facilities and psychiatric facilities. I hope that this year we can come together to get something done in bipartisan fashion, even compromising on CON issues for facility closure, certain private equity investments, or consolidation. What I do know is that healthcare costs rank in the top 10 in Connecticut nationwide, and that this is only impeding affordability in healthcare, and that something needs to be done. So I strongly encourage all my good colleagues on this committee to try to get something done on CON reform this year.
Thank you so much for your testimony, Senator Fazio. So, and thank you for many of your proposals that we have looked at as well as a committee. And I think this bill that there's a public health committee bill on 1539 that you're supporting, it comes from a number of ideas, bipartisan ideas that we've all put our heads together and said, these are the things that are areas of opportunity. So we appreciate your support of that bill. Do you feel that the time has come for us to have a CON to restrict healthcare systems leaving areas?
I would be willing to, that's an area that I hear a lot of concern about, and I would be willing to compromise on it because I'd rather see progress be made than I get everything that I think should happen. Inevitably, I think if you have CON for the rollback or closures of certain facilities or services, it is going to dissuade people from investing in healthcare expansion in the state in the first place. If you have a money losing facility, a facility that isn't getting patients or revenue, then the inability to kind of dial back investment in that in favor of other areas of care that are seeing the need displayed by the population, that is going to, I think, reduce the overall investment in the healthcare space in Connecticut, the overall expansion of healthcare in Connecticut. So I think that excessive CON for closure or rollback of certain facilities would have that unintended consequence of reducing access statewide. But it's an area I hear a lot of concern about. And so it's an area that, I with members of this committee have offered compromise legislation on that keeps CON in place for the rollback of certain facilities while eliminating CON for the expansion of care.
So there's another question that's a philosophical issue that we as a committee deal with. There's a mindset which says that if you build a healthcare facility, more people will use it and the cost of healthcare will go up. And another view is that if there are not enough places and we restrict them, then less people will use and the cost will decrease. Can you expand on which mindset is right? And if the first one is right, which in our conversations, I believe it is, that we need to have increased access, but access means you're improving health care of the people. And then people are going for emergencies at that situation rather than getting a preventive health care. So that's part of the issue that we have to fight at times.
Yeah, I understand. And it's the most common argument I hear in defense of CON. I still think that generally speaking, the laws of supply and demand and competition mean that if you have increased competition, you have increased supply, that you're going to reduce prices and you're going to increase access for people. And in the states that have rolled back their certificate of need laws, including those cited in the 128 studies, the vast majority of those studies found that those basic laws of supply and demand are holding in those states. Where CON was rolled back, there was a decrease in costs. There was a decrease in aggregate spending too, at the same time that there was an increase in access. So, I get some of the argument. It's almost kind of like in the utility space where you have an industry that is so kind of government regulated. There is a high degree of taxpayer spending for every dollar spent. But at the same time, the basic premise that if you provide more competition, more supply, you're going to reduce costs still seems to hold in the healthcare space.
Thank you. Senator Gordon.
Thank you, Mr. Chairman. And Senator, it's good to see you. I know you and I have had many discussions and have been working together on what I consider a lot of common sense CON reform. And in general, I do believe that CON for expansion of many of the services, such as outpatient services, mental health, behavioral health, inpatient beds, is something we should be encouraging to have done and not necessarily have CON get in the way, because there's a lot of other codes and regulations that have to be followed anyway, including DPH and building and everything. But one of the things I do hear, and I hear this from various folks who work or run hospitals, is that if there is no CON for expansion of services and a private entity, so to speak, expands their services, that's competition, perhaps with a hospital that's in that demographic catch basement area, that they could then be, in a sense, outcompeted or unfairly competed against if, say, a private group takes private insurance and then more Medicaid patients, for example, go to a hospital that's nearby, given the issues with differences in reimbursements. Is that something that you've been hearing about? And I'm interested in what your thoughts are about that, because I've not necessarily really seen that to the degree that I think some people are raising alarm bells about.
Well, thank you for your question, Senator Gordon. I really appreciate your work on this topic. You and Senator Anwar, I think, have shown good leadership in trying to find bipartisan solutions on CON reform, and I hope that you'll continue to do so with success. I've heard that argument as well, and I think the evidence doesn't hold up. Our primary job as state policymakers isn't to protect private businesses from competition. It's to protect consumers and provide competition, especially when necessary. But again, the studies seem to show in states that have rolled back CON that the number of hospital facilities have increased, not decreased. So the argument that this will undercut hospitals hasn't been borne true in states that have expanded CON, because the number of hospitals have eliminated CON, because the number of hospitals in those states actually expanded after the CON was eliminated. Moreover, the ratio of Medicaid patients to all patients in those hospitals in states that remove their CON basically holds steady. So the idea that it'll just become all Medicaid in the hospitals and uncompensated care in the hospitals and private insurance elsewhere also hasn't seemed to hold. Finally, I would say it would be a very, very indirect, convoluted way of dealing with the issue of uncompensated care or Medicaid reimbursement rates to have a CON process where it takes 378 days on average to approve the expansion of a healthcare facility in the state. This is a very indirect and convoluted way of going about that issue. So I don't think the argument holds up well.
Thank you, Senator Fazio, and I appreciate your leadership in a bipartisan way on this big, important issue for our state. Thank you, Mr. Chairman.
Thank you. Representative Zupkus.
Thank you, Mr. Chair. Thank you, Senator, for coming. I know this has been a top item for you for a long time, and I have been very vocal on this committee about the CON process. I think, unfortunately, I missed the commissioner this morning. And I guess this is a comment versus a question to you, but I missed the commissioner this morning because I wanted to ask about the CON process. As you know, what's going on with the Waterbury and Johnson, like the hospitals right now. And I think perhaps this could have been solved years ago if it weren't for the delay in the CON process. And I find it interesting on this committee, there are times that the CON process is carved out where they don't have a CON process. One was the birthing centers.
Yep.
And the other one, we just voted on the injection sites. And so for somebody to go in and shoot up drugs, they don't need a CON, but a hospital does. And so I think we really need to think about what we're doing with the whole CON process. So I just wanted to say thank you for coming and continuing to fight for that. And please don't stop.
Yes, I'll be back here every year that they'll allow me. I like having the colloquy with the good members of this committee.
Hopefully it'll be done and you
Yeah,
won't have
hopefully
to
I don't
come
have
back.
to. You're right. You're right.
Thank you. Thank you, Mr. Chair.
Thank you. We'll find other reasons for you to be back here instead of this.
You can't force me.
Madam Co-Chair.
Thank you very much, Mr. Chair and Senator. Thank you for being here and for your interest in this topic. And I do just want to say, we hear you in terms of the concerns about timelines. I think that's a shared concern, both Senate and House. I've listened to some of the Senate debate and know that certainly that this is an issue that many of your House colleagues are also concerned about. We did hear earlier in testimony today that the median number of days of approval in the past year is down to 130. So we're seeing progress. I just wanted to share that with you because I know, as we often say here, as legislators, we're in lots of different places in the building. I also just wanted to comment and appreciate your remarks, which are you'd like to see some progress versus not having any. And I couldn't agree with you more about that statement. We spent many hours together on a bipartisan basis last year working with the Office of Health Strategy. There was a lot of communication back and forth, unlike what was reported in the press and stated in places. Perhaps some of that communication wasn't happening at different levels, but within the committee, we didn't get to a place, unfortunately, where we could see some results. So I am exactly in the same place as you. My hope is that we can be realistic, practical, but also extremely focused on the ability to make progress. So with all that preamble, as a comment, my question would be, the bill that we have before us today, the committee bill, as Senator Anwar said, was put together in an effort to look at some of those different bipartisan items that have come before us from both chambers, both parties, about what we would like to see. Without, having something collapse under its own weight, if you were able to add one or two things to this bill, knowing that eliminating CON is not on the table here today, but if you were adding one or two things to that bill, what would be what you would choose to add to it first that's not there today?
So I'll try to answer the spirit of the question, because I do think the fact that the legislature, this committee, has carved out or eliminated CON for establishing new facilities in certain parts of the healthcare space shows that would suggest to me that you should continue down that road. At least you should find other areas of the healthcare space where eliminating CON for expansion generates the most support and the least resistance. So I would say that's one. I think the idea of doing some sort of shot clock on CON approvals, while at the same time not allowing a disapproval to happen, T-1 day before that shot clock happens to expire, basically requiring that a certain kind of a certain amount of due diligence and substantiveness corresponds with that denial at the limitation, or at the point of the expiry of that timeline. That I think about that a lot, but having some sort of limitation on the timelines, while not allowing just a broad denial to happen for any reason, might be the type of reform that's reasonable. You mentioned that the wait time for the CON approvals has come down. I think in the Mirror study, it said that the average time was across the board over 200 days or around 200 days. So if it decreased, 2 months in a short period of time, without any real statutory change or statutory requirements, it almost begs the question at how I don't want to use too pejorative a term, but how arbitrary are these timelines in the first place? I mean, how necessary is it that we wait half a year to give approval or a full year for approval? So I do think dealing with the time would also be something that maybe could be done as a compromise, while not allowing the denial to just happen at the expiry of that timeline in a kind of just generic fashion.
I appreciate that. And I think some of the timelines are things that we limit via statute. So that's part of what we spent a good deal of time trying to get to last year, was how do we address any limitations from our end on the statutory level. But thank you for the conversation, and I look forward to continuing it with you.
Thank you, Representative. Thank you, Senator.
Thank you so much. With that, we come to the next person who is online, Kathleen Garrity. Welcome.
Thank you, Senator Anwar, Representative McCarthy-Vahey, and esteemed members of the Public Health Committee. My name is Kathleen Garrity, and I'm the Executive Director of the Connecticut State Dental Association. And I come before you today on behalf of the oral health care providers in our state and the patients we serve. While SB 7 is a robust bill that addresses many health concerns in our state, we respectfully urge inclusion of CSDA's proposed medical loss ratio into this bill. There are 5 different versions of this bill introduced this year, and this is the 3rd year we have sought this legislative initiative. We are grateful to Senator Looney for co-sponsoring all of those bills, as well as robust support from both the House and Senate, Democrats and Republicans on this measure. Indeed, there's been no public opposition to this initiative in the 3+ years we have sought its passage. Adding this provision to SB 7 would promote greater transparency and accountability in dental insurance. MLR standards have long applied to medical insurance. There is no reason dental coverage should be held to a lower standard of care. This would improve patient access to care and a consumer protection that is currently absent. Without dental insurance MLR, patients are paying more while receiving less care, often foregoing necessary, essential oral health treatments. Establishing an MLR standard would help correct this imbalance, ensuring fairer treatment for both patients and providers, and ultimately strengthening our state's dental care system. This initiative is also part of a broader national movement. States like Rhode Island, Massachusetts, and Louisiana have recently enacted dental medical loss ratio laws, and states like Washington and North Dakota are actively pursuing similar reforms right now. We have seen what can happen when transparency is put into place. In California, reporting requirements have revealed that some dental insurance plans are spending as little as 7% of premium dollars on actual patient care. Massachusetts, Nevada, and New Mexico have implemented similar policies with minimal additional expenditure by their insurance department. In fact, the systems in place at our insurance department here in Connecticut to cover MLR on the healthcare side are already capturing pediatric dental insurance information as it is covered by definition in the Affordable Care Act. Furthering the capture to include adult information as well is not a heavy lift. Being able to accomplish 85% medical loss ratio in the health insurance, which is a much bigger portion of the insurance portfolios than dental insurance, has been demonstrated by testimony proffered by insurance companies to the insurance department as part of their annual rate hike hearing. This proposed legislation will incentivize payer companies to increase the amount of premiums that are devoted to patient care. Any company that falls short of the 85% threshold will be mandated to return the missing portion back to those that purchased the premium, either individuals or small businesses that are offering dental insurance as an employee benefit. This is a critical component to ensure that patients receive the extra care that would be afforded to them under this legislation. Please note, this does not fix the whole system, but is a significant step towards the improvement, not only of patients' access to care, but to increase the care that they can have. This committee has heard extensively, even today, the need to keep non-emergency visits out of the emergency department.
Excuse me, Ms. Garrity, but you've reached your 3 minutes. Thank you.
Thank you. Ms. Garrity, I'm going to ask you a few questions and that'll allow you to clarify some things. My first question is, help us understand what medical loss ratio means at a 4th grade level.
I appreciate that. I thought that was Representative McCarthy-Vahey's line. I like how you share them. Medical loss ratio is basically a simple fraction, numerator and denominator. The denominator at the bottom is the entire dollar amount that a patient or a small business pays for a premium. So if it's $1,000, that's in your denominator. The top part is very clearly defined in our legislation to be only active patient care, the actual treatment of a patient. It does not include advertising, it does not include marketing, it does not include administrative costs, CEO bonuses, and that sort of thing. So the numerator over the denominator gives you our percentage. 85% is what is listed in our legislation.
Right. And the reason both Representative Kristen McCarthy-Vahey and I use the same language is we are in the same class. So we are 4th grade level. So
I don't buy that, but okay.
So the other question I wanted to ask you was, how is the cost of healthcare, dental healthcare, going to decrease to an average consumer if we were to pass a bill that you are proposing?
Well, the reality is, as we know, all the insurance has been going up every single year without providing any increased care. This bill would specifically provide increased care to our patients. So with oral health care, essential health care, when you kick a treatment plan that your dentist provides you down the road and say, I can't afford it, I'll try to do it next year, the problem does not go away, it gets worse. So that compounding problem is being addressed by this bill that allows the patient to not only contemplate the treatment plan that's being advised by their doctor, but actually implementing it. So what we're trying to do, as I was saying in my testimony, is stem those people that show up in the emergency department with oral pain, because our emergency department, first of all, is overwhelmed with true emergencies. And while oral pain is damaging to your psyche and probably keeps you out of going to work or school and other things, the reality is the preventative care and the restorative treatment that you've been prescribed by your dentist would prevent you from being in the emergency department in the beginning.
So the cost will decrease.
The overall comprehensive cost will absolutely decrease because people are getting increased care, yes.
And you're asking basically for transparency, if I understand you correctly. You're saying we need to know about what is the medical loss ratio in dental care.
right? That's currently a missing piece, and the part that makes it incentivizes the payer community to actually try to meet those goals is twofold. Number one is that obviously there's a rebate here that if they don't meet that goal, they have to return some of the premium money. But the second part of it is that, as we've seen in other states that have passed similar pieces of legislation, there's now a competition. There's a consumer protection piece that we don't have right now in Connecticut, which is that somebody can actually go, as you can on the exchange currently for health insurance, to see which plan is better. You're no longer just looking at a glossy brochure. You're actually looking at percentages about, okay, this one's going to put 80% back into my personal care, but this one's going to do 85% or 87%. And we've seen the development in markets already where that has happened, that has transpired. So that's the betterment of the patient, obviously.
Thank you so much. We appreciate your testimony and your advocacy on this important issue. Thank you.
Thank you, Senator.
The next person on our list is John Brady, who is here in person. Welcome, Mr. Brady. Good to see you again.
Good afternoon, Senator Anwar, Representative McCarthy-Vey, members of the committee. My name is John Brady. I am the Vice President of AFT Connecticut. I'm a registered nurse. We represent members in healthcare, education, and in public service. I have submitted testimony on 3 bills, and I'd like to just briefly touch on each one of them. The first one is HB 7050, which is the OHS's recommendations regarding certificate of needs. Specifically in section 2, the part that talks about the 180-day period and 2 years for cessation of services. This language is to fix a loophole that was put in place to fix another loophole. So a year or so ago, we changed it to 180 days because to define cessation of services, because some hospitals were saying we didn't stop services, we've just paused them. What has happened since then is some hospitals, and Wyndham Hospital is an example of that, they closed their progressive care unit, but they would reopen it on occasion so that they never got to the 180 days. Some of those reopenings were only for 1 shift. This would hopefully close that loophole. The next bill is SB 1539, also about certificate of needs. So in section 1, the part about private equity, I know we've passed already 2 bills out of committee on private equity, and I think they're good bills. We know that there's still going to be work on that language. I think this section, or at least the spirit of this section, should be kept in mind, because I think that any sale of a hospital that involves private equity should, at the very minimum, need a certificate of need if we don't outlaw it altogether. The other part is in section 2, lines 227 to 230, which deals with the 25 miles between hospitals for labor and delivery services. A couple of thoughts on that. 25 miles on an interstate is 25 minutes or less, but 25 miles on back roads is not. As an example, from Wyndham Hospital to Bacchus Hospital is 19 miles, but it's 29 minutes. From Johnson Memorial Hospital to Manchester is 20 miles, but it's 32 minutes. And from Sharon Hospital to Charlotte Hungerford is 25 miles, but it's 37 minutes. So my thought is that we should consider adding time into it, because time is more important than miles, maybe making it 25 miles or 25 minutes. So something to consider. The other thing that I thought about was what I call the cascading of distance. So right now, Johnson Memorial Hospital is 20 miles from Manchester Memorial. But if Manchester Memorial stopped labor and delivery services, and which they could because they're only 11 miles from Hartford, Johnson Memorial would end up being 29 miles and 35 minutes away from the nearest labor and delivery at either Hartford Hospital or St. Francis.
Excuse me, Mr. Brady, but you've reached your 3 minutes. Thank you.
I really want to hear to the end of this.
Okay.
Yeah.
So, I think we need to think about the spirit of it needs to, I think what we're looking for is that no labor and delivery service is more than a certain time distance from any pregnant woman or baby in the state. And if you'll indulge me, I'll be quick on the last one, SB 7, which is about the hospital administrators. Some hospitals used to be run by doctors and nurses and other health professionals, and that's not the case anymore, not necessarily. And some people that are running hospitals, administrating hospitals, do not have the clinical vision to see what the decisions they're making, how they affect patients. This bill would require some training and hold them accountable for the actions they do. And I even have a case in my testimony about what's happening at Bacchus with mandatory overtime. So thank you for listening, and I hope you can consider those thoughts.
Thank you, John, for your testimony. I'll start with the last part again. So, and the reason we put this in was that the reason a physician is licensed, a pharmacist is licensed, a nurse is licensed is because you are supposed to be held accountable. And if you are involved in malpractice, there should be consequences. And the malpractice would be defined as harming a patient in some respect. What we have seen in the last few years is that we have administrators for hospitals who are sitting in another state. California, Michigan, for Trinity, it's in Michigan, and for a Prospect, it was California. And they are making decisions which are harmful for the patients, some very dangerous. And we also have individuals who are no longer licensed, but were of healthcare background. They're actually starting to make clinical decisions which are not impacting one patient, hundreds of patients from their decision. And this new license category would hold them accountable for the ethics and understanding that there is a bigger responsibility that they have towards the human beings rather than another administrator on top of that administrator to satisfy them for their financial expectations or pushes that they're trying to make. So I appreciate you testifying in favor of this part. And I think this is other states are looking at this as well. And I know the nurses had requested me to look at this language because other states are looking at this because the nurses are the first line of defense and when healthcare is harming or being harmed.
Yeah, thank you for that. I think the state of Washington has a proposal at least. And I also, we deal with education also, and I think, we require superintendents to have certifications, and we can hold them accountable. I mean, it makes sense.
Thank you. Thank you for that. Your point about the distance being in time is well taken. Another thing, common sense, right? So I appreciate that part of the thought process too, because especially in the rural parts of our state, it's not a easy path. And then actually, and the other parts, if you're 95, if somebody's going to, on certain times of the day, 95 will not be 25 miles. It would take 2 hours for that 25 miles. So that's true. So Senator Gordon.
Thank you, Mr. Chairman. Thank you for testifying. I've read through your testimony and thank you for the work you do as a nurse and those you represent. I do have Johnson Memorial Hospital in my district up in Northeast Connecticut, and I can tell you I've tried to push the Office of Health Strategy when they went through the decision they ultimately made to allow the closure or the continued termination of inpatient labor and delivery services when they were looking just at distance. And I challenged them, including the commissioner, to actually go to Johnson Memorial, just not in good weather, but in the winter, and see how long it takes to actually get to the nearest hospital, even if you try to get into Massachusetts to do that. They have yet to take me up on that, but I'm happy to continue to publicly ask them to do that in their decision-making. Your point is very well taken about the time. Just because 25 minutes on 84 is probably less than, 25 miles is probably, based upon the average speed, 10 minutes. But when you're dealing with winding back roads that really have no street lights and the weather is bad and you're sick and needing to get to a place, that takes forever, literally, to do it safely. So I think that's a point very, very well taken. One question I do have for you is in some of the testimony that you've submitted, you've talked about issues relative to staffing, where hospitals may staff a unit or something for some time and then unstaff or staff for, you said, I think, a shift or not even for a whole day. Have you been seeing that as overall more and more of a trend with regards to what you and your colleagues are seeing with boots on the ground where the care is being provided, this on and off type of staffing, as opposed to just a continuous low staffing, but this intermittent staffing?
Yeah, well, both. We see low staffing too, but yes, I do, Senator. And the progressive care unit at Wyndham, that was the case. It seems to be, it seems to be when they are not sure they want to have that service anymore, or labor and delivery at Johnson was like that for a while. It would be open, it would be closed. They often blame it on lack of staff, lack of nurses, but we know you can get nurses if you're willing to pay nurses. And the financial part and the Medicaid and all that is another problem that we do have to deal with. It's a real problem, but they don't close the OR. They don't stop doing knee surgeries. They stop the services like labor and delivery and progressive care units and intensive care units. And they've been more and more doing it. And then we passed the bill of 180 days because they would say, we haven't stopped services, we just paused them. And we say, okay, if you pause them for 180 days, you've stopped them. And now they've found a workaround on that. I'm afraid if we pass this bill, what next workaround they'll find. I wish they could just live with the spirit of what we're trying to accomplish in the law. But if that was the case, we would have a lot less work to have to do as a regulatory.
Well, thank you. And I appreciated your written testimony and your testimony here today. Thank you, Mr. Chairman.
Thank you. Thank you so much for your testimony. Seeing no other comments or questions, we move to online. Jamie Reed. Welcome, Ms. Reed.
Thank you. And thank you for your time today. My name is Jamie Reed, and I am a whistleblower from a pediatric gender center. I hold a Master's of Science in Clinical Research, and I'm also the co-executive director of the LGB Courage Coalition, a national LGB advocacy organization. I am a lesbian and a Democrat. My testimony today is in opposition to Raise Bill number 7. This bill is making a grave error in tying two radically different medical interventions together. What we know so far regarding puberty blockers, cross-sex hormones, and surgery is that the international consensus is only strengthening that these interventions have low to no evidentiary support and are harmful. These practices have been scaled back and are ending in many nations. Connecticut would be enshrining into law through the use of fiscal dollars what will be considered in the next 5 years to have been grave life-altering mistakes. We have already seen lawsuits from real harms across the country, and these are only increasing. The American Academy of Pediatrics is currently being sued by young people who have been harmed by these procedures. And the American Surgical Association has reviewed these procedures and has concluded that the evidence does not support the continued use of these procedures. My organization understands these procedures, that giving young people puberty blockers, cross-sex hormones, and surgery is deeply homophobic. These procedures and these protocols were created and what was rooted in regressive stereotypes about how women and men should act and behave. Stereotypes that specifically target my community, young people who might grow up to be gay and lesbian, and also target vulnerable populations, those with autism, trauma histories, and serious mental health concerns. We urge Connecticut to cease tying reproductive health care to experimental procedures related to what we call gender. Tying this together only harms women and will end up harming your state. We urge you to review and remove lines 1057 through 1058 and ensure that all dollars that are going to be added to this fund are explicitly banned from being used in what's referred to as pediatric gender interventions. I worked inside this industry for nearly 5 years. I understand as an insider these procedures, and I have become a legally recognized whistleblower because this is an industry that is harming young people. I filed a formal affidavit with my state's attorney general. I provided evidence, and within 6 months, the centers in my states were closed. We advocate that all states remove their fiscal support for these interventions, as these are harmful and dangerous for all young people in the United States. I thank you for your time, and I'm open to any questions.
Thank you so much for your testimony. I appreciate your time today. Ms. Reed, where are you located and where is your organization based out of?
I am from St. Louis, Missouri. I was trained at the Washington University School of Medicine, and I currently run a national organization that represents lesbian, gays, and bisexuals across the United States.
So you're currently in Missouri?
Today, correct. I will be in New Hampshire tomorrow, but yes, I travel all over the United States.
Thank you. And how did you hear about this bill?
I have a legislative organization, the LGBT Courage Coalition. We actually run and work through bills all across the United States. I was in Montana 3 days ago. I'll be in New Hampshire tomorrow. We actually keep on our radar any and all bills that deal with pediatric gender, especially when it comes to states who have either sanctuary laws, do not currently have bans in place. So we advocate for bans in all 50 states. And this bill was brought to our attention because it is fiscally going to be putting in a slush fund, essentially, that your state will have monetary state level. Basically, you're enshrining that your state will be paying for something that we believe is harming young people.
And Ms. Reed, did you maybe you missed part of a conversation earlier on this topic? The state taxpayer fund is not going to be used for that. And I think the treasurer was here and we were clarifying that. But I appreciate your insight and that's helpful. And I think you're on the same page as we are, that the taxpayer money should not be used for the purpose that we have defined here. Perfect.
So we would just highly advocate that you remove those lines because your bill does specifically say that it will be performing and allowing fiscal for gender affirming healthcare services.
All right. So seeing no other questions or comments, we want to thank you for being here with us today.
Thank you.
That brings us to the next person on our list, Robert Miller. Welcome. Thank you for being with us today. Actually, why don't you sit down and turn the, now you can say that.
Okay.
Thank you.
Thank you, Senator Onwall and Representative McCarthy Vahey. My name is Robert Miller. I'm the Director of Health for the Eastern Highlands Health District and a member of the Advocacy Committee for the Connecticut Associations of Directors of Health, and I'm representing them today. The Connecticut Association of Directors of Health strongly opposes Section 2, subsection C1 of Raised Bill 7248 provisions that establish private well and semi-public well test results as confidential. The proposed changes in Raised Bill 7248 and previously passed changes in the statute seek to address concerns related to data accessibility. Unfortunately, these efforts fall woefully short of protecting health and ensuring access to information vital to that mission. Safety of water is something the public expects. Approximately 24% of Connecticut's population rely on private well for drinking. Groundwater contamination, whether natural or man-made, poses a significant public health concern in Connecticut, particularly in areas served by private wells. Providing residents and stakeholders with unfettered access to water quality information is an essential public health function, empowering property owners, neighbors, and communities to take action to protect themselves from contamination exposures. Data related to private water quality was readily available to the public for over 60 years. Over these years, local health departments have worked closely with stakeholders and communities on groundwater quality issues, addressing a wide range of contaminants, including currently sodium chloride and PFAS. There's no reasonable rationale for limiting access to this important environmental health data. It's our position that governmental public health's duty to inform significantly outweighs any de minimis right to privacy. With limiting access to such information, at least public health negligence, and at worst, public health malfeasance. For example, as one reads the current plain language of these provisions, the local director of health is required to obtain approval from the Commissioner of Public Health prior to disclosing drinking water lead test results from a private well to a resident family with a child who has been diagnosed with lead poisoning. This requirement stands in stark contrast to local director of health's ability without explicit approval from the commissioner to disclose the health information and identity of a sick restaurant worker to a restaurant manager. The lead scenario is one of many examples when there appears to be no justification for the additional layer of bureaucracy, which is currently affecting timely reporting of potentially additional exposures. In addition, the basic science of groundwater hydrology tells us that the presence of a single contaminated private well indicates risk to other nearby wells. Yet, under these current statutory provisions, neighbors whose wells are at risk would not be able to access critical information unless they meet specific and unreasonable conditions. These conditions include obtaining explicit approval from DPH commissioner and submitting a signed contract to purchase their neighbor's property. Furthermore, administrative burden and the number of legal questions created by these provisions and confronting local public health cannot be overstated. Prior to the establishment of this law, we routinely released and consulted on the data with a number of stakeholders for legitimate public health reasons.
Excuse me, Mr. Miller, but you've reached your 3 minutes. Thank you.
I'm going to ask you questions and you will
Sure.
be able to answer them. We truly value you being here and
Sure.
we value your insight.
Thank you.
If I heard you correctly, this bill 7248, it's talking about, so this is an area on well waters
Correct.
that has an overlap between deep and DPH.
There is, well, DEEP's involved because of investigations they oftenly engage in regarding groundwater contamination. Yes.
And DPH, because of course, if the water is not has contaminants, to your point, that is going to have a public health or the well-being of the person being impacted.
Correct.
So the bill is talking about the commissioner implementing policies and procedures necessary to administer provisions relating to cross connections between water supplies.
I believe there's a subsection below that identifies, and I have it right here, which identifies.
Section 2.
Right, Section 2, subsection C1 goes into broader, much more in-depth language about the conditions under which, or establishes well water data as confidential. That's reported to DPH and local public health, and then goes on to identify scenarios under which the data could be disclosed with commissioner's approval. That includes to the property owner, includes to the two individuals, or under circumstances in which the local health director has statutory and regulatory responsibility to disclose, state agencies, and DEEP. The DEEP provision, I believe, was the one most recently added under 7248.
Yeah. And if I understand you correctly, you're okay with the DEEP part and you're okay with part of it, but you have part of Section 2C1 are the areas that you have concerns about. Is that my fair understanding?
There are two specific areas in which we're concerned, Senator. One, the added layer of approval needed to get from the commissioner to disclose information in which technically, other than that, we're already obligated to under other statutory and regulatory obligations. The other piece of this is that that there are scenarios under which property owners in proximity to a contaminated well, under the current language in the statutes and under this raised bill, would have almost no access to this information, and then therefore would not be privy to any potential risks to their own wells, and then therefore potentially could result in additional exposures to contaminants.
Yeah, I hear you loud and clear. And I can also say that this is not the intent, but thank you for highlighting that. I think my co-chair has a comment or a question as well.
Sure.
Thank you, Mr. Chair. And Mr. Miller, thank you for being here and for the conversations that you have had on this. I just want to clarify testimony. The bill itself, the only change that it makes in that section is to add the Department of Energy and Environmental Protection. You are not opposed to adding the Department of Energy and Environmental Protection. Is that correct?
I would say no, we're not opposed to that. It's a bit redundant since state agencies are already in there, but sure.
I don't, I think you mentioned that, but in terms of those in the A, B, C, D, E.
I think it was just
it's
before.
an agent of a state agency and then it specifies.
Oh, as
and
a
it makes
agency as a
explicit.
whole, yes.
So I think we've had conversations with the Department of Public Health. I think your concern is actually a change that was made previously in the legislation, not this year, not being proposed. That is, just let me ask the question if I may. That is that now there is explicit approval of the commissioner of the Department of Public Health that is now required. That was
Correct.
not previously required, you said, for 60 years. Is that correct?
Correct.
Okay, so really what you're here today asking is that, if I'm hearing correctly and what conversations I've had before, is it's making sure that you don't have to go through that additional step in order to be able to provide the information that you believe will allow you to do your job as public health professionals. Is that correct?
May I elaborate on my answer?
Absolutely.
To answer your question directly, that is an important position, and that is an important, the answer to that fundamentally is yes. However, there's a layer above that that we are specifically concerned with. Even under the current language of the statute, there are individual property owners and residents in a neighborhood who would not be able to access this information under the current provisions, which would allow local public health to disclose the information. And I did provide one example of that in which if a neighbor wants to figure out what to test, or I'm sure I'm adding it now, if a neighbor wants to know what to test his water for, we routinely provide guidance. We'll look at your neighbor's water quality, but we can no longer do that now. Now property owners and neighbors in proximity to contaminated well appear to have no access to that information under the current provisions. So there's two layers there. One is that now that it's confidential, those interested parties which have clearly an interest in access to that data to protect their health and potential exposures no longer have any access to it. Second, yes, to answer your question directly, we feel like the added layer of getting commissioner's approval is wholly unnecessary.
Thank you for that. So really it's two things. One is the confidentiality piece,
Yep.
and then the second is the commissioner approval.
Correct.
Both. We have had some conversation with the Department of Public Health and made them aware of the conversations that I and others have had previously with health directors, including yourself, and I would like to continue this conversation. I think we're all aligned, certainly the commissioner and all of us here as the committee and all of you, in terms of making sure that our residents have the safest drinking water that they possibly can. And that's the number one goal that we all want to keep in mind, how we get there and how we communicate that, what kind of access people have when those are the questions that we're seeking to resolve. So I appreciate you taking the time to be here. I also just want to ask, have you submitted written testimony, or will you be submitting written testimony?
My organization, CADH, has submitted written testimony, yes.
And I think that's helpful and important to acknowledge. And I believe that's under Robert Rubo.
Correct.
And so that members of the committee are aware. So you are in line and aligned with the testimony in writing that he submitted.
Absolutely.
Wonderful. Thank you very much for being here with us today and for the time you've invested in this very important issue. Water is the source of life. So very important conversation. Thank you, Mr. Chair.
Thank you. Senator Gordon.
Thank you, Mr. Chairman. It's good to see you.
Good to
And
see
thank you for the work that you do. I know the work that the local health departments do is not always easy, but extremely important when it comes to trying to maintain as best as we can the safety for the public and the health of the public. So I appreciate it. I know very well the issues in some of my towns, especially Tolland, where we have salt contamination, and salt being one of the most water-loving substances there is, easily gets into the water supply and just blooms everywhere. And so I understand this issue well. In fact, myself, along with Rep. Nuccio and Rep. Ackert, and co-sponsored actually by Senator Rahman, did submit a bill this year, 254, that got to that point about trying to better allow this information to be known, especially when we're talking about if there's contamination in one lot, at one house, the risk goes up the closer you are to that lot, and over time the risk goes up farther you're away, just because of the blooming that happens horizontally when various contaminants get into the water supply. And I think those changes that you've been advocating for certainly are very, to me, very common sense from a public health point of view. But one of the things that I wanted to highlight, and correct me if I'm wrong in my thinking, is that you're looking at this not to necessarily divulge somebody's private information about all the details of what went on, at their house, but if there is a known contamination in the water supply, say affecting their private well or a semi-public well, that information is of utmost importance. Am I correct, from a public health point of view, especially to those who are already living nearby, or, for example, if someone wants to buy a house and move into the area, that might be important information for them to know, and could be factoring into their decision making as far as for their own health and the health of their family?
Correct. In fact, we would take the position that information on a private well should be public information for anybody who has an interest in the groundwater quality for that neighborhood to get access to.
And for example, when I built my house, I had an idea that there was arsenic in the water supply, just because you can look at the maps and have a rough idea. But I actually got information and was able to see that, yes, in the surrounding neighborhoods, some of that had already been reported, even though it wasn't mandatory to test. So I wasn't surprised when I tested that I found it above what the feds say is a safe level. And of course, we then didn't stop me from building the house in that location, but it did factor in that I needed to do something. Now I know about that, and that's helpful to know. So those types of things do matter, especially when we're talking about people moving in, and is their water potable, especially for young kids. That's a big concern. So I appreciate you continuing to raise this. Thank you, and happy to work with the chairs on this. I think it's something that should be an easy enough thing to us to drill down to see what we can do to help public health, just not in your part of the state, but other parts of the state where we know there's various types of contaminations that get into the water supply. So thank you for testifying and raising this.
Thank you.
Thank you, Mr. Chairman.
Thank you. Seeing no other comments or questions, we appreciate you being here today.
Thank you so much, co-chairs and members of the committee.
Thank you. That brings us to the next person who is remote, Ms. Mona Caldwell. Welcome, Ms. Caldwell. You're on.
Thank you. Thank you, honorable members of the Public Health Committee. My name is Mona Caldwell, and I'm a resident of Connecticut, speaking in opposition to SB 7, an act concerning protections for access to health care and the equitable delivery of healthcare services in the state. While this bill purports to ensure equitable healthcare access, it embeds protections for irreversible gender-affirming procedures on children, practices that I consider gender mutilation on children and believe should be classified at a minimum as a Class D felony. I urge you to reject this legislation and prioritize the safety of our state's minors. Connecticut's laws already protect children from harm. State Statute 5320 makes cruelty to children under 16, including endangering their health, a Class D felony with up to 5 years in prison. State Statute 5321 deems acts likely to impair a child's health or morals a felony, escalating to a Class B felony if serious injury occurs. Gender-affirming care, such as hormone treatments and surgeries that permanently alter a minor's healthy body, constitute such harm. Research from the American College of Pediatrics and European studies show that many children with gender dysphoria resolve these feelings naturally by adulthood without invasive procedures. Minors are unable to fully consent due to their age, and they suffer irreversible damage, precisely what these statutes aim to prevent. Section 4B prohibits healthcare entities from limiting providers' ability to offer gender-affirming healthcare services defined in Section 52571N as all medical care for gender dysphoria and gender incongruence. This includes hormone treatments and surgeries that permanently alter a child's healthy body, interventions minors cannot fully consent to due to their developmental stage that under 5321 should be investigated as risking a child's health. Section 4C3 further protects providers from discipline for performing these procedures in emergencies, even if long-term harm ensues, weakening the accountability required by 5320. Section 19 establishes the safe harbor account funding healthcare providers and nonprofits that provide gender-affirming care and cover collateral costs for out-of-state patients. This incentivizes bringing children to Connecticut for these irreversible procedures, turning our state into a hub for what I view as gender mutilation. By defining qualified persons as residents of restrictive states, this section prioritizes ideology over child welfare, using taxpayer dollars to support practices that should instead face legal consequences. The broader bill covering fluoride in water, hospital facility fees, emergency services, and healthcare administrator licensure may seem unrelated, but it's a framework that entrenches a healthcare system that facilitates these procedures under the guise of access. For instance,
Caldwell, but you've reached your 3 minutes. Thank
okay.
you.
I urge you to reject SB 7. Thank you for your time, and I will take any questions.
Thank you so much. We appreciate you taking the time and being with us and testifying. You have a written testimony too, Ms. Caldwell?
I do.
Okay, we appreciate that. And seeing no questions or comments, thank you again for lending your voice to the issues.
Thank you.
Is Dr. Adam Kay. Dr. Kay, you're on.
Thank you, Senator Anwar, Representative McCarthy-Vahey, and members of the Public Health Committee. The Radiology Society of Connecticut would like to offer comments for the record on House Bill 7050, an act concerning the Office of Health Strategies recommendations regarding the Certificate in Need program. As always, we have appreciated our dialogue with you on this issue and our continued dialogue on it. We would like to focus our comments on Section 5, which creates an expedited Certificate in Need process for the acquisition of imaging equipment that includes CT and MRI scanners. RSC would like to reiterate that as radiologists, we do not order an imaging study. That's done by the patient's physician or prescribing professional. We believe it's critical that a CON process remain in place for this equipment. Otherwise, you would see an immediate migration of the units to affluent areas of the state with a high proportion of self-pay patients. The CON law plays a key role in assuring access to CT and MRI scanners throughout the state. The RSC can be supportive of wants to be supportive of an expedited process. We believe, however, that this must include the ability of an affected stakeholder to request a hearing on the issue of whether or not an individual project qualifies to be expected prior to OHS issuing a decision. We have provided suggested text to alter this to provide a needed guardrail. If such language or something similar is included in Section 5, RSC will support an expedited CON process for imaging equipment, and we look forward to being included on future discussions about the CON proposals, and thank the committee for considering the views of the RSC on this matter. I'm happy to take questions.
Thank you so much, Dr. Kay, for your testimony. Seeing no questions or comments, we will move to the next person on our list. That is Margaret Watt. Ms. Watt, you're on. Welcome.
Thank you. Good afternoon, Senator Anwar, Rep. McCarthy-Vahey, and distinguished members of the committee. I am the Prevention Director at Positive Directions, a regional nonprofit based in Westport, and I'm also the Public Policy Chair of NAMI Connecticut. I'm here to comment on Sections 22 and 23 of SB 7, which would invest $3.6 million in a pilot project to use technology to provide students with behavioral health education, counseling, and peer support online. I strongly support investments in children's behavioral health. As we all know, mental health and substance use challenges first appear during middle school, so anything we can do. I appreciate this bill's innovation of using geofencing to reach students and connect them to vetted services. We know that young people use social media like TikTok to talk about mental health, so it makes sense to use online targeting to reach youth with accurate information about warning signs, coping skills, and how to help a friend. One aspect of this bill would use technology such as a chat room to connect youth to online peer-to-peer support. So I'm happy to tell you that this concept is already underway through the brand new Connecticut Support Group project, which I direct. The CT Support Group is a DEMAS-funded project, literally just launched, to provide an online mental wellness platform where young people in Connecticut can make connections, find and provide peer support, and build community. The project represents an evolution of turningpointct.org, which provided online mental health information and resources that were created by our young people for their peers. This new project will go beyond, allowing young people in the state to find out about and directly access trained peer support, primarily via a Discord server. Discord is a popular technology platform where people can connect using voice, video, or text. Our project's Discord server will be a virtual community with multiple channels. Some of the channels will allow young people to just connect with others and build their own communities. One channel exists specifically to allow young people to access high-quality peer support provided by a trained young adult peer support specialist during drop-in hours. Now, most young people and most school staff don't know that peer support specialists even exist, let alone that a teen might be able to meet virtually with a young adult who not only offers the empathy of lived experience, but also the expertise that comes from being trained as a recovery support specialist or a recovery coach, or who's a trained facilitator for a NAMI young adult support group or a smart recovery teen group. These are all existing peer supports in our state, right? That this is an opportunity to connect people to. So our CT support group is going to serve as a clearinghouse for young people to access these people and programs. But there are a couple of barriers. First of all, most of the current peer support programs in the state, even if they're run by young adults, only offer peer support starting at age 18. This bill, it seems like, would be targeting younger than that. Secondly, our project funding is currently only sufficient for one RSS, one recovery support specialist, to staff our drop-in hours. So our project is in its infancy, but with support, it really has the potential to serve the purpose identified in SB 7 to connect young people online, provide peer support, and peer support that's not just their own age peers, but also trained peer support. So I wanted to share that. I know my time's up. My written testimony concludes with a paragraph about the online counseling parts of the bill. Thank you.
Thank you so much, Ms. Watt, for your testimony. Can I ask you, how long have you been doing this work?
Well, I've been in behavioral health since 2012 in various regional leadership positions. Our Turning Point CT project actually just ended its 10th year, having served over 1/3 young people in Connecticut with peer-provided, peer-developed resources. And when that happened last year, so that's all done by young people, teens and young adults in the state. I happen to be the only old person involved with it as the project director. When that project concluded its 10th year, we did a statewide needs assessment to ask young people what should be the evolution of this project. And this is what they wanted. Direct peer support through Discord, just a sort of revised platform. We do have young adults associated with all the different peer programs in the state that are on the project advisory board, NAMI, Smart Recoveries, the Warm Line, et cetera. And I think there's just a huge amount of potential here.
Thank you. And your peer guides, can you tell me a little bit what kind of training do they get?
Okay, so the person who is currently our project manager for this is Quinn Giannetti. They are trained as a recovery support specialist. They are also trained in intentional peer support, and they are trained as an alternatives to suicide facilitator. So they really have a huge amount of background in this. They've also, prior to working with us, done peer support in the LGBTQ community. And they really have a lot of personal lived experience and a lot of expertise to offer. Part of what goes into this whole process is how is it moderated? What are the resources? What are all the connections? Because the goal would be, if there's online peer support, you want to make sure people's needs are taken care of. So when I saw this part of the bill of SB 7, it seems like a great idea to have youth being able to connect with each other in a moderated online chat. And they can support one another, but also there's this other level of, you can support another peer, but not know what the resources are and how to really help them. And you may be struggling yourself. So I think this would bring an added level.
Thank you so much. Are you guys publishing your data?
Not for a long time. We've been at a couple of national conferences. This new evolution of the project, when I say it's new, I mean it's brand new. The Discord only has 43 people in it so far. So we're having an advisory group meeting tomorrow. So this is literally brand new.
Excellent. Thank you so much. My co-chair also has a question or comment. Madam Co-chair.
Thank you very much, Mr. Chair. Margaret, it is wonderful to see you here. And I just wanted to say thank you so much for the work that you've done for so many years previously with the Southwest Regional Mental Health Board. And now at Positive Directions, you are a champion in our state. And having you be here to testify about this is really helpful to us as we move forward with this work. And we know we're going to want to stay in conversation with you about this and so many other issues. But you mentioned one thing that was in your testimony that you didn't get to share, and I wondered if you could share that with us too.
Oh, sure. Just that the other, the one piece of this bill is to invest a significant amount of money, a relatively significant amount in youth behavioral health and sort of doing it as a pilot where it's all online. And so the part where it would connect youth to online counseling services, I just kind of mused about it because I thought it would be helpful if that investment were somewhat customizable in the priority school districts that it's targeted for. And I listed two reasons. I'm down here in Region 1. In Region 1, a lot of districts contract with kids in crisis. So they have a teen talk counselor located in the schools, which is a trusted adult, right? Like live in-person connection. Teen Talk, that counselor provides screening, provides crisis counseling, gathers a lot of data, but really knows the local provider community in a way that an online counselor that might be in another part of the state wouldn't. And so can do the warm handoffs and has a 24/7 helpline and has a trauma-informed shelter. So I was looking at that and thinking, boy, in an ideal world, every school would have that person. The other piece that I mentioned is that I do surveys in our towns. And so Norwalk, we've been surveying every 2 years since 2018. And our depression rates were super high after COVID, like everywhere. And the depression rates have been cut in half in our youth, according to our most recent survey, which was November of this year. And one of the reasons is that the school district has partnered with the community in a really intensive way to have embedded counselors from all these community partners and provide training, LGBT competency training, all kinds of different provisions and services, many of which are now going away because they were ARPA funded. So there was part of me that just looks at this and goes, oh, we giveth and we taketh away. Some of the good stuff might disappear and be replaced by online services. Is there an ability to say to these priority school districts, I think there's only 15, here's your couple 100,000, do some online stuff, but if you have something that's working, maybe you can sustain it.
That is incredibly helpful, and I'm hoping that the two of us and in our region and perhaps with Representative Leeper over there in the Education Committee can talk a little bit more about this because, as you know, all these systems are connected, and the bottom line is how are we best providing care, support, and treatment for our kids. Thank you for all that you do, Margaret. Thanks, Mr. Chair.
Thank you.
Seeing no other questions or comments, we move to the next person on our list, which is Betsy Guerra. Welcome, Ms. Guerra.
Thank you, Senator Anwar, Representative McCarthy-Vahey, members of the committee. My name is Elizabeth Guerra. I'm the Executive Director of the Connecticut Waterworks Association, which is a trade association of municipal, private, and regional water utilities serving customers throughout Connecticut. And I want to thank the committee for raising House Bill 7248, particularly Section 1, which includes provisions authorizing the Connecticut Department of Public Health to move forward to address some issues relating to cross connections. So cross connections, as you may or may not know, are an actual or potential physical connection between a public water supply system and another non-potable liquid, solid, or gas that could end up contaminating the public water supplies. And so it's something that our water utilities take very seriously. We are required to conduct annual cross-connection surveys to ensure that there are protections in place to prevent that contamination. And we have been working with the Department of Public Health for a number of years in updating a manual to provide guidance to water systems in doing cross-connection surveys and also on the regulations. So there have been some conversations about the need to update that manual and the regulations. And this Section 1 of the bill simply provides that DPH can proceed with the implementation of policies and procedures necessary to make some of these changes until regulations can be put in place. So it ensures that we can move ahead faster to protect the water quality. So it's a very minor issue, a small issue, but it will have a big impact on water quality. So again, I thank the committee for raising the bill, and I'm happy to answer any questions.
Thank you so much, Ms. Guerra. Were you able to have an opportunity to listen to one of the local health department person who had spoken about concerns?
I did. I believe his concerns were confined to Section 2 of the bill. And I do think it makes sense to add the State Department of Energy and Environmental Protection to the entities that receive information. Certainly, they're working in tandem with the Connecticut Department of Public Health Drinking Water section in looking at issues such as PFAS contamination or contamination of wells from other things such as uranium or road salt. And so, again, it certainly makes sense that they have that information.
Right. And I think the concern that he was specifically raising may have been from an older legislation rather than the current changes that are being suggested.
Exactly. I believe the issues he was raising was in reference to existing statute, not the underlying bill.
But it was worthwhile because that may allow us to have a conversation with DPH to understand, make sure that those issues are addressed too. So seeing no questions or comments, we will move to the next person on our list. We thank you for your testimony and your work.
Thank you.
Dr. Dan Fries. Welcome, Dr. Fries.
Well, thank you. Great to give testimony to this committee again, and thank you for all the committee members who are both there in person and on Zoom today. Again, my name is Daniel Fries. I'm an emergency physician in Hartford and a resident of West Hartford. I'm the legislative chair currently for the Connecticut College of Emergency Physicians, and I was actually one of the committee members on the boarding and crowding task force that I would like to say completed our work, but work never ends, on the boarding and crowding task force this last year. I want to give testimony mostly on SB 1538, but also a little bit on SB 7. 1538, calling for expedited conservatorship for emergency patients. While a great idea, I speak for many of the committee members, and I would defer to a lot of the testimony of Chris Moore earlier, who chaired that committee, is probably just a little bit insufficient based on the needs at hand regarding boarding and crowding in this state. I would reiterate that it's not so much crowding we're worried about, and it's not input or people that don't need to be in the emergency department, but rather the difficulties in getting people out of the emergency department. Again, we do support the expedited conservatorship ideas, but would also like to see increased state quality metrics based on boarding, increased Medicaid funding, which is a separate bill, as well as work toward improved pre-authorization and limits to delayed pre-authorization to get people out of the emergency department when their time is completed. Finally, there are a couple other bills related to this, calling for caps on nursing ratios and even physician ratios to patients, which may be beneficial in some sense, but can be very disastrous to boarding and crowding, increasing both of those things. So basically, our testimony is that we are in support of this bill, but would hope to see more, either this legislative session or the next. And again, I would defer to Chris Moore, who gave earlier testimony to this effect. Secondly, on SB 7, Connecticut College of Emergency Physicians is very much in support of EMTALA. That is what we do. I'm not sure necessarily the importance of codifying it on the state level, because as long as the state doesn't pass any bills going against it, the national federal statutes still stand in Connecticut. So we do abide by everything, more or less everything being called for in this legislation already based on federal requirements. We do want to point out that EMTALA, as always, is an unfunded mandate. Thus making some of the things discussed earlier even more important in terms of Medicaid funding, not capping Medicare funding, not capping negotiations with insurance companies on out-of-network care, and allowing emergency physicians and hospitals in general to recoup the amount of money they need to keep emergency departments open. Whether it's talked about a lot or not, emergency departments across the country are strained financially, and many are even closing, including in Connecticut, where there are some that are very much at risk.
Excuse me, Dr. Freese, your 3 minutes is up. Thank you.
I will defer to you guys if you have any questions, but thank you for the testimony.
Thank you so much. Thank you so much for your testimony, Dr. Freese, and thank you for serving in that committee. I know hundreds of hours of volunteer time has been spent to try and address this complex issue. And we look at this issue as a journey and a process, and we'll probably have to continue to look at various ways to address this in the next many sessions, but completely agree with you that the current bill in the current form that you're testifying on is not enough. And this was just to get you all to come and testify so that we can improve on it. So I think you're successful in that.
Thank you.
So I don't see any questions or comments. So I appreciate you being here and thank you for your time.
Thank you.
And that brings us to Anna Montalvo, who's not here. And that's next is Mr. Burrell, who's here in person. Welcome, Mr. Burrell, and thank you for being here with us this morning, afternoon, hopefully not evening.
Okay, my name's Tom Barrow, and I'm here in opposition to Committee Bill number 7. Though I have been a respiratory therapist for 32 years, I'm not here in any capacity as a medical professional. I'm here as a man of God who fears God, who loves God, and who keeps God's commandments. I'm here to make God the issue and let you know from him the consequences of what you are proposing. Using taxpayer money in support of abortion and mutilation of children, and creating our state as a sanctuary for these egregious sins against God. Earlier, the chair inferred that the historic values of Connecticut are pro-abortion and pro-transitioning minors. I can assure you that Connecticut has a much, much longer history as a pro-life state and a solid understanding that there are only 2 genders. But you are breaking apart what's left of the spiritual fabric and the mystic cords that have bound our state together for almost 400 years. You have sponsored this bill and co-sponsored this bill, and you who are supporting this bill have no idea of the spiritual damage you are creating in the state of Connecticut. But the devils who are inspiring you, they know, and they are delighted. I am here to let you know you are violating God's laws, violating God's innocence, and you are violating God's marriage love. You are in big trouble with God. I know this sounds insane to your hard and impenitent hearts, but I'm not here to appeal to you or for you to agree with me or to repent. It's far too late for that. At this point, it would be better, as Jesus said, to tie a millstone around your neck and cast yourself into the sea than continue your vile assault against the innocent. In this life, God gives us a choice. He sets before us life and death. Your support for this bill is a witness that you have chosen death. We all have an appointed time to leave this earth and give an account for what we have done with the life, the gifts, and the abilities that God has given us. In that day, when your judgment is pronounced, there will be no safe harbor. Hell will open before you, and you will scream with terror and horror. Why didn't somebody tell me? Why didn't somebody warn me? The angels will respond, someone did. Consider yourselves warned. It is a fearful thing to fall into the hands of the living God.
Thank you so much for your testimony and thank you for being here with us. We appreciate your time and your words. Next person on our list is Carrie Moss. Yeah, sorry. We were looking for you in person, but go ahead, Ms. Moss. Dr.
Sorry.
Sorry, I had to come back to the hospital. Senator Anwar, Representative McCarthy-Vahey, and members of the legislature's Public Health Committee, thank you for the opportunity to share my support for SB 1540, an act implementing the recommendations of the Pediatric Hospice Working Group. My name is Carrie Moss, and I'm a board-certified pediatric hematologist and oncologist and board-certified hospice and palliative care physician. I'm the founder and serve as the current medical director of Connecticut Children's Palliative Care Program, the Sunflower Kids. Additionally, I serve as the appointed pediatric representative on the legislatively mandated DPH Statewide Palliative Care Advisory Council and serve as the co-chair of the current working group task force for pediatric palliative care and hospice services. Before commenting further on this bill, I would like to share a bit with you about our hospital. Connecticut Children's is nationally recognized. We are a 205-bed, not-for-profit children's health system driving innovation in pediatrics. With over 3,200 employees and more than 1,300 pediatric experts on our medical staff, we are the only health system in the state dedicated exclusively to the care of children. Over the past 6 months, through the pleasure of working on the working group, we met 9 times in core and sub-working group forums to identify the key challenges and review and interpret existing state data. Dedicated state resources were surveyed to assess patient volumes and related needs and to identify the barriers and limitations currently impeding the delivery of hospice care to children in Connecticut. The defining goal of this committee has been to identify best practice and to in turn to propose the development of a statewide program that will offer pediatric patients throughout Connecticut palliative and hospice services. Although there remains much work to be done, this is an inspiring start and the foundation from which a true best practice can grow. We've made significant progress since we were last in this very room together. On a more personal note, I am submitting testimony in support of this bill because I remain truly grateful to the state of Connecticut for prioritizing pediatric palliative care and hospice for our most valuable and vulnerable population. I'm truly grateful that these recommendations are being considered on behalf of the patients and families I continue to have the honor to serve every day. Unlike adults with terminal illness, children do not receive the same access to hospice and related end-of-life support services. In fact, as the data shows, there is not a single agency that provides services exclusively for children, and most adult agencies lack both the expertise and comfort in doing so. Depending on town, agency availability, pediatric comfort in taking care of these patients, certification and timing, our fragmented services come from piecemealing what we can and more often than not, what we can't, accepting when we simply cannot provide this service for patients in their home. Families are then faced with the challenge of deciding between a hospital-based passing or being at home with only the remote support potentially of our Sunflower Kids team. The reality that children die in the hospital because we are unable to provide them with the appropriate home services remains unconscionable. We can do better, and we need to do better for these children and their families. There is no greater tragedy than the loss of a child, and sadly, losing a child without hospice and end-of-life support has become a normal occurrence here in Connecticut. Creating a hospice program for children will allow our patients and families to receive developmentally appropriate support and services, including bereavement support for the devastated parents and siblings that are left to carry on their legacy. Ensuring the words of a former patient, the value and imperative needs for this service are simply truly clear. With the help of
Ms. Moss, you have reached your 3 minutes. Thank you.
Thank you, Dr. Moss. I'm just going to ask you a couple of questions. I wanted to first thank you for your work that you have done in raising awareness on this issue and being part of the solution going forward. It was quite painful to know that we do not have a hospice program for children in our state. And then hopefully with this bill, we are hoping to be able to address that area. Would you be able to speak about the parts of the bill that you think are essential if there is a financial limitation of any kind, which would be the few things that you feel are necessary that we should be working on?
I think first and foremost, we need to be able to provide a reach to the homes of these patients and the ability to care for children in the home. So whether that means skilled nursing visits in the set of continuing on with the current home services they receive, I think we need to be able to get into the homes and take care of patients first and foremost. I think there's many ways of doing that. I think the most important thing is by communicating who in the state is able to do this. And I think that the proposal that we've been working on suggests that we look at a statewide initiative that would allow there to be a central repository for these services, and through a best practice, be able to start with one group, allowing services to be spread throughout the state and therefore allowing all patients to receive the benefits of palliative and hospice care services in the home.
Thank you.
That is probably our greatest priority.
Thank you. We appreciate that. My co-chair also has a question.
Dr. Moss, I just wanted to say thank you for the time and attention that you and others who I know we will hear from later, who are here in the room with us, have put into this work, and for the care and thoughtfulness that you give both to your patients, but to the recommendations and the committee that has put this forward. So we know that we, as Senator Amor alluded to, are unlikely to be able to take all the steps we might like to take this year, but this is work that will continue, and we're grateful to have you helping us lead this work. Thank you, Mr. Chair.
Thank you. Senator Gordon.
Thank you, Mr. Chairman. And Dr. Morse, thank you for your testimony and the work you do. I'm actually also a HEMONC doctor, but I take care of adults. So I'm very used to dealing with hospice services, of which we have a lot of good access for adults. I don't take care of children, anyone less than 18, but it certainly is quite interesting to have learned through this whole process the limited capability, especially at home, for a large number of kids who, unfortunately, along with their families, are facing a hospice care. So I certainly would look forward to seeing what more can be done here in Connecticut for that. And I certainly understand quite well hospice and palliative care. Actually, when I trained, it was before it was a certification, a board certification, but I nevertheless trained for hospice and palliative care. A question I have for you, are there any states or a particular state that you can cite that you think is a good example for us to look at, that you feel is doing things quote unquote well, or has a good setup that we might be able to learn from as a legislature and what we can do here in Connecticut?
So I think that's an excellent question, and I appreciate you asking it. I think we have to look no further than our neighbors in Massachusetts to to see the program that they developed and how they had come from a smaller program and now have a $10 million budget for their pediatric hospice services. I think it would be a great opportunity for us to look to them. We have done that, and we have worked with them, but I think the model that they are providing in Massachusetts is one of the best that is currently still available throughout the country. So that would be where I would recommend going first.
No, thank you. And certainly number one state in my mind is always Connecticut. But I'm also licensed to practice in the Commonwealth of Mass, and I was born there. So it's my second favorite state. And they do have some good services that they do through the various pediatric HEMOC programs that they have through a number of their big hospital systems. So we can certainly learn a lot from them. But thank you for the work you and others are doing. It's appreciated. Thank you, Mr. Chairman.
Thank you. Seeing no other questions or comments, Dr. Moss, thank you for your service. We will talk to you again soon, more depth.
Thank you for having me.
Thank you. Next on our list is Deborah Barrell. Welcome. You're on.
Thank you. Thank you for allowing me this time to testify. My name is Deborah Barrell, and I'm here to oppose SB 7, especially sections 19 and section 27. As I read the portions of this bill of 46 pages, I see that there are some parts in it that will help the public health and residents in Connecticut. But I also notice that you use many different terms for money accounts. Section 19 states the account shall contain any monies required by law to be deposited in the account of any funds received from any public or private contributions, gifts, grants, donations, bequests, or devices to the account. Why should funds be given to the government? I don't understand why there should be a safe harbor account created by a state institution to support and to collect private and public funds, gifts, grants, donations, etc., for reproductive care, abortions, gender-affirming health care, mutilating children, and nonprofit organizations that serve LGBTQ plus youth and families, and to support out-of-state citizens. If this is done by state employees, the Treasury Department, aren't they paid by taxpayers? You're saying there's no taxpayer funds used for this, but there is. People are getting paid to pay attention to this. Right today, you're listening to this, so you're getting paid for it. If anyone wants to give their money to these organizations, the state does not need to be involved. I personally am abhorred by Connecticut's obsession with killing babies and mutilating children. God created us to come into this world as babies and to grow in a loving, caring family and to learn how to live happy, useful lives from a family and community. Why can't Connecticut encourage godly values? This Connecticut government is hell-bent on making sure that doesn't happen here. You are serving the wrong God. The lady that just testified, give $30 million of what's in section 27 or whatever. Give that $30 million for the hospice care for children. I worked for Connecticut Children's for 13 years, and I saw babies die because I worked in the NICU and families. They need help, but you don't need to abort babies. You don't need to mutilate children. Help the children that need help. It's amazing to me how unhappy people are that promote abortions and want to mutilate children. I would think there are more important things also for Connecticut to spend money on. Nursing homes. You need nursing homes as much. They have been closed. Helping the hospitals that we heard testify today, they are overcrowded. You know, helping the mental health care and the homeless and get rid of the drug and opioid crisis that stated in Section 20. God is very much alive and sees what Connecticut lawmakers are doing every moment of every day. And one day you will see your life works on a big screen in the spirit world and be given judgment that fits your life works, or should I say your death works. I urge you to change your ways and allow children to grow up without your indoctrination and make their own decisions when they reach adulthood. Jesus said, whosoever shall offend one of these little ones which believe in me, it were better for a millstone to be hanged about his neck. Woe unto the world because of offenses, for it must needs be that offenses come, but woe to that man or woman by whom the offense is.
Excuse me, Ms. Barrel. Okay, your time is up.
Thank you.
Thank you so much, Ms. Beryl, for your testimony, and thank you for bringing to our attention some opportunities for improving the bill. We appreciate your time. With that, no other questions or comments from members of the committee, so we'll move to the next person on our list. Thank you. Catherine Saris, you're here. Welcome. Thank you for your patience with us. You can turn the mic on. Perfect. Yeah.
There we go.
Welcome.
Okay. Thank you so much. Honorable chairs, ranking members, and members of the Public Health Committee, good afternoon. My name is Catherine Saris, and I am a performing artist and arts educator in Fairfield County. Although I appreciate that proponents of this bill, SB 7, are seeking to create greater access and equity in healthcare in our state, as I read several sections of SB 7, I have developed grave concerns. I am a survivor of childhood sexual assault. I experienced traumatic, violative behavior between the ages of 5 to 10 years of age, and this caused my childhood self to believe that being a woman was a position of weakness, that it would make me a target for future sexual assault, and therefore to reject my own body. I experienced suicidal ideation beginning at the age of 7, and if I had been offered puberty-blocking drugs in my preteen years, I probably would have taken them. It was only years later that I realized the true origins of my feelings of self-hatred. They were a direct result of this childhood trauma. Gender-altering drugs and surgeries were not available to me as a minor growing up in the 80s and 90s, and I was not being inculcated in school by a society with the lie that I could be born in the wrong body. Instead, the resources at my disposal were a loving family, youth leaders at my church, and wonderful people around me who communicated to me that being female was a good thing and my life was precious. And counseling. There are many persons like myself, a child experiencing gender dysphoria, who previously adopt a sexual or gender identity that later proves not to be the answer to their struggles. Many have found that healing from childhood trauma is actually the answer. Please check out some of their stories at changedmovement.com, or I have a book full of those stories here. There is so much documented damage from these experimental procedures and interventions known as gender-affirming care. I see the damage in my students, in the lives of my artistic colleagues, and in the bodies of my friends. Many male to female transitioners, like my friend Corey Kahn, have experienced high rates of osteoporosis, cardiovascular issues, and blood clots, as well as infertility and chronic pain. Or take, for example, Prisha Mosley. After her gender transition and double mastectomy in her teen years, she eventually decided in her 20s to detransition. Prisha was surprised to discover that she could actually get pregnant. However, her uterus, bladder, and vagina had all atrophied. Her hormone imbalance caused the baby to be big, and her hips were too small to deliver vaginally. There is no standard of care for detransitioners. When her baby was born and she wanted to nurse him, she only had painful rocks that had formed under her chest, or what her doctor says are milk masses stuck under scar tissue with no outlet because her nipple was detached. I'll
Excuse
summarize.
me, Ms. Saris, your 3 minutes is up. Thank you.
May I summarize?
Please.
Oh, thank you. These rocks that had formed under her chest, the doctor referred to as scar tissue with no outlet. It was only decorative, and so the breast tissue was, her milk was trying to come out but couldn't get there. So I urge you, please don't pass SB 7 as written currently.
Thank you so much for your testimony, and thank you for being with us from this morning. And I know it's not easy to share your personal experiences, so we appreciate you being here and experiences that you shared with us.
Thank you very much.
Thank you. Seeing no questions or comments from my colleagues, I appreciate you being here. Next person on our list is Tony Ann Marchion. Welcome, and I think, yes. Thank you for being with us, and thank you for waiting for your testimony. We've been looking
Thank
forward to
you.
it too.
Thank you so much, Senator Anwar, Representative McCarthy-Vahey, and distinguished members of the committee. I am grateful for the opportunity to speak before you today to share the findings of our task force and critical barriers we have identified. I'm the president and CEO of Regional Hospice and the co-chair of the appointed task force to study pediatric hospice in our state. Our work has been driven by one simple yet profound goal: to ensure that children facing life-limiting illnesses and their families have access to the care, support, and dignity they deserve during this incredibly challenging time. One of the most pressing challenges we have identified is the need to pilot a center of excellence dedicated to the education of nurses in pediatric hospice and palliative care. Nurses are the heart of hospice care, and their specialized knowledge in pediatric care is essential. Currently, there is a lack of comprehensive training programs focused specifically on the unique needs of children, which creates a significant gap in the quality of care provided. A center of excellence would provide critical, focused education and clinical training to ensure that nurses are equipped to deliver the best possible care to children in need. Another barrier we found was the need for better education and awareness for referring physicians regarding concurrent care. Many physicians are unaware that children in need of hospice care can still continue curative treatment concurrently. This misunderstanding often results in delays or missed opportunities to refer children and families to hospice care at the appropriate time. A more robust educational initiative is needed to equip our medical community with the knowledge and confidence to make timely, compassionate referrals. We have also found a lack of consistent communication with parents about palliative and hospice options. Many families are not fully aware of the full scope of pediatric hospice services, and there is often confusion and fear around what hospice care actually entails for children. Clear, consistent messaging is crucial to ensuring that families can make informed decisions about their child's care without fear or misunderstanding. Our task force also recommends the creation of a generalized program that provides palliative and hospice care across all levels. This would help create a more accessible, inclusive system that meets the needs of all families, regardless of the complexity of their child's condition or where they are in their care journey. A program that not only sets the standards and criteria for all providers licensed in the state to provide hospice care, but helps to monitor the needs of each case. In conclusion, the task force is also requiring some additional time to further develop this pilot program and conduct additional research into successful models from other states that have effectively implemented pediatric hospice programs. Our goal is to ensure that we design a program that is thoughtful, comprehensive, and ultimately provides the best care for our children and their families. I'd like to thank you for your time and attention. We are so committed to working with you all to make this vision a reality. And if I can just introduce Carolyn Torello right now, who's also on the list to testify.
I think since your 3 minutes are up, I wanted to just pretty much up. So I wanted to ask Ms. Torello, as a parent, to share with us why this bill is so important.
My testimony, I have a testimony too, and it will tell you why it's so important. Is that okay if I read my testimony?
Please, please, please.
Okay. No parent ever wants to outlive their child, but for some of us, it is a reality that we have no choice but to accept. Our beautiful twin boys, Michael and Matthew, were born on May 21st, 2006. Michael was diagnosed with athlete cerebral palsy. He had little motor control, was in a wheelchair, and required a feeding tube. Although he was cognitively normal, he was nonverbal but communicated through a device, head nods, and facial expressions. Michael was considered medically fragile, had daily nursing care for 16 hours a day, and a hospital setup. However, when he required intensive care, he was in and out of the hospital for weeks, sometimes months at a time. When he was 13, Michael suffered a terrible fall that fractured his jaw. Needing multiple surgeries, this was too much for Michael's already compromised body to handle. Michael lost weight and was not able to thrive. My husband and I consulted a palliative care doctor who led Michael's care. At this point, his death was certain, and we had to make plans for this. The doctor put us in touch with a hospice that usually cares for adults. After speaking several times, they agreed to take on Michael's case. When the time approached, I was told to reach out to them when Michael was closer to actively dying. When the time came several months later, I was told they could no longer help us. We were devastated and lost. I asked who I could contact and had no guidance. The hospital tried to help, but they also didn't have an answer. Because of the hospital bureaucracy, Michael's palliative care doctor was limited with what he could do. His regular nurses could only provide life-saving care, so I was the one who had to administer morphine to my own child. I knew the morphine was just to make him comfortable while he died. I had to do this while I was emotionally dealing with the impending death of my child. It actually ripped my heart to shreds to do so. No parent should ever have to do this. On top of this, I had to deal with a system that could provide me with no help. Ultimately, we were able to find support from a local convent where Sister Catherine helped us to find regional hospice. Michael, poor Michael, I wish we had found regional hospice sooner. Regional hospice staff were wonderful. However, he died 2 days after they took on his case. Connecticut is in dire need of a children's hospice. I do not want any parent to have to provide end-of-life care to their child without support as we were forced to do. It is so unfair to the parents and the child. Imagine for a moment if you had to make the same decision for your child. Everyone deserves to die with dignity. Again, I want you to imagine being in our shoes and being told that the hospice isn't willing to help your child. You are helpless and numb. No one helped with our child, even though hospice is readily available for adults. Every hospital should have resources available to guide parents on options to care for their medically fragile or dying child. Regional hospice never.
Ms. Torello, but you have reached your 3 minutes. Thank you.
I'm almost done.
Sure, please.
We should have been provided with this information long before we were. It is inexcusable that we were not. It made the most devastating time in our life even more unbearable. I am here today because this cannot happen to another child. Thank you.
Thank you so much for your testimony. Thank you for being here throughout the day with us. And I'm so sorry for your loss.
Thank
and we've had the sad situation of meeting parents like you. And that's what made us realize that, you know, as a parent, nobody can ever imagine. And that's why you don't plan. And the state, which is so conscientious about so many things, never planned this aspect. And this is little blind spot for the state. And it's no longer a blind spot anymore because of parents like you and individuals like Tony Ann who've been speaking about the need for this.
Right.
So you guys are heroes for standing up and helping us to recognize as a state that we can do better. And the amount of work you have put in this group, our working group, and we look forward to getting more information. This bill is an important bill. It is not a perfect solution to what you're hoping, but it's going to be a starting point, and we will hopefully continue on with the work that needs to go on. And I know we are extending the date of your report, and which is very important. We want to get this right rather than do it early, but we'll start the process of some of the things that make sense now and continue to pursue those. But I know my co-chair also has a comment on this.
Thank you, Senator Anwar, and thanks to both of you for being here, for sharing your stories and experience, and that the pain that you have experienced and witnessed, both of you yourselves in different ways. Tony Ann, thank you for helping to lead the conversation. And I do, as you heard me say earlier, look forward to continuing the conversation and this journey. Thank you, Mr. Chair.
I know one of my colleagues, Representative Cavros DeGraw, has a question or comment. Representative.
Hi there. Thank you so much, Mr. Chair. I just wanted to make a quick comment because I know that it's that time of day when so many of us are in so many meetings. I just want to thank you for your bravery in coming forward. I have never had to engage with hospice with a child, but I know my experience with engaging with hospice with a family member at home. And I know how incredibly difficult that was to be the nurse and be the one responsible. And I can only imagine what that must have been like for you. And so the work that has gone into this, I think, is some of the most important work that we will do this session. And I just wanted to thank you again for doing this work for all of the families who will come after you that you are leading the way for. So thank you again. And thank you, Mr. Chair.
Thank you. Seeing no other comments or questions, we appreciate you being here with us today.
Thank you.
Thank you. Next on our list is Dr. Mohab Rizkallah. Dr. Rizkallah, you're on.
Yes, hi, my name is Dr. Mohab Rizkallah, and I'm your neighbor actually in Massachusetts. I'm the president of the American Alliance on Dental Insurance Quality, which installed Massachusetts Question 2 in the year 2022. Massachusetts Question 2 was a dental loss ratio ballot, and it was the first dental ballot in the history of the nation. It resulted in a 72% yes vote by the citizenry, and it established the first meaningful dental loss ratio in the nation, as well as the first meaningful dental insurance reporting in the nation. Why did they vote yes? The Massachusetts people are not different than the Connecticut people. And they voted yes because there is currently very little value in dental insurance. There is currently unfair denials in dental insurance. The insurers currently pay between 40 to 70% of their premium revenue for commercial dental plans, while in Massachusetts, medical plans have to pay 88% of their premium revenue, and self-funded plans are able to pay 94% of their premium revenue. And yet, dental insurers seem to just glide by with no regulation. There's some very interesting data. I have vast data. A $600 million self-funded plan can be managed by a third-party administrator, which is a commercial insurer, with a 95% efficiency. That means their actual cost to manage the plan is only 5% if they make no profit, okay? Now imagine in Connecticut, as we did in Massachusetts, imagine you change that number. Let's just say that you change that number to 90% efficiency. You hold them to a 90% dental loss ratio. Well, they'd still make $35 million in that case. Or let's say we change that number to 85%, which is actually what the Affordable Care Act requires of large group medical insurers. And that's actually what the CDA, the Connecticut Dental Association, has proposed in a bill that they're asking you to add to this omnibus bill. That would allow the commercial insurer to make $70 million for $600 million worth of premiums. It's a significant amount. And what are they really doing, these insurers? They're not providing the service. They're just intermediaries, okay? And there are many intermediaries that take out of this pie. And a quality dental loss ratio regulation, what it does is it disintermediates. It removes the intermediaries, such as brokers and producers, and it puts the money back into the patient's pocket.
Excuse me, Dr. Riscala, but your 3 minutes is up. Thank you.
Okay, thank you.
We appreciate your testimony, Dr. Riscala. And so after that ballot initiative, did the premiums go down?
They didn't move at all. In fact, what happened was, and we have all the data on this, by the way, what happened was the cost of the premiums didn't go up, even though inflation increased. So effectively, their true value did go down. And your next question is going to be what happened to the number of insurers. The number of insurers dropped on a tiny level, went from 26 insurers to 21 insurers, and all of the insurance loss ratios went up to the 83%, and they started to compete with themselves. Blue Cross Blue Shield went to 87%. And this happens because you have the transparency in the reporting that allows the insurers to actually see what each other is producing in terms of loss ratios. And they say, well, if the consumer is going to see that number, we would rather be able to provide a higher number so the consumer is more likely to buy our product next year. So the competition allows for greater value in the dental insurance.
Thank you so much. Do you have a written testimony, Dr. Riscala?
I do not.
Would you be able to submit one? We would appreciate it as well, because I think many of our colleagues would love to get an insight into the Massachusetts experience.
I'd be happy to do that. And I want you to know you can call on me as a resource. We're here to serve not just Massachusetts. We're really here to serve the entire nation, starting with our sister state of Connecticut.
And for dental appointments too?
I don't know about that.
Okay, thank you. All right. Seeing no questions or other comments, we will have the next person, Danny Brucho. Well, I probably messed that up, so please correct me, and thank you for your patience with us.
Absolutely. Good afternoon, Senator Anwar, Representative McCarthy-Vahey, and distinguished members of the Public Health Committee. My name is Danny Brochu. I'm a registered nurse and lifelong Connecticut resident. I'm speaking today in support of Senate Bill 7, an act concerning protections for access to healthcare and the equitable delivery of healthcare services in the state. Access to reproductive services saves lives. Miscarriages and complications in early pregnancy can result in retained products of conception, which may need to be removed by a qualified healthcare provider in order to preserve the life and overall health of the mother. Under the current federal administration, it is critical to remember that separation of church and state is a non-negotiable foundation of our nation. The religious beliefs of individuals or organizations should not be utilized as an excuse to restrict care to community members in need of life-saving medical services. Access to gender-affirming healthcare saves lives. According to the Trevor Project's 2020 National Survey on LGBTQ+ youth mental health, 54% of young people who identified as transgender or non-binary reported having seriously considered suicide in the last year, and 29%, nearly 1/3, have made an attempt to end their lives. In contrast, numerous research studies have shown that gender-affirming care leads to improved mental health outcomes among trans youth. The safe harbor portion of this bill will be especially important as women and transgender people continue to flee from areas of the country where their care is criminalized. Connecticut has historically been a state that has allowed individuals to make informed decisions about their bodies and health, and I believe that having this legal protection will improve the health of women and gender diverse individuals in our communities. From a financial perspective, people who travel here to receive these services will stimulate our local economies and may even choose to take up permanent residence in our state, incentivized by their right to reproductive choice and a more accepting socio-political environment. I thank you all for the opportunity to testify, and I implore you to vote yes on this bill. And I'm open to any questions at this time.
Thank you so much, Ms. Brochu, for your testimony. And um, could you tell me a little bit about your nursing? What background of nursing? What work do you do within the nurses?
Yes, so I'm a doctorally prepared registered nurse. I am a former nursing professor, and I have been a nurse for almost 9 years at this point. I have seen firsthand folks come from other states to access these services because they don't feel safe or they're not available in their home state. Folks that have traveled many, many miles for these services.
And would you be able to speak a little bit about perhaps a case or some situation which would help us illustrate an example?
Yes, I took care of a woman from down south. This was probably 2 or 3 years ago now, who had 2 children at home already, had an unintended pregnancy of a third, and was very adamant that she was not able to physically, emotionally, financially handle a third child. These services were not available in her state, and she sat on a Greyhound bus for almost 3 days in immense pain, immense anxiety to get here and have the services that she needed. So whenever I speak about this topic, she's probably the first person that comes to mind.
Thank you so much. And we're hearing more people speak about some of the difficulties. I think many of the people have read the bill as we are changing the existing laws of how things should be. We are just providing a safety for individuals from private money, not public money. And I think that part in the bill was not what was the intention, and then that has caused a little bit of anxiety in amongst people as well. But your testimony is helpful. We appreciate you being here and the work that you do.
Thank you, Dr. Anwar.
Thank you. With that, we ask the next person on our list, which is Dr. Steve Ward. Dr. Ward, you're on. Welcome.
Hello, thank you. My name is Dr. Steve Ward. I'm a board certified internist. Been practicing for about 16 years. I oppose SB 7, and the timing is fortuitous. I'd like to respond to the previous testimony that we just heard. If the life of a mother is in question, that mother will already receive the care that she needs to preserve the mother's life. And the other comment about the separation of church and state, I agree. We should keep the government out of the affairs of the religious community and the church. So I think we have that a bit backwards. So jumping into this bill in section 4B1, this is the discussion about hospitals limiting a provider from reproductive healthcare services and gender-affirming healthcare services, specifically lines 401 and 430, talking about conforming to the accepted standard of care. And then also lines 435, 436, the discussion about medically accurate and appropriate information and counseling. Well, who determines what is medically accurate and appropriate, and who determines what the standard of care is? I'm familiar with the Trevor Project studies that were done. They were done extremely poorly. This is very poor quality science or pseudoscience. The claim that gender-affirming care prevents suicide is absolutely false. The surveys that were done asked kids with gender dysphoria if they had considered suicide in the past, but did not tease out the underlying mental health problems of the child, such as pre-existing anxiety and depression. And current research actually shows that gender dysphoria is a symptom of underlying anxiety, depression, and other issues, not the cause of the suicidality. So there's a lot to be desired in that interpretation. Gender affirming care does not save lives. It's actually quite harmful, especially to children. There is absolutely no long-term safety data showing that this is effective or safe. What we really have is a disagreement on what the standard of care is. We have ideologues in various bodies putting forth the idea that hormone therapy, surgery, puberty blockers is the new standard of care. It is absolutely not. There is no consensus that that is the case. In fact, we have good research showing that gender affirming care, like I said, is harmful. Faith-based hospitals and communities should have the absolute right to do what they know to be in the best interest of the child. I also have a concern about, in Section 19, gender affirming care being included as part of the broader reproductive health care services. And this idea of a safe haven funding mechanism. I'm less concerned about the dollars and how that's being transferred around.
I'm sorry, Dr. Ward, but you've reached your 3 minutes.
Okay,
Thank you.
I'll end by just saying that regardless of the funding mechanism, I don't think this care should be performed at all anywhere in minors. Thank you.
Thank you so much, Dr. Ward, for your testimony. We appreciate you being here with us today and your testimony. Dr. Ward, you're practicing in Connecticut?
Yes, sir. I live in Cheshire. I'm a primary care doctor.
Okay. We appreciate your taking the time.
You bet.
Thank you. Seeing no questions, we'll move to the next person who is here in person, Mag Morelli. Welcome, Ms. Morelli. Thank you for being here in person.
Oh, thank you for having me. And good afternoon, Senator Anwar and Representative McCarthy-Vahey and the distinguished members of the committee. My name is Mag Morelli. I'm the president of Leading Age Connecticut, a statewide membership association representing not-for-profit provider organizations serving older adults across the continuum of aging services and including not-for-profit assisted living communities. We thank you for this opportunity to testify on House Bill 7249, an act concerning assisted living service agencies and rehabilitation facilities, and to offer our assistance in clarifying the intent and language of the bill. The concept of assisted living service agencies, also known as ALSAs, having person-centered client service programs that address the potential for a medical emergency related to their chronic and stable condition is laudable and is currently done by most ALSAs. It must be pointed out, however, that it is difficult to address every potential medical emergency that may arise in a senior living setting, or to foresee the skilled medical or nursing professional that may be needed to address it. We therefore have some concerns with the expectations of this proposal. It's important to note that the assisted living setting in Connecticut is designed to care only for residents who have chronic and stable medical conditions. It is not for acute care or for skilled nursing care. There is a requirement for a specific number of licensed nursing staff hours, but it is not required that a registered nurse be on site at all times. In this setting, as in all settings, it's appropriate to contact emergency medical response when there is a belief that there is a true medical emergency. In such cases, time is of the essence, and while in hindsight it may be determined that the situation was not emergent, it should not be expected that a certified nurse aide or a licensed nurse be asked to make that determination when the symptoms or conditions indicate a medical emergency. Remember that when addressing medical emergencies, a licensed practical nurse is limited in that they are not permitted to conduct a nursing assessment, and a nurse aide also cannot conduct a nursing assessment nor administer any type of medication or medical treatment. We therefore ask that the language of the bill be clarified to recognize the need to include the circumstances when calling for emergency medical response is appropriate, and we have provided some suggested substitute language for your consideration. Regarding Section 2, we can't support this section at this time. Currently, the bill pertains to rehabilitation facilities, but there is no state licensure category for rehabilitation facility. And with the broad manner in which it's defined in this bill, it could include almost all licensed healthcare entities in the state. The proposal then mandates inclusion of 3 specific care components to every patient's care plan, and a statutory mandate. We would believe that would be a statutory mandate of the practice of medicine, and we believe it's not appropriate. Based on these concerns, we must oppose this section of the bill. We thank you for the opportunity to testify and happy to answer any questions.
Wow, you left like 15 seconds on the table.
Do I win?
So we have put in the bill, some of the things we've sort of limited it with respect to some of the examples. I don't know if you saw the examples in there.
Yes.
And the examples are based on the various reasons why the patients are sent for emergency room. And these are situations where most of the time those patients will stay in the emergency room for 12, 15, 16 hours and be sent back. And this was triggered by patients' families and others who felt that some of the basic things could have been addressed at the facility. That's a rationale. Give a nebulizer treatment to somebody, not the end of the world. And in the same way, if somebody is dehydrated, give them a little bit of water if they're able to have the water. Because many of the times you see that the elderly are not drinking enough water, they get dehydrated or get a urinary tract infection. So these are preventable things. And almost at times it's felt that anything slightly abnormal, I don't want to take a risk, go to call the ambulance and send them to the emergency room. And in the emergency room, they're not getting the care, as you have heard today, that they're waiting for hours and hours and days, and then they get confused, and then before you know it, they go to a rehab facility because they are deconditioned. I think we want to break that cycle somehow for a little bit more very basic, humane, kind, understanding care.
And I think the language that we provided or suggested includes those conditions in it. It doesn't change that language. It says to address that, but it also asks that it address in the care plan when it is appropriate to call emergency services. So there isn't a question of that. And it recognizes the fact, we want it to be recognized that there is a time when the emergency medical response should be contacted, that there shouldn't be a question. Because at times in the middle of the night, it might be a nurse aide that comes upon the person that's ill or experiencing symptoms. There may be symptoms different than what their chronic disease, would normally show. Or it might even be, even if it requires the injection of a medication, if there is no one on site that can do that injection and time is of the essence, then there needs to be some type of response called. And it could be called to the RN. I mean, there are a lot of responses that can be placed in there. But we just want to make sure that it's recognized that emergency medical response is appropriate at certain times.
So we'll look at your language change, but conceptually, you understand what we're trying to get to.
I understand completely.
And you have suggested language that would allow us to be able to get there.
I think it does. It keeps in the types of issues that should be addressed in the care plan. You have to understand that these are private pay patients who would request certain types of nursing services at certain times of the day. And if someone is rejecting that, those consequences have to be discussed with them. But we keep all of that in there. What we add is that you include in the plan the circumstances under which the staff should seek emergency medical services, including the use of 911, so that the plan talks about everything you've addressed. And then it talks about just, making sure it's recognized that there is a time when 911 should be called.
Thank you so much. This is very helpful. Appreciate you taking the time to be here with us.
Well, thank you.
All right. That brings us to the next person on our list, which is David Fenton. Welcome, Mr. Fenton.
Hello, thank you. Appreciate it. I appreciate your time. I'm here to comment on the medical loss ratio. I'm a dentist and oral and maxillofacial surgeon. I live in West Hartford. I have a practice in Bristol. And I think a couple of things, major issues. I think capitalism is great. I'm all for it. Generally, it works best when there is appropriate regulation. I definitely respect Dr. Rizkala's testimony and would also look forward to his written testimony. The CSDA has written testimony as well. But we're in favor of including dentistry and dental insurance in the medical loss ratio or a dental loss ratio. I think what's a major difference and a reason that further supports why dentistry should be included is that dental insurance really isn't even insurance. It's a discount plan. When you're in real need, that's when the dental insurance doesn't cover. The insurance companies have a very strong ability to know what their kind of risks are for costs. And they know a maximum they're going to end up putting out. Most dental insurance private carriers, it's like $1,000 or $2,000 for an annual maximum coverage. So they're never going to pay more than that, whether it's covered or not. So it's the main reason the patients get a benefit from insurance is because of the somewhat inflated fees that we are kind of required to have so that we can get our maximum reimbursement, which is already discounted when we are in network participating with a dental carrier. And so they get a discount from the dentist's fees when they are in network, but that doesn't mean that the insurance company is even paying anything. So I think it's extremely an important issue because pretty much every single patient I deal with, sometimes ad nauseum, the only thing they focus on is what's insurance going to cover. You know, they're prioritizing insurance coverage because of their fears of the financial implications of the treatment over even what is best for them and what they should get. And this kind of cycle that has occurred has started to almost brainwash patients to thinking that their insurance companies are out for their best interest and that they only need it if the insurance is going to cover it. And if insurance isn't going to cover it, it's because that care is not even appropriate. And obviously, I think anybody that knows the system at all in healthcare, that's not what it's about. But I think having a medical loss ratio for dentistry will help encourage the carriers to provide appropriate services for their care and under their benefits. And at the very least, if they're not, then they're not just pocketing extra cash from their patients, which are our residents.
Thank you so much, Dr. Fenton, for your testimony. We appreciate you taking the time. Seeing no questions or comments, we'll move to the next person on the list.
Great, thank you.
Danielle Berriault. Ms. Berriault, you're on. Welcome. You're not unmuted.
Thank you. Good afternoon. My name is Danielle Berriault, and I live in Danielson. I'm an RN at Bacchus Hospital, and I'm the vice president of our union local, Bacchus Federation of Nurses, AFT Connecticut 5149. Please accept this testimony in support of Senate Bill 7 and 1538. The language in SB 7, pertinent to administrators holding a license, would complement the previous safe staffing legislation that came from this very committee. 2 years ago, I testified in support of SB 1067, and while this legislation was a good place to start, there is a lack of enforcement of this law. Our staffing committee meets regularly to review complaint forms and to discuss applicable matters. As the bedside co-chair for our committee, I and we, the bedside nurses, adhere to the structure as outlined in the law to the best of our ability. To that end, we collaborate with management and vote on the staffing plan, and the hospital subsequently posts a staffing plan on the walls of our units that differs from the plan that we developed, voted on, and passed through our committee. The hospital attests to achieving 80% compliance despite their blatant and purposeful violation of the law. We have brought these complaints forward to our hospital's administration and to DPH on multiple occasions without effect. Healthcare and social assistance sectors experience the highest rates of workplace violence compared to other sectors, nearly 73% of all cases in private industry. Evidence shows understaffing is a common cause of workplace violence. As many of you are aware, some of our nurses were assaulted as recently as within the last few weeks, and these events are not a rare occurrence. We are currently in negotiations and have been fighting for improved safety standards both at the bargaining table and in other ways as we seek to keep each other and our patients safe. The hospital has not altered their practices in a meaningful way, despite our repeated advocacy. Healthcare administrators must be held to a higher standard. Studies show overcrowding leads to increased length of stay for impacted patients, increased prevalence of medical errors, increased numbers of patients leaving without being seen, and increased mortality rates. While an expedited conservatorship process would help alleviate some of this burden, we need to do more to improve safety in our emergency departments. When asked for feedback, nurses in the Bacchus ED responded with reports of boarding and crowding leading to overall poor care, staff burnout, lack of privacy for patients in hallways, poor hygiene, especially in the setting of urinary and fecal incontinence, leading to complications such as infections, wound development, nutrition leading to similar complications, as well as hypoglycemia, inadequate amounts of supplies for patient volumes such as cardiac monitors, delirium, increased workplace violence from patients and their visitors, decreased mobility and increased weakness, leading to falls and pneumonia, and so much more. While the inpatient units typically get capped after 1 or 2 hallway patients, the ED does not have that same benefit, and our administrators often continue to accept transfers from other hospitals, despite the unsafe conditions at our own facility. While there is no nursing shortage, there is a shortage of nurses willing to work at the bedside in the current conditions. These conditions can be improved if we hold healthcare administrators to a higher standard. I urge you to support this legislation and urge you to continue to implement changes to improve safety in the healthcare setting. Thank you for the opportunity to testify. I appreciate your time, and I'm willing to answer any questions you may have.
Thank you so much, Danielle, for your testimony. Appreciate your work and recognizing. So, what you're saying is that sometimes these healthcare administrators are making rules that are negatively affecting the patient's outcomes, and that's why we need to hold them accountable, because there's malpractice if they were doing clinical work, which indirectly they are.
Yes, I would agree with that statement.
Okay, good. And seeing no other questions or comments, we appreciate you being here and taking the time.
Thank you very much.
Thank you. Next is L. Palmer. Are you here? No. All right. Kathy Flaherty, you're on. Welcome.
Thank you, Senator Anwar, Representative McCarthy-Vahey, and members of the Public Health Committee. My name is Kathy Flaherty, and I'm here to testify regarding Senate Bill 1538, an act concerning emergency department boarding and crowding. And I have read the report of the work group and have listened to some of the testimony from earlier today, and agree with people who state that emergency department boarding and crowding it is a problem that we need to address. But I am just not sure that an expedited process for the appointment of a conservator for patients who lack the capacity to consent to receive health services is really going to be the solution to the problem. An appointment of a conservator to consent to healthcare decisions represents a significant deprivation of the rights of the respondent to self-determination. And that's why the probate court has to ensure that due process is respected. What's not clear to me is that people may not know enough about the already existing process for appointment of a temporary conservator who would only serve for 30 days instead of being appointed till somebody does something to get rid of that conservatorship. But if the person is incapable of managing their affairs or incapable of caring for themselves, and it would result in an immediate irreparable harm to their mental or physical health, a temporary conservator can be appointed. And that appointment can happen even without a hearing or without prior notice to the person if the court finds that the delay resulting from giving notice to the person and getting them an attorney would result in immediate and irreparable harm. So if the ex parte order is issued, a hearing has to be held within 3 days. So I would say you arguably already have an expedited process, although it appears that fewer than 250 petitions for appointment of a temporary conservator were filed each year of the last 2 years that were available from probate courts administration's biennial reports. I'm wondering how much of the problem is really due to a lack of resources at other levels of care. Because there is that possibility of getting the temporary conservator, you might have the person who's able to make that substitute decision maker decisions, but they don't have the legal authority to consent to admission to a psychiatric inpatient unit, for example. Although a physician can issue a physician's emergency certificate to get the person from the emergency room to the inpatient psych unit. But if there's a wait for an inpatient bed, the person does get stuck boarding in the ED. I don't think that the problem of boarding and crowding in emergency departments is really going to be solved by establishing an expedited process for the appointment of a conservator when it really is the result of under-resourcing of other levels of care. So I thank you for the opportunity to offer testimony on the bill.
Thank you so much, Kathy, for your testimony. We appreciate you taking the time. I think we hear you loud and clear. This is a small part of the bigger picture, and thank you for highlighting that. And I think we will have to readdress the way the bill is looked at this right now. So thank you for your insight. Seeing no questions or comments, we will move to the next person who's on our list, which is Cassandra Lair. Oh, wait, sorry. Mark Schaefer. I'm sorry. Welcome. Thank you for being with us. Actually, press the button first. No, the other one, the other one. There, and go for it. Now you start.
Thank you. Good afternoon, Representative McCarthy Vahey, Senator Anwar, and distinguished members of the committee. My name is Mark Schaefer, Vice President of System Innovation and Financing at the Connecticut Hospital Association. I appreciate the opportunity to voice our strong opposition to Section 3 of Senate Bill 7, which concerns injection and infusion services provided by hospitals in off-campus settings. The majority of this care supports cancer treatment, which typically involves frequent infusion of chemotherapy or other drugs by nurses or other hospital staff pursuant to a physician order and plan of care. This bill would introduce an outright prohibition on commercial reimbursement for these services in off-campus settings. Stated another way, hospitals and the clinical staff who support these services would receive no commercial payment whatsoever for providing these services other than for the cost of the drug. This would likely result in a loss of access to these services. It would also introduce the needless loss of tens of millions in hospital revenue at a time when hospitals across the state are experiencing extraordinary financial challenges. Low-income patients on Medicaid rely on the access provided by hospitals, access that they might not otherwise be afforded in community practice settings. In addition, hospitals often serve patients with more severe or complex conditions that can be effectively managed in non-hospital settings. There's no public health rationale for making it illegal for hospitals to collect commercial reimbursement for these services, which would result in the elimination of these care settings entirely and access for all patients who rely on this care, regardless of payer. Thank you for your consideration. I'm happy to take questions.
Thank you so much. You left about a minute and a half on the table. I love it, but it's to the point. But don't go away. Would this be the same? So if there's a private oncologist, they're providing chemotherapy at their office or the space, and the hospital has an outpatient practice affiliated with the hospital. In the first situation, there is no facility charge, and the second one, there is a facility charge.
Well, in both instances, the commercial reimbursement covers both the cost of the pharmacotherapy, the cost of the drug, as well as the services associated with administering the drug. It may be combined into a global payment, or it may be a professional it may be an all-inclusive payment, but there is more than just the drug that's covered in non-hospital settings. And it is those costs that are being prohibited or proposed to be prohibited in hospital settings.
So part of the bill also talks about transparency around the process. So the patient knows in advance that when they are going to have that infusion, there is going to be a facility charge to that. Are you guys opposed to that transparency or communication?
Well, there's existing statute that we think adequately serves and that hospitals follow today around notification around facility fees. And, that's been in existence for more than a half dozen years. And we think avoids a situation where there are surprise bills.
Okay, so you think that this part of the bill is going to, because we've not had any oncologist or anybody reach out to us and say this is a concern, but it's more hospital-based centers where the challenge is different.
Well, the bill is specific to hospital off-campus settings. So for that reason, physicians who aren't practicing, oncologists who are not practicing in those settings would not be concerned about this bill.
Okay. Well, this is helpful. You're taking note of your testimony, and there's a written testimony. Thank
right.
you. Thank you for being here. Thank you. With that, we will take Senator Looney. Senator Looney, we're waiting for you all day. Welcome.
Welcome.
Thank you for your indulgence, Mr. Chair. As you know, I had signed up earlier in the day, but events kept intervening to keep me from getting down here. But wanted to thank you so much, Senator Anwar, Representative McCarthy-Vahey, members of the Public Health Committee. I'm Martin Looney, represent the 11th Senatorial District, parts of New Haven and Hamden, and would like to express my support for SB 7 today. At a time when so much is really unknown at the federal level, and the impacts that will hit us are alarming, but still speculative. It's vital, I think, to have the fundamental right to health care and safety in Connecticut reflected in what we do in SB 7. Pardon my cold came down with this morning. Back in 1986, Congress enacted the Emergency Medical Treatment and Labor Act, EMTALA, to guarantee access to emergency services regardless of ability to pay. And this bill will protect people in Connecticut and codifies EMTALA on the state level, partly because we don't know what's going to happen with the federal guarantees. It also will make sure to protect the most vulnerable people in our state, making sure that a hospital will render emergency medical services to any person without first questioning their ability to pay for those services, a critical protection and security. Also, with the ever-growing changes in the federal level and with the U.S. Department of Public Health, it's important for the state to be prepared for any type of public health emergency. And SB 7 establishes a public health urgent communication account as well as an emergency public health financial safeguard account, both important precautionary measures. In addition, SB 7 codifies the federal guidance for fluoride in our water, maintains the current 0.7 of a milligram of fluoride per liter of water. Again, a proactive measure to help with tooth decay and long-lasting health issues in our state. Section 3 of the bill adds infusion and injection services to the list of outpatient procedures for which hospitals cannot charge facility fees. We know there was a tremendous increase in the cost of those services when they are provided it is on an outpatient basis with facility fees added when there's really no rationale for those fees. In general, infusions at hospital-owned infusion centers cost about twice as much as the same infusion at a non-hospital-owned infusion center. The bill also restores the CUTPA, Connecticut Unfair Trade Practices violation language regarding facility fees that was, I think, inadvertently taken out in 2023, which weakened facility fee enforcement. Excuse me, Section 15 of the bill removes the presumption of approval for physician practice acquisition. Obviously, it should be go forward on a neutral basis rather than a presumption. It's important when we have so much happening with our hospitals and healthcare system, and this presumption, excuse me, makes oversight better. We also create a mental and behavioral health awareness and treatment pilot program in our priority school districts and declare opioid use a disorder as a public health crisis. Thank you, Mr. Chair, Madam Chair.
Thank you so much, Senator Looney, for your testimony and your support and guidance on many of these bills. We appreciate your leadership. I think you have a written testimony as well, and I know you've been busy and you're not feeling well. Despite that, you're here to advocate for this important bill. We cannot thank you enough.
Well, thank you. It's an important bill. As you know, these single-digit bills are, excuse me, our caucus priorities, and I want to thank you for your work and input on this bill.
Thank you. We have no questions. We just want to appreciate you being here.
Thank you so much.
Thank you, Senator Looney. With that, Paul Kidwell, welcome.
Good afternoon, Senator Representative. Nice to see you. Since Mark left a minute 30 on the table, am I able to use that minute 30? Paul Kidwell from the Connecticut Hospital Association, and I'm here today to testify on the two certificate of need bills before the committee. Our comprehensive written comments on both bills are available for your review, so I'll be using my 3 minutes to highlight a select number of provisions. Related to the committee's bill, we support Section 1, which adds a CON requirement for any investment in a healthcare facility by a private equity company in which the private equity company acquires a controlling interest in the facility. We believe that this new oversight requirement, which focuses on investments that impact the controlling interest or managerial control of a hospital, is targeted and reasonable. Section 3 of the bill requires OHS to post notice on its website when it enters into agreed settlement negotiations, prevents OHS from granting intervener status in public hearing related to a CON application filed by a group practice, and creates an expedited CON process for an application to increase licensed bed capacity. Wanted to focus on the third item, which allows for the expedited approval of licensed bed capacity. We support that notion. We're hoping that the committee would be amenable to actually making the OHS either approve or deny the request within 48 hours. And I'm happy to answer any questions related to our concern there. Related to OHS's proposed revisions, we oppose the continued use of policies and procedures in implementing statutory language. We think the regulatory process should be followed there more closely. We are opposed to the change to the limitation on termination of services. We believe existing statute is sufficient to ensure that both OHS has information related to a termination of services while also allowing the facility to determine if such services will in fact be terminated. Finally, Section 5 of the bill proposes that OHS may develop and implement an expedited process for certain determinations. We certainly agree with the general approach, but think that it should be much more targeted and that the expedited process should specifically be used for the establishment, transfer, or expansion of behavioral health and substance use disorder treatment services, the acquisition of imaging equipment, and the termination of services. Keeping in mind Representative McCarthy-Vahey's comments from much earlier in the day related to making progress where we can, I do want to say, we generally believe that the CON process needs a much larger overhaul, and certainly have ideas related to how that can be accomplished. But in a number of areas, we would like to see the CON process prohibit OHS from requiring applicants to meet requirements or obligations that are not set forth in statute or regulation, streamlining CON by not requiring an application for relocation of outpatient services within the same municipality and other like services. And like I said, developing a CON process, an expedited process for those specific services I mentioned earlier. Finally, I'll note Section 6 of OHS's bill allows OHS to charge up to $300,000 to an applicant for the services provided by OHS. That currently exists in statute at $200,000. And so to the extent that we will be providing OHS with greater resources to do its work, then we would hope that that process would move more quickly than it currently does. So with that, I will appreciate your time and happy to answer any questions.
Thank you very much, Mr. Kidwell. And I'm not sure, I'm not able to get to your written testimony right this moment, but I will find it, and I know you have submitted that. Just to your point about the incremental change, some say Connecticut is known as the land of steady habits, and others say Connecticut is known as the land of incremental change. So to that point, have you experienced in the years that you've been doing this work, any years prior to my time on this committee, or perhaps even Senator Anwar's time on this committee, years where there has been a major overhaul of the CON process?
My time, Representative, is probably as limited as yours related to the CON process. And so I don't know of any time when there's been a major overhaul. My colleague Karen Buckley may be able to answer that question more thoroughly than I can. But I will say that in the last 5 years, we've had some major CON applications that from our view have taken much, much too long and have really had a negative impact on how healthcare services are delivered in this state. And we're currently, as an example of a current process undergoing, New York has already approved one of the CON applications in front of Connecticut OHS right now. They did it within 90 days of it being requested. So we think there certainly are reasonable questions to be asked, but it's taking far too long to come to decisions. Additionally, I think some of the applicants for CON are sort of practicing defensive CON medicine, in that in order to preserve our right to appeal a decision, there needs to be a contested case, so a mandatory hearing must be called. And in the case where a mandatory hearing isn't called, OHS has the ability to call a discretionary hearing, but if they do that, we lose our appeal rights. And so what we see happening is either you try to get a mandatory hearing called in order to preserve your appeal rights, or you just hope that OHS doesn't call a discretionary hearing, say, on the 89th day before the 90-day period is up. And so we've got this situation where we need the timelines to be either firmer or clearer, so that we don't see what we think is sort of an abuse of the timelines being used, either to delay or ask additional questions. So of course, we're always happy to work with the committee on that. We think there are some meaningful improvements in the committee's bill that we certainly support, but do think there's more work to be done.
So thank you for that answer. The other question that I had is just about the termination of services. I know, I mean, again, I have not reviewed your written testimony, but your suggestion is that basically the process seems to be working the way that it should be now. Is that a fair way to say what you're saying? Or because I think given some of the situations that we've seen, there are concerns, because when you have intermittent service, you can't count on that. And of course, if I'm a pregnant mom and I don't know when that baby's coming, right, I'm not probably going to the place that, well, it's only open sometimes. When I'm in labor, I'm not checking to see which one is open. I'm going where I know it's available. So if you can speak to that,
sure,
that'd be great.
So we think for termination of services, that should be an area where an expedited process could be useful. To your point around whether the sort of uncertainty around service availability, certainly we think that OHS should have a review of that application, but it shouldn't be over 180 days. It should be a much more streamlined and efficient process, so that all parties can then come to a decision about whether the service is going to be available or not. Now, in certain instances, and I know there's been testimony on this prior, it is difficult to find certain providers to provide certain services in certain areas, based on the level of volume of those services, the level of need in the community. So those are hard decisions to grapple with for a community, for patients, for the hospital. So no denying that none of those decisions are made without study, but we think it should be done in a more expedited fashion.
Thank you for that. So if I were to give you the magic wand, putting aside that getting rid of CON altogether is not one of the choices, but if I were to give you the magic wand and say, you can design how we go about redoing the CON process. And I'm not suggesting that, just to be clear, I'm not talking about the content of that, but how would you go about having the conversation to redesign the CON process? What would that look like from your magic wand standpoint?
So I heard you ask this question earlier today too, so I'm hoping I'm prepared for it. But two things. I think it's identifying those areas today that require CON where an expedited process could be useful. So for my example, termination of services, that's a good place to start with an expedited process. Two, it's making sure that the timelines aren't then used as a delay tactic, so that if 90 days is 90 days, it's 90 days. And that's all, both parties have to abide by the 90 days. It's not endless requests for information in order to come. That's what's killing the process, is that it's, you know, Paul Kidwell, what's the answer to this question? I give the answer to that question. And then there's another set of questions. And then there's another set of questions. And then there's another, it's endless. Until you get into a sort of an agreed settlement framework where you may be forced to agree to things that frankly aren't relevant to the CON that you applied for, just to get the process completed. So I think expedited process for certain services and making sure this statutory timelines are just that, and every party has to abide by them.
And I appreciate that answer. I'm going to go up a level in
Yep.
terms of how would you make that happen here? If you were, you know, anywhere around the table, and when I'm talking about process, I'm not talking about the actual CON process,
Yeah.
but who's having what conversations when and how?
So-
And I don't mean to put you on the spot,
No,
Mr.
no, I
Bidwell,
think-
but I think it's a worthy conversation. In part, I'm asking because, as I've said in many different meetings, there's a lot of energy and emotion around the Office of Health Strategy. And there's a lot of energy and emotion, understandable frustration that people have had related specifically to the timelines on the process. And again, I think we all have talked about that here. We are interested in streamlining. We want to provide the kind of predictability too. So, you know, that's part of my question.
One of the things you'll see in our testimony is I think it would be interesting for the committee or whomever, the group of individuals, to look at our neighbors in New York and see how do they efficiently do this within 90 days. That's what they do. They do it within 90 days. And they do it regularly within 90 days. And so what is the process that they've implemented that allows them to do that? Not arguing New York's healthcare system is perfect, but they have a process that seems to at least cut down on the length of time for those applicants to get answers.
Okay, well, we can talk more offline about that. And I think I am interested in that. I'm also interested in comparing apples to apples to see what kind of resources that office has to be able to do that work.
Absolutely.
I think that's part of the conversation that's on us as a legislature, obviously.
It's, if you may, it's slightly off topic, but the sort of resources question and energy related to OHS, if you think about the cost growth benchmark, we compare ourselves a lot of time to Massachusetts. Massachusetts has a vastly better funded infrastructure for their cost growth benchmark program. So to your point related to resources and how do you resource a program that is supposed to be long lasting and meaningful, it does require a level of investment, I think beyond what we have done, which is investment in consultants. I think it's a different level of investment.
I really appreciate that answer because I could not agree with you more. And I think you're right that we will need to have a different level of investment. And it's a little bit of a conundrum because I think, you know, some of the frustration leads to a desire to not invest, but it's in many ways the opposite is we are going to have to invest in the ways we need to be able, in order to be able to move this work along. But I really appreciate this conversation and I'm looking forward to talking together with all of you, with all of the stakeholders. I think you've heard us here talk about the fact that we spent a lot of time last year with the Office of Health Strategy to try and get to a certain point. We did not spend as much time talking with all of you. And, you know, I'm hoping that we can bring together the stakeholders, at least in this session, make some progress, but talking about and with a vision towards what's that long-term plan in terms of a more comprehensive look. Thank you, Mr. Chair.
Representative Zupkus.
Thank you, Mr. Chair. Hi, thank you for coming. And my question was going to be if you had a magic wand. So I won't ask you to repeat that, but you did say, if I heard you correctly, that you get all these questions and they're never endless. And sometimes you have to agree to something that's not part of the CON. Could you expand on that for a minute, please?
So OHS, thanks for the question. So OHS has the ability to approve a CON, disapprove a CON, or what happens very frequently is say, well, let's have an agreed settlement on your CON, which then is generally a list of conditions for the approval. And in our estimation, OHS pushes for items in the agreed settlement that are not specifically related to the CON. So for example, they will say in the case of a change in ownership of facility, your commercial rates may not go above a certain percentage for a certain amount of time. We've testified quite vociferously that in Connecticut, Medicaid is underpaying, Medicare certainly underpays, and that is made up in the commercial market. And certainly OHS has a specific view about commercial payment. And in our view, they're then using CON to impose what in the CON process, what they have not been able to do or advance through the legislative process.
Thank you. And so then my last question, in your magic wand, what would you do to prohibit that from happening?
So I think we would build it right into the statute. There's a list of things that require a CON. There's a list of things that OHS needs to review or take into account related to CON. We think that should be the list, and we would build into the statute a prohibition on anything other than that.
Thank you. And your written testimony has all this written out?
It does, and we're certainly happy to provide what we think are amendments to the statutory language that would be helpful.
Great. Thank you so much.
Thank you.
Thank you, Mr. Chair.
Thank you. I've also made an observation that as soon as somebody says CON, Senator Gordon appears. I was looking this way and I said CON and Senator Gordon is sitting there. Thank you. So, Mr. Kidwell, I have a few questions too.
Sure.
Earlier this morning, we are having a conversation with Commissioner Gifford. And in the last couple of years, things have changed within the department. Through the legislative body, we did put some more resources, and the different types of resources. In the past, if anybody left OHS, those spots were not filled. We are filling them as a state, and I think we have put more money into the department as well. And Dr. Gifford mentioned about the timelines changing quite a bit. What is the experience on ground on that part? I'm talking about the last couple of years, not prior to that. And I think in my conversation with various hospitals, there's a low grade or a high grade PTSD with OHS during the pandemic and perhaps prior. So I'm more focused on the last year, 2 years time.
Yeah. So thanks for the question. I think that certainly there is an interest, and Dr. Gifford expresses it, to attempt to move some of these CON applications through the process more quickly. And for certain services, that may be the case. I think and I noted it earlier, the concern is that applicants are we have a difficult time understanding how each application is going to be viewed by OHS and what tools OHS is going to use throughout the process, and where we may need to make sure we are availing ourselves of every right throughout the process. And so if we could improve the timelines so that applicants understand that there are hard and fast deadlines and those are going to be met, I think that would go a long way. One, to expediting the process from both sides, so that each party has a sort of specific expectation about what's going to happen and what they should prepare for. And so I think Dr. Gifford has attempted to focus her staff in moving some of these applications forward, but I think there are instances where it's still unclear how processes are going to be used.
Thank you. I'm going to give you a couple of important questions maybe you can answer. You know, everybody, and I've spoken about this passionately in another committee, that everybody talks about cost of healthcare. Nobody talks about cost of insurance of health insurance. And if the cost of healthcare is going up, the cost of health insurance is going up at a very different trajectory and much more steeper trajectory. Why is it that an insurance company can one day randomly say, we are not going to cover anesthesia? And whereas a hospital says, I want to add 2 beds or 5 beds, and then you have to wait for like 6 months or a year to get that yes, and they can just wake up one day and say, today we're going to stop anesthesia coverage. Can you expand on this and your frustration?
It's enormously frustrating because, and so thank you for the question. There have been, days when we've come into the office and there's a hospital that they have reached their licensed bed capacity, and there are a lot of people in the emergency department. And there is no one to call to say, there's nowhere to put these folks. They have reached their licensed bed capacity. You can't call OHS and ask for an expedited process to increase the licensed bed capacity. And if you do, it's sort of we don't have the statutory authority to do that. And Senator, to your point, what is the hospital going to do in that instance? We have to treat the patients, or we look to divert patients from the ED to other hospitals that do have capacity, but we have to help manage the patients. To your point, we get edicts from the insurance companies all the time that say anesthesia is going to be changed next week, or we're piloting this in Connecticut to see what will happen. Right in the middle of someone's course of care, or as you're getting prior authorization for someone. Those are all things that have to be managed by the providers, by the hospitals on a day-to-day basis, while at the same time managing, I've reached my licensed bed capacity, what am I going to do? And it would be really nice to have someone at the state to be able to call and say, how can you work with me immediately to address the situation? And so that in our comments specifically to that is create this sort of temporary authority to allow for an increase in licensed bed capacity, and or to your point, create a ceiling. We suggest nine beds in 2 years that you can just increase, you can flex basically up to allow for those changes in volume.
So there's a mindset that the healthcare cost is primarily going up because of healthcare systems. And there's a lack of understanding that a number of costs are related to the insurance bureaucratic barriers. Who studies that, or who talks about that aspect and breaks it down? In other words, if Medicare Advantage requires you to keep the patients for much longer, and you're not able to provide a bed there, there's a loss to the healthcare system, and you need to have multiple different individuals who are fighting with the discharge planners and so on. So is there anybody who's doing data on that to see if that's increasing the cost of healthcare?
So I actually think that in the case of prior authorization, CMS over the last couple of years has actually taken a leading role in helping to improve that process, specifically in Medicare Advantage, to your point, because the federal government is paying for those all the costs that are going into that prior authorization. I will say at the hospital level, we have multiple people who spend all of their time getting prior authorizations and or fighting down codes from the insurance company, or looking for discharge. As you note, to the extent someone, it's interesting, you heard a lot of testimony about emergency department crowding today. Emergency department crowding is a symptom of the rest of the hospital not functioning efficiently, because there are people who do not need hospital level of care who have no other place to go. And that may be because of prior authorization, that may be because of a lack of someone at the home, that may be the probate issue that you're talking about today, and any number of issues. But fighting with insurance companies about whether a service is required and or prior authorization for someone to leave the hospital creates hundreds of millions of dollars in costs every year.
On another note, different topic. We have in Senate Bill 7, we're asking for a hospital administrator to be licensed. You know the emotions around that for the people because of what we are seeing with Trinity, that they're controlling from Michigan, or they sent a person from Michigan who is going to be expected to do certain things. They are harming the well-being of our patients in our state more than any physician, nurse, APRN, PA, all put together in the state of Connecticut. Why can't we license them and have them training for ethics to be able to say no when their administrator from another part of the country tells them that they have to do certain things? They say, no, I cannot harm my patients.
So in our written testimony on SB 7, we talked more about this administrator role. A couple of things. As written, the bill would require a vast number of individuals in the hospital to be licensed. And it's unclear if you're considering an individual type of license for each of those individuals or not. Right now, hospital administrators in Connecticut are required to have worked in hospitals prior and have certain qualifications. Additionally, I believe, if I recall correctly, the bill says that all of this has to be done by October 1st of 2025. Karen will correct me if I'm incorrect. The ability to license that many people from the end of session to now is incomprehensible to me. And the consequence of that is you don't have people in the hospital who can do their jobs. So I think hospital administrators today certainly take their jobs very seriously. And there are physicians running hospitals today in Connecticut, non-physicians running hospitals today in Connecticut. And I think in both those cases, those administrators are operating their hospitals in a way that is mindful to patient care. And I don't certainly view licensure as a cure to what could be specific bad acting, certainly in one case in our state.
Okay, I hear you. I do think there's a role to have a license because if I hear these horrendous stories, like chief nursing officer comes to one place and says that we can put 2 people in the ICU today in the same room. So this patient is having dialysis. This patient has C. difficile. What do you mean? So it's like there are individuals who went into administration because they were not good at some of the clinical work, perhaps. And now they're making decisions on the patient's well-being, which is, when you hear about those, they absolutely do not make any medical sense or nursing sense. It's important to have some kind of a check and balance, because they say we're a private entity, whether it's a private equity or a not-for-profit. They believe that they can do anything to a person who walks through the doors. That's where the issue is. And this is administrators, so who are checked at times by the staff, the medical staff and the nursing staff, who have to pay by their jobs by stopping these individuals who feel that they are above any existing rules because they have their own little kingdom at times.
So I understand the point, Senator. The Department of Public Health does license the hospital. The Joint Commission comes in and reviews operations of the hospital. There are conditions of participation for Medicare for the hospital. There are a lot of different reviews and checks to make sure that care is being delivered appropriately in a hospital today. So if your concern is specifically to activity going on in the hospital to ensure that safe, quality patient care is delivered, we have mechanisms today in place to ensure that that is happening. I think, as I noted, we don't think that a specific hospital administrator license is going to sort of get to what you're concerned with.
I'll stop back and forth on this topic. And the reason is that bad things are happening despite those checks and balances, so they aren't working. And we know many of the hospitals are being managed remotely or by administrators who are brought in by a helicopter. They come and do the things and then move to the next hospital. They destroy that one and then move to the next. That's what we have seen a pattern at times. So because that's what some of the larger centers are doing at this time across the country. And we're seeing a little glimpse of that in our state. Thankfully, we do have local hospitals with local leadership, and they are not renting the hospitals. They own the hospitals. They own the people in the community. So we see both mechanisms where, I'm just going to say it, Hartford and Yale are here to stay, and they do the right thing, and they are not doing the kind of things that some of the others are doing who are being remotely managed. And there's a very big difference in both of them, both of them, the types of setups. Yale is doing good, Hartford is doing good, and the smaller hospitals that have local management, they're doing okay from the value moral perspective. The others are falling up in the wrong direction, and that's why a bill like this would keep them in check. That's how I see it. But Senator Gordon.
Thank you, Mr. Chairman. Thank you for being here.
Thanks,
and I've read through the CHA testimony, so thank you for submitting it. I do have a few questions that struck me in the testimony, and I do appreciate the work that hospitals are doing. I know it's not an easy environment in general to operate in, but there is a couple items that I had some questions on, if I may. One is in testimony, it talks about what the CHA wants to consider, or in fact, see if it could be put somehow into the bill about streamlining the CON process by not requiring a CON for reduction in the number of inpatient or outpatient beds by 9 or fewer in a 2-year cycle. So if I read that, that means that no CON would be needed if 9 beds were determined by the hospital for whatever reason not to be needed, quote unquote. And then 2 years later, they can drop another 9. And every 2 years, they could just keep doing that if they wanted without a CON at all. Am I reading that correctly? Because one of the concerns I have is reduction in services. And that, to me, should be one of the things that we have CON for. I think in general, 99% of what CON is being required and processed by the Office of Health Strategy for expansion of services, one could argue may not be needed. We should be saying, thank you for expanding services. But that just struck me as a little interesting about CHA feels that no CON for reducing beds every 2 years on a 2-year cycle by 9 or fewer.
So I think it works in the inverse too, right? So it works with, if the hospital believes that it needs 9 more beds in that 2-year process, it would increase the bed capacity by 9 as well. I think what we're trying to get at is a process by which we can address fluctuations in volume without waiting for a CON application and process that may take up to 6 months. And so in the instance I was speaking of earlier, in which we're envisioning this, we've had instances here where hospitals have reached their licensed bed capacity, and they were not able to admit any additional patients until such time as the others were discharged, and their emergency departments continued to take patients, and or we had to find other hospital or emergency departments to take those patients. There was no one to call in that instance to say, can we increase the licensed bed capacity so we can accommodate some of these patients? And so I think it's providing some flexibility within the process to allow a hospital to manage its beds in a reasonable way. And, every 2 years seem reasonable to us. Certainly happy to work with you if you think there's a different standard.
I wasn't asking specific about increasing. I personally don't think if you want to increase your number of beds, we should have a CON for it. We should say, thank you for investing in increasing bed capacity. My concern is reduction. And I think anytime a service is to be reduced, let alone terminated, we should have a review of that. I can cite, for example, inpatient labor and delivery at several hospitals, Johnson Memorial, Wyndham, that may be beneficial for the hospital systems. They're not beneficial at all for patients and the communities at all, which unfortunately kind of gets pushed to the side in the calculation made by Office of Health Strategy. But that's my concern, is a reduction. So every 2 years, 9 or fewer beds could just be reduced. So technically you can have a scenario of a hospital saying, we want to reduce 9, 2 years later, we want to reduce another 9, and go accordingly and close a whole floor or a whole service. So that's just a concern I raised, but it sounds like.
Well, certainly, I think in that instance, Senator, if you were terminating a service, you would still need to go through the CON process.
Well, that gets to the second question I have, if I may, which is CHA has testimony that says that streamlining the CON process by not requiring a CON for the termination of inpatient or outpatient services due to insufficient patient volume or the inability to recruit or retain an adequate number of providers. So not only there would be not even needing a CON for that.
Yeah,
it just seems to be a continuum. And, is that what CHA is interested in? That if a hospital decides it wants to be reducing beds every 2 years, not talking about increasing, but reducing, which reduces service, or eventually terminating a service, wouldn't then need a CON? Am I reading
I
the
think so.
testimony?
Yes, and I think we're interested in making sure that what we have seen recently is in our view, an insufficient understanding of the ability to offer services when no providers can be recruited to provide the services, or there's no volume to support the service. And what we've seen are very lengthy processes by which those services were either required to stay open or accommodations made. And again, we think there should be some general improvement in the process or the ability for hospitals to make decisions that fit their ability to provide the service.
No, thank you. I appreciate the testimony. And I agree that there should be a stem to stern reform of the whole CON process, or the way at least it's being administered by the agency. But I do have serious concerns about reduction in services and not having some degree of oversight. It may work for the hospital, but it may not work for the community, especially rural communities where people then have to go to bigger hospitals that may already be overcrowded, not have enough beds or enough ER capacity. So I'm just concerned about how the dominoes fall if you streamline too much a CON process for reduction or termination of services. I think things can be streamlined, and I think other states do it. For example, other states can do it within 180 days for some real complicated decision making. But I just really worry about reduction and termination of services, just outright saying no CON. But I'm happy to have offline discussions about that. But that just raises concerns, to me, as far as that might go too far. And I see that as a proper way to make certain that we're trying to get services available to people in various parts of the state, taking into account that just because you may see point A and point B may be X number of miles away, that can be quite a distance in the real world trying to get from point A to point B.
Certainly.
So I just wanted to raise those concerns to make certain I was reading the testimony correctly, but I appreciate you being here, and you do have a number of other good items in your testimony. Thank you, Mr. Chairman.
Thank you, Senator.
Thank you. Seeing no other questions or comments, we thank you for your testimony and the time with us. That'll bring us to the next person, which is Cassandra Lair, followed by L. Palmer, and then we will have Liz Gustafson. So Cassandra Lair, you're on. Thank you for your patience with us. I know you've been waiting for a little while, so please go ahead.
Great. Good afternoon, Senator Anwar, Representative
Fahey, and distinguished members of the Public Health Committee. My name is Cassandra Lair. I am a Hartford resident and a board member for the REACH Fund of Connecticut, Connecticut's only abortion access fund. I am here today to express REACH's strong support of SB 7. The REACH Fund was founded by a group of abortion patients, providers, and advocates who understand the significant barriers to accessing abortion care in Connecticut. Since 2022, we have provided nearly $200,000 in financial assistance to help over 600 people access this essential health care. REACH not only contributes to care for folks at Connecticut-based clinics, but also supports Connecticut residents who must travel out of state, most often due to being impacted by Connecticut's arbitrary 24-week abortion ban. Later abortions are extremely expensive, and the cost does not include travel, lodging, meals, childcare, and other expenses. Despite Connecticut's reputation as a wealthy state, we have one of the largest wealth gaps in the country, with nearly 40% of Connecticut households living paycheck to paycheck or below the federal poverty line. Additionally, people seeking abortions may have a high insurance deductible, may need to pay cash for safety reasons, or may have federal insurance which specifically excludes coverage for abortion. While we have strong community support, REACH is primarily grassroots funded, and we sometimes have to pause funding or go over our monthly budget in order to meet the need. SB 7 is an essential investment in the sustainability of abortion and practical support funds, such as REACH, as well as nonprofit organizations serving our LGBTQ+ communities. The proposed Connecticut Safe Harbor Fund would help ensure REACH's sustainability and assist us in making sure abortion seekers can access the healthcare they need by providing financial assistance for practical and logistical costs. Additionally, the current uncertainty regarding federal level policy poses a threat to patients' ability to seek timely, life-saving care, even here in Connecticut. In the face of federal threats, it's essential for our state to clarify and codify protections for emergency care, including emergency abortion care. Passage of SB 7 would reaffirm our state's commitment to protecting the provision of and access to emergency pregnancy-related care, and will also protect our providers at all healthcare institutions who offer medically accurate information, counseling, or referrals for this care. Abortion care is healthcare, and healthcare is a human right, a right that the government has a responsibility in protecting for all of us. Abortion funds like REACH help meet a need created by the restrictive landscape of abortion access, a need that should not exist in the first place. Connecticut, at the absolute bare minimum, has a responsibility to protect patients who need access to time-sensitive, life-saving pregnancy care, including abortion. The REACH Fund strongly supports SB 7 and respectfully urges the Public Health Committee and Connecticut General Assembly to vote favorably. Thank you for your time and consideration.
Thank you so much, Ms. Lair, for your testimony. Would you be able to share the kind of situations that your fund had to provide support to people?
Yeah, so although Medicaid, Connecticut Medicaid does cover abortion services, there's still patients who seek care who have large deductibles through their private insurance or through their healthcare exchange. There are patients who do not want to go through their insurance because they're on a family plan and risk other people knowing about their abortion, therefore needing to pay out of pocket and not having the ability to do so. And we also help Connecticut residents leave the state of Connecticut when they're past our gestational ban of 24 weeks.
Okay, thank you so much for your testimony. We appreciate you being here today. That brings us to the next person, who is Al Palmer. Welcome. Thank you for being with us. Press the button in front of you. There we go. You're on now.
Thank you. Good evening, Mr. Chair, Madam Chair, the members of the committee. My name is Al Palmer. I'm testifying in opposition to SB 7. I'm here to share my experience with gender-affirming care as a detransitioner. Because this bill mentions support for gender-affirming care several times, I believe it's important to hear testimony from the other side. 10 years ago, when I was 15, I came out to my parents as a transgender boy. 1 year later, I was prescribed testosterone at Planned Parenthood. I was 16. I told the doctor about my traumatic female puberty with debilitatingly painful periods, severe suicidal thoughts, and self-harm, and anxiety so bad that I dropped out of school. I told him that I went to a children's mental hospital 3 times before I was 14. You might be surprised to hear that the doctors, nurses, and therapists not only knew these things, but they believed the root cause was due to my internal sense of gender identity. Transition was supposed to be the cure. Not even a history of sexual abuse will stop these medical professionals from putting a young girl on testosterone. Even if I had known testosterone would give me prediabetes, high blood pressure, early onset osteoporosis, and an increased risk of sterility, I wouldn't have said no. In my mind, there was no other option. It was transition or die. This myth persists in the LGBT community 10 years later. You'll hear supporters of this bill call this life-saving care. When I was 19, I went back to Planned Parenthood. I told them I was female to male, but I wanted to go back to female. They didn't know what to do. As weeks turned to months, eventually, every single doctor had called me back saying, I don't know, maybe another doctor can help you. Planned Parenthood could easily put a teenage girl on testosterone, but no one in the entire state knew how to treat a woman who just wanted her female body back. For years, I couldn't live a normal life as a woman. For the first year of my detransition, I looked like a man wearing a bra. Can you imagine being a 20-year-old woman that people mistake for a man? The amount of times I was called sir left me thinking I would never be seen as female again. Almost 6 years later, I still have a deep voice, and some people still call me sir. I was only on testosterone for 3 years, but this effect is permanent. I started taking prescribed steroids for a mental illness at age 16. This is not life or death. A teenage girl does not need testosterone to survive. This is what's happening here. This is what you need to vote against. Please oppose this bill so other detransitioners like me who didn't understand the life sentence that they signed up for will still be able to seek the justice that we deserve. Thank you.
Thank you so much, Al Palmer, for your testimony. I wanted to thank you for taking your time and staying with us and speaking about your experience, because it takes a lot of courage. And I know it's not easy for you to come and speak to us. So we truly appreciate you being here.
Thank you.
I have some questions, but I know my colleagues have some. So Representative Zupkus, you want to start?
Thank you, Mr. Chair. Thank you, Elle, for coming. It's, I have to admit, we always hear the opposite, right? And so I greatly admire you for coming and testifying, because I know you're not the only one, right? I
Yes.
know there are many of you out there, and sometimes they're scared to come and testify or face us or Planned Parenthood or whomever. So thank you. It takes bravery and courage to do that. But I am going to ask you because this is the talk now, as you know. So what would help someone like you? What could, because it's always in the laws and people wanting to do the opposite.
Right.
So from your point of view, how do we help girls like you? How do we help people like you?
That is a great question. Across the country right now, this is being legislated on more than ever. I just went to Montana last week, which is where I'm from, to testify on a bill that's extending the statute of limitations for the ability to hold medical providers accountable up to 25 years past the date of medical affirmation. So I think one of the big ways that the government can step in with this is extending the statute of limitations for the ability to sue, hold these doctors accountable. That's going to make a big difference. the statute of limitations right now in Montana is only 2 years past realization of medical harm. So 25 years is obviously a big step up from that. For things like gender transition, realizing the harm that's been done to you is not an immediate thing. There's, surgeries where they might get an x-ray after and realize that a medical instrument was left inside of you. That's obviously a case where you can sue immediately, right away. You could go find a lawyer, but for realizing that you were harmed by a gender transition, it could take years to realize, the real permanent, long-lasting effects, the mental effects, like figuring out what you need to hold the doctors accountable for. You can't do that right away. So that's one very important thing that I think needs to be legislated. Another very important part of detransitioning is seeking medical care after the fact. So I have a lot of friends who have detransitioned who had double mastectomies and want to seek breast reconstruction. And we currently do not have any insurance billing codes. There are no specific codes for detransitioners right now who want to go back to their birth sex and receive hormone treatment, for example, if they had their ovaries removed, or breast reconstruction. So those are the two big things that we're trying to legislate right now.
Thank you. Just if I may, so I really believe in parental consent. And not this in a lot of things.
Yeah.
And I always get pushback that, parent might be mad and they might, and I'm sure their parents that do. I'm not saying that, but I'm a big believer in parental consent, no matter what. And so some of my questions have been, number one, should there be parental consent under a minor? And what about minors? I mean, in this building, we sometimes it's under the age of 18, you're considered an adult, or 22, 21. It kind of fluctuates depending on what the discussion is. And so I'd just like to know really quickly, what do you think about parental consent and the age?
Yeah. So as far as my story goes, like I said, I was 16 when I got on testosterone, which required parental consent. I think a big problem still to this day is that a lot of parents are not educated properly on this before agreeing to let their child transition. I think there's a lot of misinformation that gets passed around from medical providers, from therapists, people who are kind of ideologically captured, who support this no matter what. Even going beyond individual circumstances, like all of the things that happened to me, there was no consideration for past sexual abuse or mental illness, being hospitalized, suicidal. There was no consideration that might have been a reason to step back and say, what's going on here? A lot of parents are just being misled into thinking that their child will kill themselves imminently if they are not transitioned. So my parents were scared. They did not want their child to die. So they agreed to let me take the testosterone because I told them that was what I wanted. I went to a therapist. The therapist affirmed me and said, your child is a boy. Your child needs testosterone. The doctors that we went to said, okay, the therapist said this, your child's saying this, obviously it's true. There was not really a lot of thought that got put into this. So I think the parents are being misled. I think that's a big issue. I think they should definitely have to consent. I mean, point blank, that's definitely how it should be. But even the parents that do consent, they're not really fully informed on what they're consenting to. And as far as the age that minors should be able, or that people should be able to transition, I've noticed personally a trend with a lot of my detransitioner friends where we were 19, around 19, when we realized that we needed to detransition. I think at least 20 should be the age that people need to get to before they start the transition process. A lot of people have different opinions on that. A lot of people say 18, that's when they're an adult, they can do what they want. But I do think it should be a little older.
Thank you. Thank you for that. And I'll just leave it with, I had friends and their neighbor, their son was about 3 and hung out with all girls, was a little boy. And he used to run around in ballerina tutus and wanted to do everything the girls wanted to be a girl. And later on in life, he didn't want to, he didn't talk about transitioning because it wasn't as much talk as it is today. And, I do think about him often, and now he's a big rough and tough like football player and all that. And we tease him a little bit, but, if parents are misled, which I believe you, I believe not all the information is out there. It could have been another person like that. So just thank you again for coming. It's really good to hear your point of view, and hopefully this committee will take that to heart.
Thank you.
Thank you, Mr. Chair.
Thank you. So do you have a written testimony that you have submitted?
Yes, I just submitted it right before I went on.
Okay, good. Thank you so much. That would be helpful. So let's go back in time for a second. And when you were transitioning, you in your testimony said that you were suicidal. And I'm sorry to have to ask you this question. So if you feel it's triggering and bothersome, we don't have to go through this. But when you were going through that process, what was your conversation like with your parents?
Yeah. So I had been experiencing suicidality for a few years at that point. It didn't start with me wanting to transition. It was already there. I had attempted suicide several times before I ever came out as trans. So my parents had been dealing with that for a few years, and that was the reason why I ended up at the mental hospital 3 times. Kind of trying to start fixing those problems, and like my depression, I was on a lot of different psychiatric meds. So I was pretty used to being suicidal at that point. I had actually started to get a little bit better when I was 14 before I found the trans community. But then when I joined these online spaces that I was in, I had dropped out of school at this point. I didn't have any friends in real life. So I spent pretty much all day, every day on the internet, on Reddit and on Twitter, where I was surrounded by the trans community. And after my depression had already started lifting a little bit and I had kind of started to get into more of like a normal headspace, I was kind of pulled back into this depression and this suicidality when I joined the trans community and started overthinking about things I didn't like about my body, and, this desire slowly overtaking me that I needed to become a boy and that I needed to transition. So it was a pretty gradual process. But by the time I had a conversation with my parents, I was fully convinced already that I was a boy and that I needed to transition. So it took them by surprise. It shocked them. They had no idea that I was feeling this way. And by the time I had a conversation with them, I already had decided that I wanted to go on testosterone. So since I had been in the trans community at that point for at least 6 months, I had pretty much been given a script of what to say to my parents and to the doctors and to the therapists to get them to put me on the path to transition. So when I was feeling the way that I was feeling, fully convinced that I was a boy, obviously that came with a lot of big feelings. And it's hard to go back to that mindset now when I just think like, how did I ever feel that way? Like sometimes it doesn't really make sense to me that I felt so strongly about it, because I just can't even imagine that feeling anymore. But I know for sure that I went to my parents and I said, like, I want to die. Like, I want to become a boy. And if I don't become a boy, like, I'm going to die. Like, I remember saying that to them. And I don't know how I would respond to that. You know, if I was a parent, I have no idea. Like, obviously, they didn't know.
Yeah.
So yeah, it's very, I'm sure it's very, very difficult, you know, to make the decision.
Right. And Al, thank you for sharing this.
Yeah.
I know it's not easy and it's not easy to share it in public, your pain and the suffering that you may have gone through at that time as well. Um, the reason is that when a child, no matter what age they are at, but you're around 16 at that time, when a child has suicidal ideation, it's devastating for a parent. I can't even imagine what a parent would go through, and the parent would do anything for them, give their organs, give their blood, give anything for that child. So, um, and I'm trying to, we look at decisions based on what would you do if you were to go back in time, not having the luxury of where you are right now. And then we also look at the probability of how many individuals who have gone through transition require to retransition. And this is where the arguments would be different from different people. Some people will say that's a small minority like yourself, and others will say, well, that's everybody like you. So we don't know the answer, but we will look at the studies to conform to our preconceived notions. Having said that, the bill is saying that if somebody is going through that problem or situation that they are wondering about and they feel so strongly about the transition and they cannot be in that place and they would harm themselves, and they talk to their parents and the parents say, we will do whatever it takes to help you. And if they happen to live in part of the country where everybody who even thinks about this will be criminalized, would it be reasonable to try to do whatever you can to save that child and say, okay, if we don't have to pay out of pocket, we are right here, and come to Connecticut where a philanthropy is going to help us just to come over here and then get somebody who deals with this. Again, there's a process that's outlined where there's a psychiatrist who goes through this, the evaluation of an individual, make sure they're undergoing any treatments. So that's part of what the bill is talking about. Whether there is a medical part of retransitioning or transitioning, there needs to be some support for individuals who are going through a very difficult and perhaps existential crisis. Do you hear what I'm saying?
I do. I do have a few comments if you
Please do.
if you may.
Yes,
Okay.
yes.
Yes, I totally agree. I think that there should be multiple safeguards. I think there should be multiple processes through which we try and, you know, discover, is this treatment really needed? You know, is this the right thing to do? And I think that the processes of seeing psychiatrists and seeing doctors and all of that, I think that's great. I think that's necessary. I think that is how it should be. The problem that we have right now is that doctors and therapists and psychiatrists are ideologically captured. And what I mean by that is what they are taught to do is affirm. They're not supposed to ask questions. They're not supposed to challenge. When somebody, especially a child, comes to them with a gender identity, right now the protocol is not to say, but what if you're not? Right now the protocol is, that's conversion therapy. And that's what we're dealing with is, you know, the like in my case, and this was 10 years ago, I'm sure that it's everywhere now. My therapist was a gender therapist, but that meant that she was already educated by the LGBT community on how to deal with a trans client. And what that meant to the LGBT community was you affirm them. You say, I can see why you think that you're a boy. I can see how your story, you know, it is accurate. You know, I can see that you feel very strongly that you are a boy. These are all the reasons you've outlined. This is why you want to transition. Like all the pieces line up. But there was no questioning. There was no deeper assessment. I think that's the big problem right now is we need more gatekeeping. We've gotten rid of a lot of the gatekeeping that there used to be for people who want to transition. We've replaced that gatekeeping with affirming.
So, Al,
Yes.
you're so sure about these protocols. Have you seen those protocols? It's just your assumption?
Well, here's the thing. There's not a lot of good information out there on studies and on research of this. What little we do have is that more and more young people are being pushed through this system, which is an indication that these gatekeeping protocols are being
So
lessened.
that's your assumption then. It's not based on any fact. It's just your assumption.
There are more recent studies that have shown the rates have gone up of young people transitioning.
No. In other words, what you're saying is that in Connecticut, if somebody's feeling that they do not go through an appropriate process of checks and balances, it's just like, oh, this is what you want, we'll give it to you right away. But that's probably generalizing something that I know for sure is not that way. But in your perspective is that that's how it's happening, but you do not have any proof of it. It's just your perception.
Well, I'm not in the medical field, so I can't say, you know, whether that's true for everyone or
I'm
not.
just trying to clarify your statement because you made a statement that these are the protocols, and I know these are not the protocols. I'm trying to help navigate what made you think those are the protocols. That's what I'm trying to clarify.
Okay. Yeah. It's just based on the experiences that I've seen and heard from a lot of the detransitioners that I know those were our experiences.
Yeah.
So yes, of course, I can't speak for everyone and I can't speak for how how it's outlined and everything like that. And, for the professionals who are doing this, but that is definitely our perception of what happened to us.
I want to thank you again for being here, and thank you for your testimony. I appreciate you. And I just want you to know, as this committee, we accept you, who you are, where you are, and what phase and difficulties and challenges you're going through.
Thank you.
Thank you.
I appreciate you hearing me.
Okay. All right. That brings us to the next person on the list, which is Liz Gustafson. Welcome.
Good evening. Senator Anwar, Representative McCarthy-Vahey, and esteemed members of the Public Health Committee. My name is Liz Gustafson, and I am the Connecticut State Director for Reproductive Equity Now. Thank you for the opportunity to testify in support of SB 7. Reproductive Equity Now works in Connecticut and across New England to make equitable access to the full spectrum of reproductive health care a reality for all people. Our state continues to make significant progress to expand access for patients seeking reproductive health care services, as well as protect our state's providers who are doing all that they can to care for their patients and offer medically accurate and compassionate care. In order for us to continue meeting this moment, it is paramount that we continue our bipartisan efforts to break down barriers faced by patients and protect the providers who are offering this life-saving care. Just as Connecticut led the way by enacting the nation's first SHIELD law to offer a critical layer of protection for patients and providers, SB 7 would follow through on this promise and commitment to protecting and expanding the provision of and access to care by 1, establishing the Connecticut Safe Harbor Fund, 2, creating a state requirement for hospitals with emergency departments to provide stabilizing emergency pregnancy-related care, which includes abortion. And 3 would also protect providers at all healthcare institutions from facing reprisal for sharing medically accurate information or counseling their patients or for making referrals. Any delay in seeking time-sensitive reproductive health care, including pregnancy-related care, is a threat to public health. Institution-wide policies that inhibit providers' ability to follow clinical guidelines and provide medically accurate information, counseling, or referrals not only undermines the patient-provider relationship, but undermines the patient's agency when it comes to making an informed decision. Additionally, with the current administration recently dropping the EMTALA lawsuit against Idaho, signaling enforcement of existing federal protections may cease, patients who may require emergency life-saving care are especially vulnerable, including here in Connecticut. Providers must be able to empower their patients with the medically accurate information and resources to make fully informed healthcare decisions, as well as referrals for relevant or recommended services available in the community. And additionally, Connecticut must implement measures and statewide level protections for patients needing this emergency pregnancy-related care, regardless of which emergency department they are presenting at. And so with that, Reproductive Equity Now urges the committee to support SB 7. Thank you so much.
Thank you. You saved like 20 seconds on your testimony. We'll
timed myself
we'll put
today.
this in the bank. So thank you so much for your testimony. And you want to start first? No, I wanted to thank you. There's a lot of conversations around this topic that we've had, and EMTALA makes perfect sense, right? It's a straightforward thing, and at least in my understanding, there is a sense that that fund that we are talking about to provide support, it is being used for providing the medical care, and there's an open door, and I think people may not have read it the way it was intended, and then maybe it was legal language that did not clarify things. Are we opening the doors to do more surgeries, or are we doing changes in the existing laws on gender affirming care that we in this bill?
No, those funds, as the bill is drafted, would be for practical and logistics support. So that is transportation, childcare, things like that, not medical care. And we would not be opening the current statute on reproductive health care or gender affirming care.
Thank you for saying that, because many of the people who came and testified, they were reading that inaccurately. And I think that caused a lot of confusion and emotion for the people who feel that we are restarting the debate, like we may be changing something. So, and also I think there was the way the bill was written. So we have said that many a times that we are not using public funds. Is that what your understanding as a proponent of the bill is too?
Yes, it's my understanding that it is private donations, and then that money would be allocated directly to nonprofits and service providers via the governing board of trustees.
Right. And in your experience, what are the anxieties and difficulties people are facing in other parts of the country? And we do hear about deaths among especially the women who are in minorities or have poverty. They're dying in other parts of the country right now. Can you speak to that?
Yes, so the overturning of Roe and also the current we're getting signals from the current administration in that they may not be in the business or intend to enforce EMTALA, so these federal level protections for emergency related care. Also with the overturning of Roe, there's been a nationwide chilling effect too for providers across the country, not understanding what their legal ability to provide that care is, both because of the overturning of Roe and any subsequent restrictions or bans that may have been passed, while also at the same time, EMTALA still existing. So recently, the current administration dropped the case against Idaho because Idaho was enforcing and now is an abortion ban. And after the overturning of Roe, the previous administration did put out a memorandum, a memo clarifying that even if you have an abortion ban or restriction, federal law supersedes your state ban or restriction, to ensure that people who have emergency pregnancy-related complications receive stabilizing health care.
Do you know much about the viability law in the state?
I'm sorry?
The viability law for the state of Connecticut?
So
Yeah.
what about it?
Can you tell us a little bit about that? Yeah.
Yeah, so sorry. So we do have we have codified the protections under Roe, but our current abortion law rests on a viability standard, which is not a medically agreed upon or medical term. That typically refers to around 24 and 6 weeks. But currently in Connecticut, because of this viability framework, I'm not going to remember the specifics, but it is written that abortion is banned after viability, except for the life or the health of the pregnant person. And so when it comes down to folks seeking care later in pregnancy, it is not the provider, it is not the person in need of this care, it is hospital lawyers, administrators, coming between a provider and their patient and their ability to get that care that they may need.
Have you seen anything in this bill that's changing that?
No.
So is this bill also saying that a Catholic institution will be required to do something differently than they are doing because of the federal law?
No. This would not require any affirmative actions by healthcare institutions or compel individual providers to provide care that they either have personal, religious, conscious objections to providing.
So I'm just going to say this and I'll be careful how I say this. I think the word gender affirming, abortion, and other terminologies just trigger people in our communities on all sides of the equation. And we read more than what's written, and we react more than what is required of that law. And then I think sometimes I see that, unless the other possibility is that somebody's providing misinformation to people, I'd rather not say that and not believe that. I think people emotionally get triggered by that, and they feel and they go to their corners without going into understanding what's happening. Because right now, the word on the street is, well, we are changing and taking the rights away from Catholic institutions in this bill. We are also promoting abortion in the third trimester. We are talking about changing the gender affirming and taking the rights away from the parents. These are the classic talking points that make everybody scared and worried and respond in a manner. And I think there's no such thing in these bills. And many of the people who have testified, they feel that's what's in these bills. They feel it, they've not read it. And as we are listening to the testimonies, both me and my co-chair are saying that they did not read the bill. And that's part of the difficulty that we have, is that people are speaking about the bill without actually reading it. And that makes it a little tricky for us to counter every line by line and say, no, you didn't read the bill. But I'm glad we have the opportunity to clarify some aspects, and that's helpful. So thank you for your testimony, and thank you for what you're saying, Madam Co-Chair. Representative Zupkus.
Thank you, Mr. Chair. Hi, thanks for coming. So you mentioned it's all private donations?
That's how it's written.
Right. And so if it's private donations, why would it be in this bill?
That is a question for the treasurer. And I would say it is also a recognition that Connecticut supports people who may have a financial need accessing this care.
Okay, but it would still be private. I guess that's kind of what I'm thinking. Why would the state, I mean, that would be like you make a donation to the state and the state's kind of holder of the money, but I mean, in most, you're a nonprofit, I'm assuming. Are you a nonprofit?
We're a 501c3 and a 501c4.
So you would get you get private donations all the time, I would think.
Yeah.
Yeah. So I guess I'm just asking, I'm trying to think why, if it's private donations, why does it need to be at the state from a nonprofit standpoint? Because I'm wondering also if someone makes a donation to the state they would have to donate it. Like if you make a donation through United Way, you have to say for X, Y, or Z nonprofit, right? So it would be the state taking money, saying it's specifically for this organization. And I'm not even sure that the donor would get a write-off, a tax write-off. So maybe that's just a question for our chairs, or I just find it interesting that it's private donations going to the state for an organization that's not associated with the state. Thank you.
Yep.
Thank you, Mr. Chair.
Thank you so much. I'll attempt to answer the questions, and that's not based on my understanding. This is actually direct questions, and the testimony, the written testimony for the treasurer is available, and it speaks to that as well. The treasurer's perspective is that this is once this fund is created, they will be able to accept money from various not-for-profits or individuals who are willing to contribute. That would be there. And the fact that it's going to be part of the state is actually a statement on behalf of the state that we value this issue and we respect the people who are in need. And we as a state are taking that position. So that's the rationale for having it as a state rather than a non-governmental organization. We've already heard from some of them that are actually already doing this work. So it's more of a statement on the behalf of the state. Seeing no other questions. Oh, sorry, Senator Gordon.
Thank you, Mr. Chairman. Thank you for testifying. I've been a supporter, just not as a senator, but as a doctor of EMTALA for many, many years. So I can certainly understand why we want to continue the basic provisions of it. I don't know if you were here when the treasurer testified, and I asked some questions of the treasurer. Question I have for you is, you're not advocating at all for the use of any public or state funding for the account that would then be overseen by the treasurer, I guess really the board that the treasurer, I'm assuming, would be part of or be working with. Is that correct?
I am testifying in support of how it is currently written. So yes.
Okay, well, it's currently written. I asked the treasurer this, and the reason I'm asking is that it does talk about that it shall contain any monies required by law, which means perhaps the legislature by law could at some point require state money to be put in. But it also talks about public contributions. When I did ask the treasurer about that, he had told me, quote, unquote, that he would then be comfortable removing that wording, so to speak, in order to make it very clear that it wouldn't be any type of public or state funding. That's separate from the merits of the account. I was just talking with the treasurer about the logistics, the process. If that were to be the case, that wording were to be changed, so it's very clear that there is no public money, there is no state money, there would be private donations, as the treasurer made very clear is what is the clear intent, and it sounds like that's what you're advocating for. That would be okay?
I think any opportunity for there to be more of an investment, whether private or public, towards ensuring people have the financial support they need to access the care that they need, we would be supporting that.
Well, thank you for the answer, Mr. Chairman.
Thank you. Seeing no other comments and questions, thank you for your testimony and staying with us for today. Next person on our list is Christina Bennett. Ms. Bennett, thank you for your patience with us. Welcome.
Thank you for having me. I would like to speak in opposition to SB 7 and specifically the Safe Harbor Abortion Fund. Connecticut has made many statements. The fact that we allow abortions up to 24 weeks, our viability is making a statement. The fact that minors can access abortion without notifying their parents, without getting consent, makes a statement. The fact that our taxpayer dollars pay for abortion through Medicaid makes a statement. I think it is very clear that Connecticut is a pro-abortion state, or a state that fights for abortion access. I think this statement is clear, and we don't need to further this statement by allowing this private abortion fund. It's interesting that it's called Safe Harbor, because I actually think it's pretty dangerous. And I want to bring stories forth from women who have suffered pain from abortion in Connecticut. One woman is Shanice, who I worked with, who is a resident of Connecticut, was going to school in DC, got pregnant, was coerced by her boyfriend, came back to Connecticut to get an abortion so it would be paid for by insurance. She went to Planned Parenthood in Bridgeport. She took the abortion pill, and tragically, there were fetal remains left inside of her after this abortion. She went into septic shock, and she was hospitalized in Connecticut for 30 days. She was put in a medically induced coma for a month. And after she got out of this medically induced coma, she had to have a partial hysterectomy, and she lost her fertility in her early 20s. This is one story. There are other stories. Now we're thinking of bringing women from other states to Connecticut and paying for their travel, paying for the abortion through private donations. And yes, I know people are saying it's private, so it's not us paying, but as stated multiple times, there is the possibility, because of what was said in the legislation, that there could be an open door for taxpayer funds to go towards this. But I think it's dangerous for many reasons, because what if there's a complication? What if the woman who came here from Texas to get an abortion, like Shanice, has to go to the hospital for 30 days because of septic shock? Who pays for that if she can't pay for an abortion? Are the private funds going to cover that? What if she goes to the airport and she's bleeding because she has a perforated uterus? What if she changes her mind but feels pressure because these private funds brought her to this place of Connecticut to have an abortion? And what if at the last moment she doesn't want to have one, but she feels pressure because she's already feeling obligated? That happened to my mother. She went to have an abortion at Mount Sinai Hospital in Hartford, Connecticut, because she was pressured and coerced, but she changed her mind at the 11th hour. But it was very difficult for her to leave the abortionist office. She said, I changed my mind. And he said to her, you've already paid for this. Now she ran out, and I discovered this story while in college at Southern Connecticut State University, which changed my life and caused me to advocate for women and families. But this is dangerous, and it prioritizes the abortion industry, basically making the treasurer a fundraiser for Planned Parenthood in the abortion industry.
Excuse me, Ms. Bennett, but you're exceeded your 3 minutes. You've reached your 3 minutes. Thank you.
Please consider the things that I brought up, and please consider opposing SB 7 in regards to the Safe Harbor Fund.
Thank you. Thank you, Ms. Bennett, for your testimony. We appreciate you staying with us. I know it has been a long wait for you as well. So thank you for your passion, and thank you for your testimony. Seeing no questions or comments, we move to the next person on our list, which is Dr. Bubu Benini. Welcome.
Thank you so much. My name is Dr. Bubu Benini. I'm the Translational Research Director for Metabolic Health and Weight Management, and also Associate Director for the Clinical and Translational Core of the Yale Liver Center. Thank you for having me today to testify on Senate Bill 1537. So non-alcoholic fatty liver disease, which has now been renamed metabolic dysfunction associated steatotic liver disease, or MASLD, is a growing public health concern in the US and also worldwide. It's popularly known as fatty liver and typically occurs in individuals with metabolic risk factors such as obesity, diabetes, high blood pressure, and other cardiometabolic risks. The prevalence of MASLD in Connecticut is not known, but the presumption is that it closely estimates that of the US population, and essentially 1 in 3 Connecticut residents, which is 1 in 3 Americans, is estimated to have MASLD. A subset of those patients will then go on to develop the severe subtype of the disease, which is MASH, characterized by inflammation of the liver that over time can develop into end-stage liver disease and liver cancer. So really, the time to act is now in terms of educating our populace about this liver condition, as well as other liver conditions, and helping them achieve healthy lifestyles and also treating the disease before it progresses. We also know that there are other risk factors for liver disease, such as chronic viral hepatitis and alcohol use, which all contribute to progressive liver disease over time. So I'm here today to support Senate Bill 1537, especially to create the Connecticut Liver Health Day, which will essentially educate people about this condition and other conditions that cause chronic liver disease and help them to improve their lifestyle and also decrease the risk of getting this. And I want to thank you again for letting me testify today, and happy to take any questions.
Thank you so much, Dr. Benini, for your testimony, and thank you for serving on the task force along with Dr. Mehel, and a lot of good work and the conversation. I was glad to be part of many of these conversations, and I felt it's worthy to implement some of your recommendations that will hopefully save lives. I see my co-chair has a question or a comment, so Representative McCarthy-Vahey.
Thank you very much, Mr. Chair and Mr. Chair. Dr. Benini, I just wanted to echo the comments of my good co-chair, and thank you for your leadership report on this issue. I learned a lot about this, and it's clear we have to raise the awareness even more so that people understand the risks. And thank you for being here with us today.
Thank you so much. It was my pleasure and honor to serve on the multidisciplinary task force and to co-chair it. And I'm happy to provide any further help and service for this cause.
Thank you. So Dr. Benini, we may reach out to you because as we move forward with this bill, there is a possibility that the cost may be too high. We will have to start to make priorities and then see what other things that we need to do. And some of the things would be logistically very difficult for the Department of Public Health to implement. It clearly is an issue that we need to address. It clearly has some of the parts of the recommendations. We can probably do them within this session. But there's a probability that we may not be able to do all of the issues that the committee has raised for the data and collection of that information. But
Absolutely. I agree. I think that it's going to be really all hands on deck and involving organizations and other groups that really have an interest in helping decrease the prevalence of liver disease. So, for instance, the American Liver Foundation, who we spoke with during the time that we were drafting the recommendations, really are very happy and excited to be part of this effort.
Good. So seeing no other comments or questions, we will move to the next person on our list. Thank you for being with us today.
Thank you so
The
much.
next person is Lisa Maloney. Welcome, Ms. Maloney. Thank you for your patience with us. You're on.
Thank you. Senator Anwar, Representative McCarthy-Vahey, and the distinguished members of the Public Health Committee. My name is Lisa Maloney. I'm a licensed therapist and Executive Director of Anchor of Hope and the President of the Connecticut Pregnancy Care Coalition. I am speaking to express my opposition to raise bill number 7 as it is written. This bill proposing to spend $30 million, I understand it's private funds, to cover elective travel expenses for elective procedures such as abortion, gender affirming treatment, not just for Connecticut residents, but out of state individuals. This is an irresponsible use of funds at a time when Connecticut families are struggling with rising costs, underfunded schools, and strained healthcare system. Connecticut's first priority must be its own citizens. The procedures referenced in the bill, particularly gender affirming treatments and abortion, carry serious risks. Studies that show post-abortion complications can include mental health struggles, including depression and anxiety. Puberty blockers and cross-sex hormones have been associated with long-term medical concerns, and the research is still out there and not complete. It's too soon. One of the most misleading narratives used to justify bills like this are the false claims that abortion bans threaten access for miscarriage treatment and ectopic pregnancy treatment. Let me be clear. Treating a miscarriage or an ectopic pregnancy is not an abortion. It is a necessary medical care. States with strong pro-life protections continue to allow these life-saving treatments. Using these tragedies to justify unrestricted abortion funding is not only deceptive, but deeply harmful. With the increase of use of the abortion pills, we will see an increase of trauma to women who will be delivering a dead fetus at home, and when calling their abortion provider, they are told to flush the fetus down the toilet. These are the calls that I receive on a regular basis at my office in New London, as they don't know where to turn for help. Race Bill 7 opens the doors to some dangerous things. I urge you to reject this bill and stand up for the policies that protect the Connecticut residents, uphold our constitutional rights, and ensure ethical use of our resources. Thank you.
Thank you so much, Ms. Maloney, for your testimony. I didn't want to interrupt you. The 30 million is not related to the other part that you're worried about. It is for emergency situations that may develop, but it's not at all about the aspect. And I think you probably may have heard multiple conversations throughout the day about the use of public funds. That's not going to be part of the bill. So sorry about the confusion, but I wanted to clarify so that at least you are aware and then others are aware that the part of the 30 million is for other emergency situations, nothing to do with the gender affirming care and other components. Thank you for your testimony. We appreciate you being here and appreciate you taking the time to testify. We will move to the next person on the list, which is Sally Grossman. Welcome, Ms. Grossman, you're on. Yes.
Grossman, but that's fine.
Yeah.
Hi, my name is Sally Grossman. I'm from there, and I'm providing testimony in support of SB 7. So I've testified for a few bills this legislative session, including before this committee. And this is not the first time that Connecticut has had to step in and protect the people in our state because the federal government has chosen not to. When the U.S. Justice Department decided to withdraw the lawsuit in Idaho that aimed at enforcing EMTALA's requirement that abortion care must be provided in emergency situations, even in states with total or partial abortion bans, it seems to indicate an unwillingness of the current administration to force hospitals and doctors to provide emergency and often life-saving care. So it's now time for Connecticut to once again step in and provide these protections for patients. This bill would not force providers to perform procedures that conflicted with their religious beliefs outside of an emergency situation. It would simply reinforce the same rules that have already been in place just at a state level. Many folks in the state do not have the choice in hospitals when confronted with an emergency. They must go to the only emergency department in their area, regardless of their policy on abortion. Or if you're like me, who lives in Windsor, you have many options of hospitals to go to, but you would have to be familiar with the policies of each and every one. I was 35 years old when I learned for the first time that religiously affiliated medical institutions could deny abortion care and contraceptives. There are many other people who are like me and would not even think to check a hospital's policy, especially during an emergency. It is important that all emergency departments provide the same level of emergency care and are required to give medically accurate information, as well as protect providers who give that care. I'd also like to express my support for the Safe Harbor Fund. There are many folks across the country who no longer have access to abortion services or gender affirming care in their state and cannot afford to travel to get the care they need. This privately funded program would be a lifeline to both Connecticut and non-Connecticut residents alike. So I strongly urge you to support SB 7. Thank you for your time.
Thank you so much, Ms. Grossman. Sorry for mispronouncing your name. Do not see any questions or comments. We appreciate your testimony. Thank you for your time with us. That brings us to the next person. That is Leslie Wolfgang. I think I saw Mr. Wolfgang here earlier, but he may have stepped out for a second. Oh, no. Leslie Wolfgang? Okay. All right. That brings us to the next person on the list. Kimberly Sandor is not here. And Dr. Nancy Stanwood. Oh, Tanisha, you had left your back. Okay, so why don't you go ahead and get started, Tanisha? We thought we lost you, so welcome back.
Hi. Oh, okay. Thank you. I was going to wait for another turn because I didn't think you guys would go right to me, but thank you. I appreciate it. Hello, Senator Anwar, Representative McCarthy-Vahey, and esteemed members of the Public Health Committee. My name is Tanisha Signor. I'm the Policy Director at She Leads Justice. We are a statewide nonprofit that uses a justice and equity lens to advocate for under-resourced and marginalized women and girls in Connecticut. We've been around for over 50 years, and I am here today to talk about our support for SB 7. You guys have heard a lot of testimony about this today, so I'm not going to harp on a lot of the specifics. I am going to say that since the overturning of Roe v. Wade, we have, in Connecticut, we've displayed a commitment to protecting residents. They have a legal right to reproductive health care here. What we haven't done is guarantee meaningful access to all kinds of reproductive health care. And SB 7 will do this in several ways. First, it will protect Connecticut patients by instituting a state requirement for hospitals and emergency departments. Second, it will protect provider ability to share medically accurate information, as well as offer counseling and make referrals to patients who might need it due to the medical institution's religious or moral beliefs. And three, it will create a safe harbor fund, which I know we've been talking about at length today about. I think that these sort of protections are essential given the federal climate that we're in right now. Issuing a state level EMTALA, as stated in the bill, is an essential way for us to address the federal shortfalls that are currently happening. Medicare funded hospitals who provide emergency medical care to treat all types of pregnancy complications with the standard of care, including all reproductive health care services, such as miscarriage management or treatment of ectopic pregnancy, is critical. Patients being able to access accurate and timely treatment in the wake of life-threatening conditions and complications is essential. And lastly, I just want to point out that ensuring these protections is a racial, gender, and economic health justice issue. The United States leads high-income nations in maternal mortality. This is something that we've talked about a lot this session and in previous sessions. Black women in the United States experience this reality at an overwhelming rate, over 2.5 times the rate of white women. Connecticut is not an exception to those rates. Although Black individuals represent only 13% of live births in Connecticut, they account for 27% of pregnancy-associated deaths. This is not okay. These numbers are unconscionable. The goal of achieving health justice and health equity in our state is possible, and offering emergency care protections for pregnant people is an integral part of achieving that goal. I'll lastly just say that we support the amended language that's been provided by Planned Parenthood of Southern New England and Reproductive Equity Now, and I have them listed in detail in my written testimony.
Thank you so much, Tanisha, for your testimony. I do not see any questions or comments. We want to thank you for staying with us today. So we'll move to the next person on our list, which is Dr. Wajahat Mahel. Welcome, Dr. Mahel. You're on. You can unmute yourself.
Thank you very much. I'd like to thank the chairs and the entire committee for this opportunity to speak for about 2 minutes to you so late in the day. I'm really calling to support Bill 1537, which is concerning the recommendations of the working group to the study of non-fatty liver disease, of which I was a part of, and we submitted a report at the beginning of January. And I just wanted to point out that This is a disease that probably many of you will be unfamiliar with because it is a relatively asymptomatic disease until the point where the liver is very badly damaged. Of course, by that time, it's quite late. Also, it is genuinely an epidemic, which is a term that's quite overused, but it's an unseen epidemic because it's a slow-moving epidemic. You know, obviously, unfortunately, we're very familiar with infectious epidemics, which flare up within months or a year. But this is an epidemic which is rolling out over 20 to 30 years. And we're probably in the middle of it at the moment. So many, many people are affected, about 30 to 35% of the population. But the worst aspects of it will become clear in 15 or 20 years' time. It's also, unfortunately, not limited to just older people, as strokes and heart attacks are, but it's related with individuals being overweight and having metabolic issues, which unfortunately are occurring in children. So this is a disease of children and young adults as much as it is a disease of older people as well. And although it's associated with obesity, the amount of extra weight does not need to be very high. Many of you would be familiar with the term BMI. The average BMI is 31 for patients with fatty liver disease. And to give you some context, for somebody who's 5'1", that would be 165 pounds. And for somebody who's 5'9", that would be 210 pounds. So we're not speaking about people who you might otherwise think, as perhaps, being 300 pounds plus, who are at risk of this disease. There are many, many people, who fall within those sort of height and weight ranges. So I'd just like to thank the committee for what they're proposing, and specifically to designate April 19th each year as an overall liver health day, not just for fatty liver disease, but just a day where we can promote activities and educate the citizens of Connecticut about liver health. Thank you so much.
Thank you so much, Dr. Mehel, for your testimony, and thank you for volunteering your precious time. I know how busy you are for being part of the.
It's my pleasure. My pleasure.
You have been leading the working group with the other physicians and other community members, and were able to provide us a pretty robust report, which will serve as a roadmap for us to work on in the coming months and years to hopefully take care of the one aspect of the metabolic liver disease in a significant part of our communities where there's a next generation that is at risk of developing cirrhosis, and we should be able to help that with your guidance and your support and the entire committee's work. I know my co-chair has a question or comment. So Representative Kristen McCarthy-Vahey, you're on.
Thank you so much, Senator Anwar. And Dr. Mahal, I wanted to take issue with one thing that you said, which was that you were a part of the group. You actually were a significant leader as the co-chair of this. You provided so much time, expertise, and passion into the conversation. And I just wanted to ask if you could repeat again what you said about the percentage of people, the numbers, because this was something that I learned participating in the conversation with you, how many people are impacted and how many people don't know they were impacted.
So yes, so overall, somewhere between 30 and 35% of the entire population of Connecticut has some stage or degree of fatty liver disease. Now, obviously, all of them will not become critically ill from this, fortunately, but a significant percentage will become critically ill. And the situation is that I think most people at the moment have a general understanding that large amounts of alcohol over many years can cause cirrhosis of the liver. I think it is such a long-standing problem that most people have some general understanding that occurs. Unfortunately, we're in the situation where in 20, 30 years time, it will be general understanding that people with this metabolic disease will develop cirrhosis of the liver. And currently, of all the cirrhosis of the liver that occurs in Connecticut and the US, roughly half is from alcohol excess and half is already from fatty liver disease. So this is accounting for about half of all of the cirrhosis that is in the population. But obviously, many more people in the population are affected by obesity than drink in excess. So this is going to supersede alcohol excess as the primary driver for cirrhosis.
And that was my other follow-up question, is you're talking about long-term time frame and, you know, over the next 10, 15, 20 years. And is it because you are saying, as you're saying, that the numbers will shift in terms of the number of people who are being impacted more to obesity as opposed to, or, you know, what is it that this is going to be an even greater problem in the next 10, 15, or 20 years?
I mean, the projections are that there'd be, so at the moment, they're roughly even in terms of, you know, if you were to see 100 people with cirrhosis today in a hospital, about half of them would have been from alcohol and half would be from fatty liver disease. It's probably going to be 3 to 1 or 4 to 1. And the reason that's happening is not because alcoholic liver disease is going down, obviously, but because fatty liver is increasing. So the total numbers of patients with cirrhosis is going to go up probably 2 or 3-fold over the next 20 years.
That's a helpful and very sobering answer. Last question, Mr. Chair, thank you for your indulgence.
Thank you.
When we think about, Mr. Chair, may I ask one?
Yeah, please go ahead.
I'm sorry, I can't hear anybody at the moment.
Just in terms of the systemic issue, you know, sometimes we kind of weigh heavily on people's behavior, but can you speak to that in terms of a broader food systems and the type of food available
Sure.
issue?
No, of course. I mean, and obviously that's a very, broad question, shall we say. But I mean, some of the facts are clear, you know, and two broad facts are that, you know, the human genetics obviously haven't changed in the last hundreds of years. And human willpower obviously hasn't changed in the last hundreds of years, but our environment has changed. So this is clearly predominantly driven by our environment, of which food is almost certainly the dominant factor, but obviously other factors such as exercise and sleep, and perhaps other medications that we're taking might also be important.
Thank you, Doctor, and thank you, Mr. Chair.
Thank you.
Madam Co-Chair. So, Dr. Mahel, what is 5210?
5210?
The campaign.
Oh, I see. I'm sorry. No, that's really just a campaign to educate, particularly younger individuals, children, to the basics of nutrition and exercise, and just going through step by step, and changing behaviors that lead to a healthier lifestyle.
Yeah. So I think the 5 stands for 5 vegetables or fruits a day. And then 1 or 2 is
I believe 2 is well, one will be some exercise, and 0 is actually no soda.
Drinks. Yeah.
No soda drinks.
So no sugary drinks, and 1 hour of exercise a day would reduce the risk of somebody having fatty liver disease, and that's the young people. I forgot what the 2 is. You know, I should remember that.
2 hours or less of screen time per day.
Oh, screen time.
Yes, which obviously ties in with mobility. So
does the screen time include the public hearing for about like 12 hours?
Yeah, well, this is my full week's worth of screen time today. So
Thank you. All right. Thank you. Seeing no other questions or comments, we appreciate you and your work. That brings us to number 56, Dr. Nancy Stanwood. Welcome, Dr. Stanwood. You're on. And Dr. Stanwood.
Hi, thank you so much.
Go ahead.
Hi, Senator Anwar, Representative McCarthy-Vahey, and honorable members of the Public Health Committee. I am Dr. Nancy Stanwood, a board-certified OBGYN with over 25 years of experience in medical practice, and I have the honor to serve as the Chief Medical Officer of Planned Parenthood of Southern New England. I'm here today testifying in support of raised Senate Bill 7, an act concerning protections for access to health care and the equitable delivery of healthcare services in the state. As the state's largest provider of sexual and reproductive health care to nearly 50,000 patients last year at 14 health centers across Connecticut, Planned Parenthood believes that all people should have access to high-quality, affordable health care as a human right, regardless of who you are, where you live, your income, or if you have health insurance. I'm here today before you to ask for your support of Senate Bill 7 to ensure that patients get the health care they need when they need it. Specifically, I want to address the important provider and patient protections in portions of the bill. Section 4 of this bill would protect healthcare providers who offer medically accurate information and counseling to patients and provide needed healthcare in line with the accepted standards for their patients facing pregnancy complications. And sections 5 through 13 of this bill would also ensure that patients seeking care in Connecticut emergency departments receive necessary emergency care for stabilization of pregnancy complications. The goal of these sections is simple: to establish employment protections which ensure that healthcare providers do not face disciplinary action for providing evidence-based care and accurate information to their patients. And during a time when other states have created climates of fear, intimidation, and uncertainty for providers caring for patients having pregnancy complications, this bill would make it crystal clear that science, providers, and patients are respected and protected in Connecticut. And it would also serve to correct an imbalance in how we approach the issue of conscience in medicine. Historically, both federal and state governments have protected negative conscience, that is, protecting healthcare providers who opt out of providing care that violates their sense of conscience. This bill would protect positive conscience. As it's a newer term, what is positive conscience? I exercise my positive conscience in my medical practice by providing abortion care, which I see as a human right to dignity and bodily autonomy, and which my conscience compels me to provide. If I were forced not to provide abortion care, I would be morally injured. This bill would protect my exercise of positive conscience. And this is not theoretical to me. Many years ago, I was called on an emergent situation to care for a patient hemorrhaging dangerously in the 3rd month of pregnancy, where life-saving care that the patient needed was abortion care. The patient was at a hospital that forbid abortion care, and I needed special permission to provide an emergency abortion. How dangerous for the patient and how morally agonizing for me it would have been if that permission had been withheld or even delayed. When a patient goes to the hospital, they should be confident that their healthcare provider will be allowed to provide the best care possible without fear of reprisal. This bill will support patient-centered, evidence-based standard of care practices that protect the integrity of the provider-patient relationship. In the face of federal threats, it is essential for our state to clarify and codify protections for emergency care, including emergency abortion care in Connecticut, similar to the federal EMTALA. I strongly support SB 7 and respectfully urge the Public Health Committee and General Assembly to vote favorably. Thank you for your time and consideration.
Thank you so much for your testimony, Dr. Stanwood. And I just wanted to see, would you be able to give us examples of what you're dealing with, people coming from other states and what situation they're in outside of the medical reasons, their financial challenges, so that we can understand if the people, what kind of help do they need? Because when another state is restricting abortion care or reproductive rights of women, it's usually the ones who are poor who are not getting the care. And could you explain if you have provided care to individuals from out of state in Connecticut?
Yes, since the fall of Roe, with the Dobbs decision almost 3 years ago now, I personally at Planned Parenthood and my colleagues at Planned Parenthood and other colleagues across the state have provided abortion care for patients who have traveled from states that have banned abortion care. I actually remember one day in particular, several months after the end of the Roe protections, where in one day I cared for 3 people who came from banned states. One was a physician from the South. One was a teenager from the South, and the other was a mother from the Midwest. And it was really heart-wrenching to see what they had to go through. And that is why we at Planned Parenthood have committed to help people navigate these uncertain and scary times by having a dedicated abortion care navigator, by having access to and dispensing funding for patients who need financial support in making these journeys for care. And so I really appreciate the additional thought that's gone into these updates to the protections for patients and for providers who are offering important care that people can't get outside of states like Connecticut.
Thank you. Thank you for your testimony. Representative Zupkus has a question or comment.
Thank you, Mr. Chair. A question. Hi, doctor. Thank you for coming.
Hi.
When you were mentioning the out of state, what percent would you say of out of state patients that you take care of? Is it 10%, 50%?
That's not a number I have immediately available, and I can certainly follow up with you. We do provide abortion care the majority of the time to people who are in Connecticut, live in Connecticut, this is their home, and they're able to access that care here. And we are proud to be a part of the work to make sure that people who need to travel for care can do so with dignity and can do so quickly, because this care is time sensitive.
Yes, thank you. I was just curious because you mentioned 3, so 3 in one day. I don't even know what percent that is. Is that 30%? I don't know how many patients.
Yeah, it's a good question, and I can certainly follow up with you with accurate information. That day obviously just really stood out in my mind.
I can imagine. I would like that data because that's part of this bill. And so it would be good to know what percent of out-of-state patients come into Connecticut.
Certainly, I'll follow up with you.
Thank you, Mr. Chair.
Thank you. Seeing no other questions or comments, we wanted to thank you for your testimony and for being here.
Thank you.
Thank you. Next is Dr. David Fried. Welcome.
Fried.
Thank you.
Hi, Senator Anwar, Representative McCarty-Vahey, and members of the Public Health Committee. My name is Dr. David Fried. I'm a practicing dentist here in Connecticut for 40 years. I represent the Connecticut State Dental Association and our 1,400 members. I'm here to talk and ask for an inclusion of our medical loss ratio proposed legislation into SB 7. I know you've been here all day, and I'm going to try to be short and concise. The medical loss ratio legislation we're proposing is a very simple pro-consumer bill. This is the third time we've tried bringing it through the legislature, and we're testifying on it. So I know most of you have already heard about it. It will give your constituents power to choose which insurance company they want to do business with based on business practices. Consumers buy insurance to help them cover expenses. It is a cost-sharing device, yet with the cost of insurance, the payoff is usually minimal as it is structured. You heard from several of our colleagues today, including Dr. Mo Riscala, who's a national expert on the subject, and he's from Massachusetts. As he said, people in Massachusetts are the same as your constituents here in Connecticut, and this legislation passed on a referendum last year by 72%, I believe. And the data out of Massachusetts is compelling, and we will make sure that we get that data to you. I don't think it's been provided yet, but providing an 85% loss ratio is obtainable, as they were showing in Massachusetts. Insurance companies are in the business to make a profit, but I can tell you that from where the rubber meets the road at the dental chair, patients make decisions based on how much they need to pay out of pocket and how expensive it is to them. They make the decisions, and often it's the cheapest option, an extraction rather than saving the tooth with a root canal or a crown. And they expect more financial aid from their insurance company, but all they hear about is that the premiums are up because of the cost, but the reimbursements are down because of the cost. That piece in the middle there, the high cost of the premiums and the lower reimbursements, that is all profit in there. And that's what the insurance companies are for. They're for profit. They don't provide health care. Since the pandemic, costs have gone way up in the dental practice. Gloves, staff, insurance, electricity, we all have the same problems, but the reimbursements are lower. But the insurance companies continue to make their profits on the backs of your constituents, our patients. So we're here advocating for our patients. And in closing, optimizing the loss ratio will either require insurance companies to lower premiums or spend more money on care. And that's really what we're looking for. Either way, the patient would win. We're looking for transparency and an enforced ratio of 85%. The other thing I want to remind you of is we have a Mission of Mercy coming up in June. It's going to be in New Britain. And if any of you would like to come, it's going to be a Friday, Saturday in June 20th through 21st. I invite you all to stop by. And if you want to volunteer, great. If you want to just have a tour, contact us and we can make that happen. I'll take any questions if you have any.
We do have a question, Representative Zupkis.
Thank you, Mr. Chair. Really, it's just a comment. Dr. Freed, it's great to see you. And
nice to see you too.
thank you for always coming up. And when I listen to you and have talked to you, it's always about your patients. So I did go and have been a couple of times, as you know, to the Mission of Mercy.
Correct. Yes.
Long name. And it is truly amazing the work that y'all do. I always tell the story that a woman, you were giving her actual teeth, and I saw her first smile in the mirror when she saw it for the first time, because she never smiled. And so it is imprinted on my heart, that one, forever. But just wanted to say thank you. Thank you, Mr.
You're gonna see some exciting things at our Mission of Mercy. They're gonna actually be first time. I think they're doing 3 sets of complete dentures, upper and lower, from start to finish in a weekend. It's tried and true technology, but we're going to be bringing it in and see how we do with it. So it's going to be a special one this time.
Great. Thank you. Thank you, Mr. Chair.
Thank you. Seeing no other questions or comments, we want to thank you for being with us today, and we'll move to the next person on our list, who is Simon.
Anytime. Thank you very much.
Welcome. Thank you for being with us today.
Good afternoon. Thank you for having me. My name is Simon Amaya Price, and thank you for allowing me to testify in regards to SB 7. I believe that Connecticut should not subsidize access to so-called gender-affirming care, and I request that an amendment is passed to exclude funding for access to such treatments from the bill. I have also submitted written testimony. Today, I sit in front of you as a 20-year-old man, but for 3 years, I thought I was a girl. I received my bachelor's degree in music from Berkeley last December with additional coursework at Harvard University in statistics and mathematics. I remember being 14. I was sitting in my pediatrician's office, explaining to him that I was transgender and that my father wasn't affirming my new identity. So my pediatrician asked my father, "Would you like a dead son or a living daughter?" I was in the room when he asked this question. There is no other situation when a doctor is allowed to suggest suicide like this to a patient, and quite frankly, it's medical malpractice. If you ask parents of trans-identified kids and other detransitioners, you'll soon discover this is a common line used to manipulate parents into consenting to such care. Despite being referred to my local gender clinic 3 times by 3 separate doctors, the emotional blackmail, and my gender dysphoria diagnosis, my father refused to take me to be medicalized. And I hated him for it at the time, but today, I'm beyond grateful. And it's not just me. 3% of 18 to 24-year-olds identify as transgender. Between the time I left high school, between 10th grade and the time my class graduated, 1/6 of the boys in my class started identifying as trans, many of whom medicalized. My girlfriend is a detransitioner, and I can't do much more than pray that if and when we decide to have kids, that despite the double mastectomy, which precludes her from ever being able to breastfeed, and the 4 years of testosterone she was put on starting from when she was minor, that she is able to carry a pregnancy to term. The other side believes that if you don't give trans-identified kids puberty blockers, cross-sex hormones, and surgeries, that they will kill themselves. That is a damned lie, and I am living proof of that fact. I was not put on hormones, I was not operated on, and I have grown up to be a healthy and happy 20-year-old man. I have also talked to parents with detransitioner children who killed themselves after realizing they regretted what they had done to their bodies. What would you say to those parents? The other side of this issue has both psychological and economic incentives to support this bill. Imagine, if you will, having administered cross-sex hormones, puberty blockers, and surgeries to children thinking that you're helping them. What if you were presented with evidence that what you were doing was in fact permanently harming them? I know I would have a hard time accepting it. Transgender healthcare is a $4.4 billion industry. Though estimates vary, the lifetime cost of providing a trans-identified individual with hormones and surgeries exceeds $100,000 over a lifetime. What would you do if you were a hospital administrator or clinician who made $1 million for every 10 of these patients you treated? And before you ask, I read the bill, and I have a final critique of the bill. If you will indulge me, as Jefferson said in the musical Hamilton, this plan is too many damn pages for any man to understand. I believe this to be an intentional Trojan horse. If you are serious about protecting families and the health of children, you must vote against this bill and amend it, and vote for it if you amend it. Thank you very much.
Thank you so much for your testimony. Thank you for being here with us. Seeing no questions, we appreciate you being with us.
Thank you.
That brings us to the next person on our list, Karen Buckley. Welcome. Thank you for staying with us all day.
Thank you for being here.
Of course.
Good evening, distinguished members of the Public Health Committee. I'm Karen Buckley. I'm the Vice President of Advocacy for the Connecticut Hospital Association, and I appreciate the opportunity to testify on Senate Bill 7. CHA opposes Section 3, 4, 14, 15 through 18, and 28 through 32 of the bill. And we also oppose Sections 5 through 13 as written. You have our written testimony, so I'll just summarize our comments, and I'm happy to answer questions at the end. Section 3 of the bill, as you've heard earlier today, would introduce an outright prohibition on commercial reimbursement for injection and infusion services, including cancer treatment provided by hospitals in off-campus settings. Hospitals and the clinical staff who support these services would receive no commercial payment whatsoever for providing these services other than the cost of the drug. If this passes, it would likely result in a loss of access to these services for the public, and in particular for the Medicaid population who seek much of this type of care at hospitals. On Section 4 of the bill, it would allow individual providers to substitute their judgment and point of view above everything else by passing protocols, policies, department structure, and leadership. Federal level changes, both actual and impending, have demonstrated that the standard of care is not settled as perhaps was thought just a year or two ago. Section 4 does not fill the gaps or threats created by those federal level developments. Instead, it creates a foothold for those who may place their own views and ideology above everything else, including patient choice. And we urge you to reject Section 4. Sections 5 through 13 of the bill would create a state-level EMTALA law in parallel to the fully operational federal EMTALA law. This is a duplication, and it's unnecessary and problematic. The federal EMTALA law and its corresponding regulations and extensive guidance have not been changed. We urge the committee to delete sections 5 through 13 and replace them with the language in our testimony. In Section 14, as large employers, hospitals, and health systems use self-funded health plans to offer health insurance benefits to their employees. These self-funded plans are supported by stop-loss policies that protect the hospital from significant unexpected costs related to covered services. And we oppose action that would undermine the use of stop-loss policies. Sections 15 through 18, we oppose the repeal of the current language that requires the presumption in favor of approving the CON application for a transfer of ownership of large group practice when an offer was made in response to a request for proposal or a similar voluntary offer for sale. Repealing the current statutory language could have a detrimental impact on healthcare access, and this change should be rejected. CHA opposes sections 28 through 32 and notes that the entirety of hospital-related health care would come to a screeching halt upon implementation because this proposal imposes unworkable preconditions for hundreds, if not thousands, of disparate hospital-based professionals who currently serve in managerial roles with a level of oversight for clinical staff at every hospital in the state. the current public health code regulations require each hospital to be managed by the governing board and that the president or CEO of the hospital meet minimum qualifications. There are
Excuse
also,
me, Ms. Buckley, but your 3 minutes is up. Thank you.
thanks, I'm wrapping up. Last sentence. There are also expectations for the role of hospital chief executives in both the CMS conditions of participation and the Joint Commission accreditation requirements, and we urge you to reject sections 28 to 32, and I thank you for your consideration.
Thank you so much for your testimony. Where do we start? I think you should have just said, these are the parts that I agree with on the bill. It's like line 2, line 5, line 400.
Well, there's certainly a lot there for us to talk about.
We keep you busy, don't we?
Yes, you do.
I think we have talked about all these issues. I do not see any questions or comments. We appreciate you for being here with us. Yeah, but my co-chair has an extensive list of questions she's going to.
Thank you, Mr. Chair, and Ms. Buckley, thank you for being here with us and for staying. And yes, I do see, unlike your colleague, I have the written testimony in front of me, and it's very well outlined. I just wanted to note that I know that we will be in conversation, as I will often say about this, but I know there's a lot here to talk about. So thank you.
We
very much.
stand ready to work with you on whatever we can.
Thank you. Thank you, Mr. Chair.
Thank you. With that, we'll ask our next person on the list to come and speak. That is Liz Dupont-Dale. Liz, you're on with your cat. Saw your cat earlier.
My coworker has momentarily left the the site. Good evening, Senator Anwar, Representative McCarthy-Vahey, and distinguished members of the committee. My name is Liz Dupont-Dale. I am a lifelong Connecticut resident and the Associate Director of the Connecticut Citizen Action Group. CCAG and our thousands of member families and allies work to challenge entrenched power and corporate interests to achieve a more fair and just Connecticut. CCAG and our members and partners are deeply concerned about how healthcare has become inaccessible and unaffordable for so many residents. For-profit entities such as health insurance companies and private equity firms have gained increasing control over healthcare. Their driving motive of ever-increasing profit has resulted in billions being diverted from healthcare. The Journal of the American Medical Association reported last month that 95% of these profits went not to researching newer drugs or building better hospitals, but to corporate shareholders through dividends and stock buybacks. 1 out of 8 adults owes more than $10,000 in medical debt. We have billions of dollars that are being sent out to these large shareholders, one of the author's studies told Connecticut Public. It really raises the question of how much money is enough for our for-profit healthcare companies to be taking from our healthcare system. So CCAG speaks today in favor of several bills that would offer progress in controlling these negative cost drivers and ensuring quality care for patients. SB 7 takes significant steps to prioritize patients, improve transparency, promote equitable access to healthcare, creating facility fee transparency rules, and prioritizing public health. It would positively impact patient access and care and improve conditions for healthcare workers and improve public health. We strongly support several elements of the bill. The regulation of stop loss, creating a state requirement for hospitals with emergency departments to provide stabilizing emergency care, which explicitly includes abortion, and protecting providers' ability to share medically accurate information, counseling, or make referrals for patients who may be unable to access reproductive health care they want and need because of a healthcare institution's religious or moral beliefs. We further support making funds available to support patients traveling to Connecticut for reproductive and gender-affirming care. CCAG also supports SB 1538 regarding ER overcrowding and boarding and overcrowding as an important step in addressing emergency room boarding by exploring an expedited conservative process. Finally, we are in favor of SB 1539 and also SB 1539, especially supportive of 1539's requirement for a certificate of need review when a private investor seeks to acquire a controlling interest in a healthcare facility, and the prohibition on closing labor and delivery units in the absence of a similar facility within 25 miles. We would also support John Brady's suggestions about including distance and drive time in that consideration. For too long, the profit motive and market forces have driven the design of our healthcare system and the delivery of services. We applaud consideration of these bills and urge you to vote favorably on them and other measures that prioritize Connecticut's people over profits. Thank you very much for your service and your time and attention today. I welcome any questions.
Thank you so much. You covered every bill in a very efficient manner. You're like an expert on this, Liz. Thank you. I just wanted to thank you for your testimony. We have no more questions, but we look forward to more conversations with you and your groups. Thank you for the work you do and CCAG for the work they do.
Thank you all for your service as well. Thank you. Take care.
Thank you. The next person on our list is Dr. Stephen Hall. Dr. Hall, you're on. Welcome.
Yeah, thank you. Thank you for it's a long day you've had here. So Senator Anwar and Representative McCarthy Vehi and the rest of the esteemed members of the Public Health Committee, I'm here to speak on behalf of SB 7. Again, my name is Steve Hall. I'm a dentist who practices in Farmington, Connecticut, and currently I'm the president of the Connecticut State Dental Association. And I think I know there's a lot of good parts to SB 7, but I want to respectfully add that you include the Connecticut State Dental Association's draft medical loss ratio into this act. I think by doing that ensures the, promoting financial transparency and accountability to dental insurances, which aligns with the broader goals of SB 7, which is strengthen consumer protections and improve access to essential healthcare services. MLR already exist in the medical field, and we just want to kind of bring that up towards the equity and health regulation. My dental staff spends thousands of hours a year on the phone with dental insurance companies on behalf of the patients who and advocating for their dental benefits. And the patients have a very hard time understanding the what the benefits are, what the reimbursements are, and typically when we are not involved, I don't want to spend the time for that. Enough of the patients actually will give up on their benefits that they've paid for and they deserve. So we're hoping that including MLR for dental plans will provide a means for patients to have an understanding of their dental plans and assure that the money they pay for these plans is going to their patient health care. So I know you've had a long day. I know this is kind of a repeat of some of the other things, testimony you've heard, but I do want to, say this: the CSDA strongly believes that adding this MLR provision to SB 7 will support the patient and enhance provider sustainability and increase fairness in the dental insurance market. So let's try to keep it short for you. I know it's been a long day.
Thank you, Dr. Hall. We appreciate you. We appreciate you staying with us and your advocacy on behalf of your patients and profession.
Thank you.
No questions. We will go next to Gretchen Rappa, who is here with us in person. Welcome. Thanks for sticking with us today.
Happy to be back. Good evening, Representative McCarthy Vehi, Senator Anwar, and honorable members of the Public Health Committee. My name is Gretchen Raffa, Chief Policy and Advocacy Officer with Planned Parenthood of Southern New England, testifying in support of Senate Bill 7. You just heard from my colleague, Dr. Nancy Stanwood, so you know who we are. I want to thank this committee and the Connecticut General Assembly for taking action over the past 3 sessions to protect reproductive health care providers and expand access to essential reproductive health care, including abortion care, with strong bipartisan support. In no uncertain terms, access to abortion was devastated by the overturning of Roe v. Wade, causing a public health crisis across the country. We are in a critical moment where our basic health care and our rights are on the line. SB 7 is another step the legislature can take to protect healthcare providers in our state who offer medically accurate information and counseling to their patients and provide needed healthcare in line with the accepted medical standard of care for their patients facing pregnancy complications. Section 4 of the bill will provide employment protections, as you've heard, and ensure providers don't face any disciplinary action when they provide patients with medically accurate information and referrals. And it would also protect providers by prohibiting their employer from disciplining, discharging, or discriminating against them for providing appropriate emergency care to their patients. And what's important to note, the employment protections in Section 4 of this bill do not require any affirmative actions by a healthcare provider and would not force or compel any institution to offer medical treatment or referrals that is against their moral or religious belief. Rather, this bill is intended to ensure healthcare providers do not face disciplinary action for providing quality care and accurate information to their patients. When a patient goes to a hospital, they should be confident that their healthcare provider will provide the best care possible. We know the dangers and risks patients face when they are denied healthcare they need, and we've heard horrific stories of pregnant people being denied life-saving pregnancy-related care in hospital emergency rooms across this country due to abortion bans and severe restrictions on abortion care in 19 states since the Dobbs decision. People are dying because of these abortion bans. We know their names: Amber Nicole Thurman, Candy Miller, and more. We know their stories. We know they are just the first. They should still be here. Far too many patients have been left without access to health care because of their zip code, even in emergency circumstances that require life-saving abortion care. Every day we live under these abortion bans, more people will suffer and die. That's why creating a state-level emergency care requirement similar to the federal EMTALA by requiring hospital emergency departments in Connecticut to offer essential emergency care, including emergency abortion care, is so important. We also support Section 19 of this bill to establish a safe harbor account in the Office of the Treasurer, which will provide critical resources for people who are traveling for essential reproductive and/or gender-affirming health care. Just as we have been seeing states ban abortion care, state bans on transgender health care have passed at alarming rates in 2024, and now 26 states ban access to gender-affirming health care. While we support SB 7, you will see in the written testimony that I submitted, we have several recommendations for amended language that will strengthen the bill. Planned Parenthood will continue to fight for policies that protect the rights of all people to ensure our patients in our communities have what they need to live healthy and self-determined lives. No one's health should be compromised or healthcare access denied because of who they are, where they live, or where they seek care. Connecticut has a responsibility to protect patients who need access to time-sensitive, life-saving pregnancy care, including abortion. That's why we strongly support SB 7 and urge passage. Thank you so much for your time and consideration.
Thank you, Ms. Raffa. Perfect timing, actually. Thanks for being here with us today. Representative Zupkis.
Thank you, Madam Chair. Hi,
Hello
Gretchen.
again.
Thank you.
Hi.
I had asked earlier about the percentage of patients that y'all serve from out of state. Do you know what that number is?
Yeah, so I just want to be clear too, this number is going to sound higher because of the percentage. While we've seen an increase of out-of-state patients, overall it's a small amount compared to the total number of abortion patients we see for abortion care every year. In the second year post-Dobbs, we saw a 147% increase, which is less than 50 patients. So again, it's a small portion of the patients we see for abortion care in Connecticut, but they are coming to our state because of these abortion bans.
Right. So I don't want to get into the federal government, the band, all that stuff. So you said 147% increase, but what is the percentage? If you see, I really don't know how many patients you see. So right over in a day, in a week, a year, I don't know. But is it 10% of your patients across the border from out of state? Is it 50%? If you had to guess, I'm not going to hold you to 42.7, but just if you had to guess, how many patients on a percentage basis do you see or coming into the state?
Just for abortion care?
People you see, Planned Parenthood.
I will have to get back to you. The number I
pyramid.
just shared was specific to abortion care. And in the last fiscal year, we saw just under 11,000. We served patients and provided just under 11,000 abortions.
Okay. If you'll get it, I just am curious if we're going to be paying for people from out of state coming and getting care. I would like to know what that percentage is that you serve.
For all services. I just want to be clear on the
All
question.
services.
Okay.
Anybody that so that's 3 answers you owe me.
Are you counting last
2
week
from the
too?
other. I am. I never got answers
I
from
know.
you.
I was going to say
So-
that at the end. I know I owe this committee
do.
follow
So
up
now
from
we're
last
on
week.
3,
And
Gretchen.
it's on my to-do list. I promise
Okay.
you.
All
You know where
right.
to find me.
I need
Right
the answer.
here.
I need your answers though. Thank you. Thank you, Madam Chair.
Thank you, Representative Mara.
Thank you, Madam Chair. Thank you, Gretchen. Appreciate your testimony. just kind of continuing on from Representative Zepkis's questions, what percentage do you know about how many people you serve for gender affirming care now at Planned Parenthood?
Percentage of total patients?
I'd be interested in cost or patients, either one.
I will tell you, in Connecticut last year, number of visits for gender affirming healthcare was just under 1,200.
And what percentage, when we talk about gender affirming healthcare, does that include all treatment for gender dysphoria, or is that only, so if you talk about gender dysphoria, does that number go up?
At Planned Parenthood of Southern New England, we provide gender affirming hormone therapy for people who are 18 and over. So that is the care we are providing at Planned Parenthood of Southern New England. We do have a patient navigator that would refer out, and our health centers have referrals for other healthcare services that we do not provide at Planned Parenthood of Southern New England. But when we're talking about the care that folks can receive at Planned Parenthood of Southern New England is gender affirming hormone therapy.
Okay. So that's 1,200, 18 and over getting hormone therapy. If you have someone present.
Those are visits. So so those are number of visits, not number of patients, but I can get patient numbers if you'd like.
No, I kind of am curious to understand what percentage of your overall cost that is now. I don't know if that's a high cost, or like when we're looking at funding Planned Parenthood, I'm just kind of curious at what that cost structure looks like. And I realize that's not on this bill, but
Are we on
we have
another
a trend-
bill again,
we have a trend
Representative?
to talk about other things with you. I'm so sorry. I'll keep it very focused on this. And then, so then if you have someone coming in under 18, you refer them elsewhere. Then is that my understanding from what you
For
just
gender affirming hormone therapy,
Yes.
we only provide care to patients who are 18 and over.
Okay, so if someone comes in younger, what do you do with someone that comes in with gender dysphoria that is younger?
I wish that you could let Dr. Nancy Stanwood back in the Zoom room, because she would be the best person to be asking about. We refer out to patients we can't see for services at Planned Parenthood across the board. I can't speak to what that counseling looks like exactly. But for gender affirming hormone therapy, no, if someone is under 18, they cannot get the hormone therapy at Planned Parenthood of Southern New England.
Okay. All right. Thank you so much. I really appreciate that.
Yep.
Thank you, Madam Chair.
Thank you very much, Representative Mara. Ms. Rafa, thank you very much for being here with us. I know we'll see you tomorrow, I think, too.
Yes, and I will get you the follow-up, I promise you.
All right. Thank you. Thank you very much. Moving on, next on our list is Sandra Ferreira Molina.
Thank you for so nicely pronouncing that, Representative McCarthy-Vahey.
Forgive me, I will just say, Sandra, we'll go ahead with you, and Mr. Brunel will come back to you. I apologize. I missed you in the order, so.
Okay, dear Senator Anwar, Representative McCarthy-Vahey, and esteemed members of the Public Health Committee, the Connecticut Oral Health Initiative urges the inclusion of the Connecticut State Dental Association's proposed medical loss ratio language in SB 7, an act concerning protections for access to healthcare and equitable delivery of healthcare services. Ensuring financial transparency and accountability in dental insurance is critical to protecting patients and strengthening access to care. Currently, many dental insurance plans operate without clear guidelines on how much of their premium dollars must be spent on actual patient cost or care, Without an MLR standard, insurers can allocate excessive funds to administrative costs and corporate profits, leaving patients paying more coverage that delivers less. This lack of accountability must change. Medical insurance already adheres to MLR requirements, and extending these same protections to dental insurance is a necessary step toward fairness and equity in healthcare. Beyond insurance reform, SB 7 also supports initiatives that promote community health, such as the fluoridation of water. Water fluoridation is a proven public health measure that significantly reduces dental decay and improves oral health outcomes for all residents, especially those in underserved communities. This preventive measure underscores the importance of equitable access to foundational healthcare resources. Additionally, real change requires a system that works for both patients and providers. People in Medicaid deserve comprehensive coverage that guarantees access to preventive and essential dental care. However, coverage alone is insufficient if there are not enough providers willing to participate in Medicaid. Low reimbursement rates are an unsustainable system that have pushed too many dental providers away, leaving patients without the care they need. A system that fails both patients and providers is a broken system. Connecticut must invest in policies that not only expand coverage, but also enable providers to deliver care without financial hardship. The inclusion of the medical loss ratio provision in SB 7 will advance Connecticut toward a stronger, more equitable healthcare system. Holding insurers accountable ensures that patients receive real value for their coverage. Creating a system that incentivizes provider participation means that more people will have access to care they need. These are not just policy decisions, they are steps towards a future where every Connecticut resident, regardless of income or insurance status, can receive timely, high-quality dental care. This is an opportunity to take meaningful action to improve healthcare access across the state. I urge you to support the critical change in SB 7. Thank you.
Thank you so much for being here with us today and for your advocacy. We appreciate it.
Thank you. Have a good night.
You too. And now, with apologies again, Dr. Brunel, we will go back to you and thank you for your patience with us. If you could unmute yourself first, that would be wonderful.
I thank you and I thank the committee for your diligence and your time. I am speaking out in support of SB 1538, the Act about Emergency Department Overcrowding. I'm currently a medical director and chairman at ECHN Manchester. I've been practicing in the state of Connecticut for 2 decades. I have seen the catastrophes that boarding has caused for my colleagues, for my patients. I strongly advocate that we move this forward, and I thank the committee and all of its members for bringing this forward. And I will keep this brief because it's been a very long day for all of you. Again, my gratitude to the senators and the committee and my support for SB 1538. Thank you.
Dr. Brunel, thank you so much for sticking with us. And I know Senator Anwar also shares his thanks as well. And we're grateful for you and for all who have come forward to support this effort, and those especially who have served on the working group as well. So thank you for taking time to be here with us today.
It's my privilege. Thank you.
Next, I have Thomas Burr. Welcome.
Good evening, Representative McCarthy Vahey and members of the Public Health Committee. My name is Thomas Burr. I'm the Public Policy Manager of the Connecticut chapter of the National Alliance on Mental Illness, otherwise known as NAMI Connecticut. NAMI is the nation's largest grassroots mental health organization dedicated to building better lives for millions of Americans affected by mental illness. For anyone who's not familiar with us, more information about NAMI is included in my written testimony. I am testifying today regarding Senate Bill 7, an act concerning protections for access to health care and the equitable delivery of healthcare services in the state. I would like to draw the committee's attention specifically to sections 22 and 23, which calls for the Connecticut State Department of Education, in collaboration with the Connecticut State Department of Mental Health and Addiction Services, to establish a mental and behavioral health awareness and treatment pilot program in priority school districts, as well as the necessary funding for the pilot. One of NAMI's top public policy focus areas is to improve mental health That is to advocate for policies to ensure people get the best possible care. This includes expanding access to health coverage and parity for mental health, as well as promoting early intervention and care integration and ensuring that the right services are available at the right time. Now, we know that 50% of all lifetime mental illnesses begin by the age of 14. So interventions in school settings where children honestly spend the majority of their waking hours is crucial. Since the onset of COVID, we have been in a mental health crisis and the need continues to be at a critical level. And we applaud the inclusion of a peer element in Section 22 of the bill, as establishing connections with peers is a key component in obtaining engagement and positive outcomes. It's one of the secret sauces, I often say. We are confident that if the pilot program is properly implemented, we will see meaningful and positive results and a significant improvement in children's mental health here in Connecticut. In conclusion, we appreciate the Public Health Committee including these services and funding in sections 22 and 23 of Senate Bill 7 and strongly support that this language be included in this bill. And since I haven't been interrupted by Kathleen, I'd like to also just add that I would like the committee to know that regarding Senate Bill 1538, an act concerning emergency department boarding and crowding, we echo the concerns that you heard earlier from Kathy Flaherty from the Connecticut Legal Rights Project. And thank you for your time and attention. I'll happy to answer any questions.
Thank you, Mr. Burr. And Mr. Burr, as is sometimes the case, as you've seen through the course of the hearing day, there are different logistics and things that we may have to take care of. So can you just repeat for me and for anyone else what that aspect that Ms. Flaherty was talking about that you are speaking to?
It was about the establishment of emergency conservatorship in emergency rooms. And her written testimony draws a lot of concerns related to that, and that there's already existing language in state statute that provides for that, and didn't feel that there's a need to do anything additional to what's already there. That the issue wasn't so much needing an expedited process. It's really an issue of we need more beds, we need peer respite, we need places for people to go so they're not being boarded.
Thank you for underscoring that. I appreciate it. And thank you for being here with us, not just throughout today, but also throughout this session. We appreciate your advocacy.
My pleasure.
Okay. Oh, Mr. Chair.
I just wanted to ask, did you miss any of our public hearings? I've missed your attendance.
Oh, I'm sure I must have at some point. But yeah, no,
No, you've
I
made
feel
every
like
one
a
of them.
frequent flyer for sure. Yeah.
Well, you get a free pass every time because you've been at every single public hearing. We thank you for your dedication. Thank you.
Appreciate
Back
that.
to you, man. Thank you.
Thank you very much, Mr. Chair. We'll move on to next, Mr. David Reynolds, who's here with us in the room. Also has been sticking with us all day. Welcome.
I'll get home before midnight. All right. Too bad.
I'm knocking on wood.
Chairs and members of the Public Health Committee, my name is David Reynolds. I'm Associate Director of Public Policy for the Connecticut Catholic Public Affairs Conference, which represents the Catholic Church and the bishops in the state of Connecticut. I'm here today to speak strongly in opposition to Section 4 and 19 of Senate Bill 7. Section 4 is designed to prohibit Catholic hospitals from disciplining a provider who violates the ethical and religious directives for Catholic health care, is a blatant and unnecessary backdoor attack on Catholic health care and religious freedom in our state. ERDs set the ethical and moral standards of care for Catholic hospitals, including the prohibition against providing abortions and gender-affirming care. I believe if the Catholic hospitals we're not adhering to the ERDs, that Section 4 will not even be part of this bill. It's very similar to language last year, HB 5424, that basically tried to do the same thing. I have to speak on this because people act under a misimpression of Catholic healthcare service. Catholic healthcare service does provide emergency care for pregnant women. And if that care ends up being that the child's life has to be, I don't want to use the word sacrifice, but cannot be saved, then that is acceptable under Catholic healthcare directives. There is no absolute ban against anything. People use this term emergency abortion care. Quite frankly, I don't know what emergency abortion care is or means, because usually when a woman presents herself in an emergency who's pregnant to an emergency room, there's specific medical conditions that exist. The standard of procedure in a Catholic hospital, according to ERDs and the Catholic Hospital Association, is that you try to save the mother and child. You try to look at the mother and you provide all the sustaining care that you possibly can. And if some of that care will result in the death of the unborn child, then that is acceptable. It's called a double effect ethical standard. A section, also we follow the emergency to EMTALA standards. And I just want to clear something up here about what's been said about EMTALA today. EMTALA has been around since 1986. It has not been changed. The change did occur at the end of, I'm going to say 2022, when passing of Roe v. Wade, the Biden administration added requirements and tried to force hospitals in states that banned certain levels of abortion to be able to do abortions. The courts rejected that and pushed back. This issue is still with the courts. So when we say that EMTALA, we have to be careful that it isn't the current administration that is doing away with EMTALA. I've never even heard of that or read of it in the press, and I'm a news junkie, okay? The impact to the pregnancy community, or the pro-abortion community, I should say, is that the provision that Biden put into EMTALA was removed, or the courts are not recognizing it as valid. So there's no big effort to do away with this law. I don't even see the reason why it has to be in the bill at this time. Also, the Section 19, again, sets up the safe harbor account to help fund people that need to come to Connecticut to get an abortion from abortion-restricted states or transgender identity restricted states. And I just want to make one thing clear that, well, two things actually. States that banned gender identity treatment ban it for minors. I'm not aware of any state that bans it for adults. It's all minors. So what we're basically doing with this bill is saying we're going to provide money to people to bring minors to our state to have transgender surgery, especially when it calls for them to meet certain standards. Those standards are in great flux in the United States, but more around the world. The way to treat young people that have gender identity problems in Europe, United Kingdom, Germany, Denmark's, Sweden, a couple of those countries who were big on this have reversed themselves. They are now promoting mental health treatment instead of affirming care treatment, hormones, letting the person dress up as a girl if it's a boy, those type of things. They're saying they're finding that. Okay, I hear you. Let me wrap up, please. is that the minor treatments we have to reopen and reevaluate. The studies are saying that. So I have concern, the Catholic Conference has a concern about bringing minors from other states where the doctors in that state or the politicians may have said, well, listen, we believe what's going on in other states, other countries, or even other states might be correct. So I'd be very leery about allowing minors to be funded to come into our state at this point in time, given the big debate that's going on in the medical community over the treatment. Thank you.
Thank you so much, Mr. Reynolds. Don't go away. We may have some questions and comments. So we appreciate you being here. I see Representative Jenga online has a question or a comment. Rep Jenga. Rep Jenga, please unmute yourself.
Thank you for your testimony. And you referred to Section 4 as being against the professionalism of the Catholic hospitals. Can you give me an example how Section 4 would work against a Catholic hospital?
Well, the way Section 4 works is legal challenges to the ERDs, or the religious directives that Catholic hospitals work under, have been tried and have failed. I call it a backdoor approach because what it will now do is it will allow doctors who, remember, they sign a contract to work at a Catholic hospital. A contract mentions the ethical and religious directives that you have to comply. But if they choose not to comply with that and maybe get involved in abortion or sterilization or some other medical service that's banned by those directives, the management can't reprimand it. They have no more ability. So that's kind of like a business where you say, we're going to treat our customers this way. And then the customer, people that work for you start treating the customers the other way, and the manager can't do anything about it. So this is really through cutting off management control of what is going on. So instead of directly hitting the ERDs, they're coming around. That's why I call it the back door. The back door is they're coming in and saying, you can have all the ERDs you want, but if we pass this law, your management's not going to be able to do anything or enforce them, which is sad.
So what you're saying is, as I understand it, is that this law would invalidate a contract signed between a medical profession and a Catholic hospital because the individual could do something that's other than in a contract and against the Catholic profession, and they would not be held accountable for that.
That's correct. That's correct. And we have to remember too that they choose to work at that hospital. They could choose to work at another hospital or medical center. So yeah, that is correct. It's a backdoor management trick to make the ERDs totally useless. And this isn't just happening in Connecticut. The ERDs have been under attack by pro-abortion advocates for a decade now, and even the ACLU. And this is a new, different type of approach to get at them to attack the Catholic hospitals, because we don't do abortions, we don't do sterilizations. But I just want to stress that in the emergency room, it's a whole different story. That we do, if a woman is pregnant, we do address the needs of the woman. She is the priority. And of course, you want to save both if you can, but there is a priority. And usually, the examples I read, it's usually where they have to do a procedure on the woman or give her some medication and I inform that if we do this, your child might die. But that's allowed under Catholic ethical directives to do that, to save the life of the woman.
Can you give me an example now of how a Catholic hospital has reprimanded one of its medical professionals for not honoring their contract?
I couldn't do that, Representative, because that's personnel information. I don't have access to personnel information.
Well, I'm not looking for specific individuals, but examples of what kind of behaviors or unprofessionalism that medical professionals would do in a Catholic hospital.
I hate to conjecture because there's outpatient services and inpatient, emergency room services. So exactly what and how they might violate that contract is possibly through, prescribing somebody an abortion pill. That would not be allowed. Even birth control sometimes is
okay. Let me ask you what you just said, providing advice on an abortion pill or giving an abortion pill.
I'm writing a prescription for it or whatever. Yeah.
Okay. And what would the Catholic hospital do about that?
That would be up to the management. That would be a management decision.
Okay, but it's specifically in their contract that they can't do that because it's against the religious beliefs of the Catholic hospital.
Right. Their contract doesn't list every belief, but it makes them aware of this. And I think
sure.
that are signing on or have gone through medical school will know about these directives. And we also have to remember the Catholic directives aren't just do not do this. The Catholic directives are the heart of Catholic healthcare. If you ever get to read them, that this whole abortion thing takes like a page. The rest of the whole document is about the quality of service, how we treat people as human beings. It's all about standards of care that should be followed. So we're actually talking about a very small part of healthcare directives.
Okay, thank you.
Thank you, Representative Janga. Senator Summers, you still have a question, or you're? I think you're still muted, so I take that as if you don't have a question. Maybe that's a,
Sorry, I couldn't unmute myself. I was just going to ask Mr. Reynolds if he has any examples of this type of bill being passed in other states, and if it was challenged, what the outcome was, requiring a Catholic hospital to do something, or basically rendering them, I would guess, impotent to be able to do anything against an employee who then felt that they could violate the contract that they signed. Has there been any lawsuits that you know of in other states that this has happened?
And I track this stuff very carefully. I have not
Mhm.
read of any actions or even a similar bill. So I don't know if we're getting in Connecticut or not at this point in time.
Okay. I thank you for your testimony. I do respect the right of a religious hospital to have their own, requirements of things that they feel are, within their religious confines and their beliefs. And the big thing I think for many of us is that you do provide care in emergency situations, which is obviously necessary. So there should be no confusion as far as that is concerned. But I do thank you for your testimony tonight.
Senator.
thank you, Mr. Reynolds, for your testimony. I wanted to clarify a few things. I wanted my colleagues to have an opportunity to ask questions.
Sure.
Can we clarify, because section 4, the way I'm reading this is that in an emergency, if a clinician is providing care in an emergency to a pregnant woman or a woman who, as you very eloquently described, a child had life could not be saved while you're saving the mother's life.
Correct.
In that situation, if the person counsels that patient that there will be no repercussions, this is an emergency situation. It's not like a regular everyday situation. So why would that be a concern if it's an emergency and the directives, ERDs are in sync with the directives that the person is following? Why would you want to not allow that physician to hold the hands of the person and cry with them or counsel them and whatever counseling they're going to provide them? That why would that be not allowed?
Well, I think, again, you got to look at you're looking at the emergency room situation. There's nothing there that says a doctor can't hold a patient's hand and counsel them through a difficult situation. It's what do they counsel them for? Obviously, I think in that question would be more for probably an outpatient situation than an emergency situation. So, and when the outpatient situations, it's not like the hospitals monitor every conversation a doctor has with their patients and meeting with the doctors or specialists. But in that term, I think if similar to what I think Representative Jengo was getting at is what situations. And I think it would be possibly, again, this is personnel matter, which is not shared by Trinity Health or St. Francis or with us. It would have to be done about maybe doing an actual referral to an abortion center. It's my understanding from talking to people at the hospital that the physicians are free to say, we don't do abortions here, but, Planned Parenthood's across town. If you want an abortion, we don't do, but if it comes to actually making a written referral, that type of thing, to calling Planned Parenthood, making it, like making sure they get in, that type of thing, those type of things are discouraged by the ERDs.
So Mr. Reynolds, again, you're going against your own directive. This is an emergency situation.
Okay,
Section 4 is about emergency. It is not about an outpatient situation. I respect the outpatient non-emergency part.
Actually, Section 4 addresses both. There's a part that directs just speech generally, then there's a part that moves on to emergency services. So it does address both situations, outpatient. And I think the thing is, I guess our statement on this is the Section 4 is not needed at all, because it's not really, knowing that we are the target of Section 4 by the advocates, and I'm not being paranoid about that. It was clear last year when we had 5424 up here that the Catholic hospitals are the target of, and their directives are the target of Section 4, that Section 4 should not even exist, because we do handle emergency situations in the way that they're supposed to be handled. And people would expect them to be handled.
So let me phrase my question again,
Okay.
if you would allow me,
Yep.
please. In an emergency, if the contract suggests for a person, anybody, a nurse or a physician or anybody who's working, which says that you are not to give any guidance about um, abortion clinic or gender affirming care or whatsoever to a person. That's, let's say that's in the contract. But in an emergency situation, the directive says save the life that you can.
Correct.
And in the process of trying to save the life, the facility does not have the capacity to provide certain care. So shouldn't that clinician be able to say, go across the street to Planned Parenthood or XYZ facility and get the care that you need? We cannot provide you the care. We will stabilize you, but we will send you in an ambulance to that place. But I'm going to have to call, because if the person has an emergency, one should not be restricted and they should not have the slightest bit of fear that could delay the process in any shape or form for saving that life. So I think
I'm not sure of your question, Senator, because.
no, I have I'm making a statement
Right,
to
yeah.
say that why do you think that, and again, I'm chairing it. So if you were
Sure.
chairing it, I
That's
would be
okay.
asking
Yep.
and saying that to you. So if you would be able to help me understand what's wrong with that clinician trying to guide that person to the place where they can get better care for something else. For example, if the neurosurgeon was not available at your facility and they were to say, hey, we know the one that is there is somebody I would not want my family to be operated by, why don't you go across the street to XYZ facility and get that care there?
Well,
What is illegal about that?
there is just nothing illegal about it. Actually, EMTALA addresses the transfer laws between hospitals. So it's very specific on what has to be done to transfer a patient. So obviously the first steps require that, screening be done of the patient. What's the presentation to the medical person? And then to stabilize the patient, and then to provide care to that patient within the facility. If, like you said, neurologist, if they needed neurosurgery or something immediately, then that person would be transferred. But if a pregnant woman comes in, I'm having a hard time grasping where the woman would have to be transferred to get an abortion. I'm having, that's where I'm having a block here.
Well, actually, it's two lives at that point rather than one life. So it's probably even easier to understand. It's an emergency situation. They need a surgery or intervention,
Right.
and that is going to require care. So I, um, I think again, perhaps from the historical reasons, you're being overcautious to say it's not a good idea from your perspective, but the intention is to make sure that the clinicians are able to, without fear of losing their job or other challenges that they may have, or the nurses in there, to be able to provide the best possible recommendation at that critical time in an emergency to a patient. That's how I see it, but I respect the fact that you are not seeing it that way. I don't understand it, but I have to respect where you're coming from.
Well, I think when you're looking at the major hospitals in Hartford, so to speak, trauma 1 level, trauma 2 level hospitals, they can provide most of the care that's needed to somebody that comes into an emergency room. So, if you're looking at those facilities, and of course, Trinity Healthcare is a level 2, I think, but they would provide that care within the facility. Nothing would restrict. I mean, the only thing that would restrict is do we need to transfer that patient to get some other kind of care that this facility would do? If that care was, okay, the mother is pregnant, she's critical. If we don't do something now, she's going to die. If that care requires that the child is going to have to, I hate the word use sacrifice, but to save the life of the mother, then that's the decision that has to be made. That's the decision that's allowed under Catholic healthcare directives, because it's not in Catholic theology, an abortion is an intentional taking of an unborn life for the purpose of taking that life.
But
So,
Mr. Reynolds, the challenge is that I'm not privy to the contracts at your hospital or the others, but it's my understanding that the contracts in your hospital restrict that individual from being able to provide that care, as opposed to any other hospital, it does not. And that's where we are having a little difficulty, that the person should be able to operate without any fear that while they're trying to save their life, they will have to lose their jobs. And that's where I think we are not connecting as well right now. But
Well,
I don't
yeah.
anticipate us connecting tonight anyway. But I
It's
wanted
late.
to appreciate you waiting for a significant part of the day and listening into the conversations and remaining open to a respectful conversation. I appreciate your passion around this
And
as well.
Senator, I'm willing to keep this conversation alive after the public hearing too. but
Thank you so
Not
much.
tonight, not tonight, though.
Thank you. With that, we will move to the next person on our list. Thank you so much. Which will be now Jamie Cavanaugh. Ms. Cavanaugh, thank you for accepting to be promoted up here to speak. You're on. Welcome.
Thank you so much. Good evening, Chair Anwar, Chair McCarthy-Vahey, members of the committee. My name is Jamie Cavanaugh, and I'm Legal Policy Counsel at the Pacific Legal Foundation. Pacific Legal Foundation is a national public interest law firm dedicated to defending American civil liberties. Over the last few years, I've become a national certificate of need expert, working with legislators in more than a dozen states to rethink and reform certificate of need laws. Thank you for all of your work considering how to increase access to healthcare in Connecticut. I know certificate of need has been a recurring topic for this committee over the past few years. And thank you for your work on SB 1539. But I would urge you to consider that more still needs to be done to make sure everyone in Connecticut has appropriate access to healthcare. Earlier today, Commissioner Gifford testified that she wants to make sure reforms are rooted in data and evidence. And I couldn't agree more. And I urge this committee to follow the overwhelming evidence while it's considering certificate of need reforms. Academics have been studying certificate of need laws since the 1980s. And despite what you might hear, the research on the effects of certificate of need laws is not mixed. Decades of research confirms that certificate of need laws have failed to fulfill their intended purposes of increasing access, decreasing costs, or improving healthcare quality. In fact, today, 40% of the nation's population live in a state with zero or extremely limited healthcare certificate of need laws, making it very easy for economists to compare outcomes. I would direct you to my written testimony that I submitted for this, plenty of citations to all of this research, including a very recent meta-study that compares all of the known academic quality studies of certificate of need laws. But the most important statistic, in my opinion, that comes out of the research is that states that have already made the decision to repeal their certificate of need laws have more healthcare facilities per capita. This may not sound important on its own, but it actually counters many of the reasons that certificate of need proponents give for needing these laws. If there are more facilities in states that have already repealed certificate of need, then residents there have better access. And it cannot be that when certificate of need goes away, existing facilities close or become unprofitable and discontinue services. Just the opposite, more facilities open and they stay open. On top of that, there are 0 tests out of the hundreds of tests of certificate of need laws. 0 find that certificate of need laws increase access for vulnerable populations. That's also really important because I know that's a huge consideration for this committee and for every legislature around the country looking at healthcare policy issues. But the one-sided nature of the data makes certificate of need a truly bipartisan issue. In fact, agencies in every presidential administration, beginning with President Reagan, have called on states to repeal their certificate of need laws.
Excuse me, but you have reached your 3 minutes. Thank you, Ms. Kavanaugh.
Thank you very much. That was the
Thank you,
conclusion of
Ms.
my
Kavanaugh.
testimony.
We do have a question for you from Senator Summers. Senator Summers, you're on.
Yes, thank you for your testimony. I am really interested in you sending us the data that you have, because I have spoken with my friends in Massachusetts and some other states which had sent me some data showing states that have certificate of need have no higher costs. I'm sorry, without certificate of need, have no higher cost in healthcare, have better access, and a higher number of healthcare facilities, just as you mentioned. But I wanted to ask you, we in this committee and in the state seem to be wanting to use certificate of need when somebody wants to close a facility, when they want to get rid of a service. And I wanted to get your thoughts on that, if I could.
Of course. Thanks for the question, Senator Summers. Well, that's actually very rare. Around the country, there are 35 states that still have some form of certificate of need laws. In a lot of places, it's very limited, maybe just for ambulance or just for nursing home. But amongst all of those states, it's very, very rare for states to use certificate of need to review closures or reductions in services.
Do you think that from your experience, when you look at Connecticut's certificate of need laws, I find them so overbearing and cumbersome, overreaching in every aspect of healthcare. Do you think that we are one of the states that has this absolutely bureaucratic, horrible overreach of CON?
Yes, Connecticut does have a very strict certificate of need program, and it's administered in a very strict way. I think a lot of states are realizing that after applying these laws for decades, we're reaching crisis levels of needing more facilities, and we haven't allowed facilities to grow in the natural way that they would have and that they have in states that don't have certificate of need. So lots of states in the Northeast right now, Maryland, Maine, Vermont, Rhode Island, DC, they're all considering certificate of need reforms. And that's just the national trend right now, to reduce the barriers for healthcare facilities to open and expand.
Right. And in Connecticut, if you apply for a certificate of need for something, it costs an extremely large amount of money, and it can take forever to get a result. It ends up in a agreed settlement that is confidential. And I just, I struggle with seeing the benefit of certificate of need. When we first started, it was, we need certificate of need so we don't have an MRI facility on every street corner. We don't want to be, but no company is going to do that if there's no need or market for that. So I'm really interested in what you have to say. And if you could share any of the data, it would be really, really helpful, I think, for us. So I appreciate your testimony tonight.
Thank you so much.
Thank you so much. My co-chair has a question, Ms. Kavanaugh.
Thank you, Mr. Chair, and Ms. Kavanaugh, thank you for listening in. Obviously, you've been listening for quite some time. If you heard Dr. Gifford's testimony or Commissioner Gifford's testimony, she was there first up today. One of the things that I'm thinking about as you're talking, and admittedly, it's late, so I agree with Senator Summers, sending us information will be helpful so that we can take it in when we're in a, maybe more rested point in time. But the question of private equity and its role in in healthcare and kind of the proliferation of private equity. That is one thing we've been talking about here this year, is how do we provide safeguards in that respect? And we are not talking necessarily just about the certificate of need process with respect to that, but I wondered if you wanted to opine on, how the private equity funding piece impacts the certificate of need conversation in other places in the country.
Sure. Thank you for that. I'm, admittedly not an expert on that topic, but, I think it's appropriate and warranted for attorney general's offices to be reviewing some of these transfers, and facility licensure requirements as well can sometimes address some of these concerns without having to go through a full certificate of need process.
Thank you for that. Thanks for being here with us today. Thanks, Mr. Chair.
Thank you. Seeing no other questions or comments, we wanted to thank you for being with us this evening. That brings us to the next person on the list, Chad Olson, followed by Paul Bannock. Mr. Olson, you're on.
Hello, this is Chad Olson. Can you hear me okay?
We can hear you, but we cannot see you.
Yeah, I had to switch to phone, so unfortunately you won't get to see my smiling face. But hello, my name is Chad Olson. Is this fine? I'd like to thank the chair and the two chairs for having me on. But my name is Chad Olson from the American Dental Association. Is it okay to proceed?
Please go ahead.
Yes, thank you so much. Again, I'm here to support including dental loss ratio as part of SB 7. You've heard from various doctors speaking to extolling the virtues of medical loss ratio. I'm here to give you the national perspective. Again, I'm with the American Dental Association, and we work with state dental societies around the country to endorse this issue. It is so important for patients. I wanted to let this committee know that if you all were to move forward with a bill and a hearing, you would not be alone. We have seen bills filed in 14 states to date, with a number of those bills advancing past committees. We're hopeful for passage in a number of states, both on the conservative side and more on the liberal side. So it's a bipartisan issue. One of the things we wanted to point out was that access will be improved. I know Ms. Garrity made this point, but I'd like to underline it. Right now, we know that about 50% of the patients out there do not even use the coverage they have. And that is because there's not an incentive for the insurers to encourage the subscribers, the patients, to go get care. If a medical loss ratio were put into place, then those patients would, the carriers would be incented to get those patients to go get their care that they so desperately need. And again, right now, that's only 50% of the people that are using it. It would be so important to them to have the carriers push for the patients to go get the care they need, and that will redound to benefits for them not having to go to emergency rooms because they're getting the needed preventive care, but also to get the care, beyond the preventive care, get the necessary basic and major services, because again, the medical loss ratio would mean that the payers are incented to pay out more for care. Lastly, I'd like to speak to the cost to the state. We've seen that Massachusetts, we heard from Dr. Riscala that Massachusetts has already established a template for other states to use. The Department of Insurance did a lot of excellent work about how they're going to implement the program. Also, the ACA has a medical loss ratio for major medical plans, and that can be used as a guide. Many states already are used to having the payers file and implement a medical loss ratio. And finally, once the systems are in place, it will run itself. And again, it may be some upfront costs, but eventually that would mean that there would be a lowering of costs after the fact. I'd like to thank Representative McCarthy-Vahey and Senator Anwar for hearing me today, and I'll pause there for questions. Thank you so much for not seeing my face and just hearing me out. Thank you.
Thank you so much, Mr. Olson. You owe us a picture and a smiling face.
That sounds good.
All right. No questions. Thank you so much. That brings us to the last.
Have a great night.
On our list, Paul Bannock. Paul, thank you for your patience with us, and thank you for the good work you do as a nurse and beyond. Thank you. Welcome.
I'd like to recognize all of you for being here all day to listen to members of the public. That's very honorable, and thank you. My name is Paul Bannock. I'm an ICU nurse. I'm here to testify on SB 7, specifically the section pertaining to healthcare administrative licensure. The past few years, we've seen many examples of what's now being referred to as administrative harm in healthcare. In Boston, Steward Health stopped paying their medical suppliers, and a brand new mother died after giving birth because the hospital did not have basic surgical supplies to stop her from hemorrhaging. Were any administrators held accountable? In Connecticut, Prospect Medical paid $645 million in dividends to their shareholders, and then they filed for bankruptcy in Waterbury, Manchester, and Rockville hospitals. Were any administrators held accountable?
These administrative decisions were made by actual people with names who showed a blatant disregard for the safety of the patients that they serve. How do we hold them accountable? We do what we do with every other healthcare worker. We license them. Attached to my testimony is a report from the Department of Public Health investigating at Hartford Hospital, or an investigation at Hartford Hospital. To summarize, a nurse witnessed a frustrated doctor slam his hands down onto a patient during a procedure, causing the patient to moan in pain. The nurse reported the doctor to Hartford Hospital administrators. When the administrators didn't respond, the nurse reported the doctor to the DPH. When the DPH investigated, the Vice President of Medical Affairs at Hartford Hospital stated that he forwarded the concern to the Chief of Cardiology. He stated that no further follow-up occurred and that the ball had been dropped. So they were notified that a physician that they supervise harmed a patient, and then they did nothing. What was that vice president held accountable in any way for dropping the ball and potentially putting more patients at risk? Why do we hold doctors and nurses to such high ethical standards to be mandated reporters and to do no harm, but we grant blatant exception for hospital administrators? In the late 1800s, it was physicians who advocated for their own licensure as a way to protect the public from bad actors. To my great disappointment, hospital administrators seem to be opposed to being licensed. I have with me the written testimony of the Connecticut Hospital Association, and I have replies for all of their concerns that I would love to share with you. However, I think the statement of Jacqueline Blake from Yale really sums it up. She states that Yale is opposed to administrative licensure because it, quote, would create personal and professional liability for their employees. Yes, that's the point. Nurses are liable, doctors are liable, and we should hold hospital administrators to the same standards. Do no harm. My written testimony breaks down the bill. I know it's a concept that it took me a while to really think through, but I've thought through it a lot. And I know there's concerns about logistics, about the exam, about how it would be set up. But I actually think the bill is very clearly written. It's very well written. It defines the role and who we're licensing. So I'd be happy to speak with anyone who has any questions about this bill.
Thank you so much, Paul, for your testimony. And I started to look at this bill after our conversation and started to see what other states were doing. And like I was saying earlier in part of our meeting, that a lot of what we are seeing in our healthcare, the things that are going wrong, traces back to an administrator in the healthcare field who is answering to another administrator in another state. Or perhaps, and right now, even if we have the licensure, that would give the tools to the administrator here to say that, you know what, I can do this, but I don't want to lose my license. In the same way in nursing and physicians and physician assistants, this conversation is happening when somebody says, I'm not going to lose my license on this. And right now, the administrators do not have that capacity in the state of Connecticut. They just say, yes, whoever, it's usually a sir. And that results in making choices, which is harming the people in our state. So can you expand a little bit about how sometimes these decisions at the bedside are outright dangerous for the patients and could cause death, which are being made by administrators at times?
I can give you an endless list of examples. I'd like to refer to the case of Billy Miller, who was a 23-year-old male. He died in the Yale Emergency Department. He went unmonitored for 7 hours. Of course, the nurses are held responsible, right? You know, you have a duty to protect your patient and to do your assessments and make sure that this person's safe. But if you have an administrator who's saying, well, Marna Borgstrom, she was the CEO at the time. She was making about $5 million a year and had influence over the budget of the hospital. So you have nurses in the emergency department saying over and over again, we need more staff here. We need more staff here. I can't complete. Some of these patients need Q1 hour neuro assessments because they're so unstable. I can't complete Q1 hour neuro assessments on 6 different patients because there's too much going on. So nurses will be held accountable for neglect because they didn't fulfill their duties and follow the orders. At what point are hospital administrators held for neglect because they're prioritizing meeting their financial goals for another $1 million bonus this year, and they don't want to provide more money to the nursing department in the emergency room to bring more nurses in or to incentivize overtime. I can give you so many examples every day.
Today the people who came and spoke in favor of this were all nurses. But we had Connecticut Hospital Association. They are against this at this time. I think this concept will become very real because the current way how the hospitals, because the people who are swimming in these waters, they know what's happening. The general public on the outside look at a healthcare system and say, well, everything is fine. They're caring people. They are caring people. That's why it's surviving. But the caring people are killing themselves to be able to get to that point. And that's the issue. And it's almost to the brink of breaking the system. And somebody else is benefiting from that. And it's certainly not the patients. And it's certainly not the healthcare workers. So I think this concept is important. It makes perfect sense, and I know Washington State is doing this right now. So have you been following what's happening there?
I have. This bill was actually developed in Washington State primarily by an emergency department nurse named Kelly Johnson. And she worked with a group of nurses from across Washington State to develop the concept. And then they met with a lot of different legislators to put their bill together. Her thought was the same as mine. Patients are being harmed every day. How do we hold administrators accountable for their decisions? And this makes perfect sense. Licensure is something that's tried and true. We require hairdressers to be licensed, but we don't require the people making the biggest decisions in our largest healthcare centers to hold a license and to commit to providing a safe environment for their staff and for their patients, the patients that they serve. That just doesn't make sense. So I know there's logistical concerns, but logistics can be worked out, and I have plenty of ideas on that too.
Yeah, I appreciate your testimony, and I want to thank you for your time and staying with us, and also the idea. So there were emergency room nurses in Washington State. We have ICU nurses and
Recording in progress.
30 miles of water.
Thank you.
Thank you.
Senator Summers, you had a question, or you good? I don't think so. Okay, good. Thank you so much, Paul. Appreciate you. And I think right now we have pretty much had every. Oh, sorry, Andrea Contreras. Sorry, we did not. We were looking for you in the computer but
Oh.
you're in person. Welcome.
Sorry, I was hiding behind your clerk. How are y'all? Senator Anwar, Representative McCarthy Vahey, and distinguished members of the Public Health Committee. I'm Andrea Contreras. I'm an OBGYN, and I'm currently a fellow in complex family planning. Thank you for the opportunity to testify in support of Senate Bill 8. This bill will protect healthcare providers who offer medically accurate information and counseling to their patients and provide needed healthcare in line with accepted standard of care for their patients facing pregnancy complications and emergency care. The urgency of this bill should not be news to you. Since the Dobbs decision, there have been multiple national media stories that highlight the importance of emergency pregnancy care and the catastrophic repercussions when legislation attempts to dictate medical care. Pregnant people have unnecessarily died. These medical complications are not limited to restrictive states and happen in Connecticut too. Just yesterday, I had to take a patient A, for an emergency DNC for an incomplete miscarriage when she presented hemorrhaging and with unstable vital signs. She had to be admitted for a blood transfusion as her hemoglobin was 6.7 and normal for context is 12 to 15. She had been to 2 other hospitals where she was discharged and told to follow up with her OBGYN in 2 weeks. There have been very few things that scare me as an OBGYN, and the following call from the ED department is one of them. Patient B is a person of reproductive age with a positive pregnancy test and a rapid heart rate. She has a low blood pressure, she's pale and confused. In my head, that patient has a ruptured ectopic pregnancy until proven otherwise, which is a life-threatening condition. I get to the ED in a minute. By then, her blood pressure is so low that the machine is not even picking it up anymore. She's obtunded and only responds to painful stimuli. I can't wake her up. Her belly is hard as a rock, a sign of bleeding into her abdomen. We took her to the OR immediately, and we took out 2.5 liters of blood from her abdomen, half of what circulates in a human body. I never say I save people's lives. I think it's a little too self-grandiose, but that day I did. I saved her life. A moment of hesitation in these situations can be the difference between life and death. Physicians should not be thinking about the potential career-ending legal repercussions for the provision of acute, evidence-based, life-saving care. And when we think about the repercussions, I can promise you that we are not thinking about our careers, the number of years we spent training, or the insurmountable debt that we've cured. We're thinking about who's going to take care of my patients if I'm no longer allowed to. Do I care for this single patient, or do I stay and care for all of my patients? Not having this protection places physicians in an ethical dilemma that only jeopardizes patients' lives. We're not asking for these organizations or individuals to go against their moral or ethical values. We're just asking you to protect and empower providers to care for their patients as they have been trained to do, whether that is emergency surgery, accurate evidence-based counseling, or referrals to the care that they desire and deserve. And when an organization prohibits me from providing the care that I know my patients need and deserve, it does force me to go against my moral and ethical values. It forces me to go against the oath I took as a physician, or positive conscience, as Dr. Stanwood stated earlier. So with that, I strongly encourage y'all to encourage the Public Health Committee to support Senate Bill 8, and I'm happy to answer any questions y'all might have.
Thank you. Seeing no questions or comments, we wanted to thank you for staying for this long with us.
Yeah, thank y'all.
Thank you. All right, finally, I'm just going to say a few thank yous because this is our last public hearing. Wanted to thank Beverly Henry for her brave support for the entire process and her team. Yes. And Peter Kolakowski. Oh, he's standing here. And David Ratcliffe. You can turn, as well as Kathleen. Kathleen, maybe you can tell us the time is over. Vanessa, do it for us.
Excuse me, Senator Anwar, but you have just finished your last public hearing. Congratulations to all.
Thank you. And
Very well done.
thank you, Kathleen. Wanted to thank Eileen Lawler Parker, Nick Panzarella, Nicole Doobie, James Orlando, and also Senator Summers, Representative Nicole Claridis Dietra, and our co-chairs, by my co-chair, the one and only Representative Kristen McCarthy-Vahey, for helping out with this whole process.
Good night, everyone. Thank you.